Page wise Proceedings. 22, 6. ಅಲ್ಲ 22/6 ಅಂದ್ರೆ ಯಾವ ಡೇಟ್ ಇಂಟರ್ಪ್ರೇಟಿಂಗ್ ಅಂತ ಅಡ್ಮಿಷನ್ ಇದೆ ಈ ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀವಿ ಬಂದಿಲ್ಲ 26ಗೆ ಹಾಕಿರೋದು 22ಕ್ಕೆ ಹಾಕಿ ಅಂತ ಮಾಡಿದ್ದಾರೆ ಕೊಡಿ ಅಂತ ಕೊಡಿದ್ರಿ ನೀವು ಯಾಕೆ ಅದು ಇದಕ್ಕಿಂತ ಮೊದಲು ಒಂದು ಹಾಕಿದ್ವಿ ಅದು ಬೇಡದನ್ನೆಲ್ಲ ಹಾಕ್ಬಿಡ್ತಾರೆ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ನಾವು ಅರ್ಜೆಂಟ್ ಮೂವ್ ಮಾಡಿದ್ರೆ ಯಾವ್ದನ್ನ ಹಾಕಲ್ಲ Your lordship, kindly, your lordship, on matter for admission, your lordship. 22 ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಪೋಸ್ಟ್ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ
ಡೇಟ್ ಕೊಟ್ಟರು ಪೋಸ್ಟ್ ಆಗಿಲ್ವ
ಇಲ್ಲ
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ನೋಡಿ ಆಯ್ತು ತೊಗೊಂಡು ಕೊಟ್ಟು ಹಾಕಿ
ಇಲ್ಲ ಇದು ಅದು ನೋಡಿದೆ ಬುಕ್ ಅಲ್ಲಿ ನೋಡಿದೆ 22 ಅಂತ ಇತ್ತು
ಡೇಟ್ ಇದೆಯಾ ಬುಕ್ ಅಲ್ಲಿ
ನೋಡ್ದಂಗೆ
ಮೆಮೋ ಏನೋ ಮೂವ್ ಮಾಡಿದ್ರು ಮೆಮೋ ಮೂವ್ ಮಾಡಿರೋದು ಕೊಟ್ಟಿರೋದು ಅಂತ ನೋಡ್ತೀನಿ ಸರ್ ಅದೇನಾದ್ರು ಕಂಪ್ಲೇಂಟ್
ಡೇಟ್ ಇದೆಯಾ ನೋಡಿಲ್ಲ ರಾಕ್ಸ್
ಆಯ್ತು
ಕೊಡಿ ಕೊಡಿ ಎಲ್ಲ ಕೊಡಿ ಮ್ಯಾಟ್ರ ಸ್ಟೇಡ್ give memo ನೋಡಿ ಹಾಕ್ಸಿ ಮೇಡಮ್ ಯಾವಾಗ ನೋಡಿ
mentioning from page number 60 69 to 72 73 to 79
73 madam
which one
73
73 ಹೇಳಿ
Harish Kumar advisement is out of station Paint habit and Monday morning.
ಅದರ್ ಸೈಡ್ ಯಾರು ಅಕ್ಷತಾ
ಇಲ್ಲ
ಹೇಳಿದಿರ ಅವ್ರಿಗೆ ಮಾಡಿದಿರಿ?
ಮಾಡಿಲ್ಲ.
ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಮಾಡಿಬಿಟ್ಟು ತಗೊಳ್ಳಿ. ಹಾ 17 70 ಹೇಳಿ. ಹಾ ಹಾ 3 ಮ್ಯಾಟರ್ಸ್ ಒಂದೇ ಇರೋದಲ್ಲ ಇಲ್ಲಿ. RSA 13 of 2018 12 ಬೇರೆ ಇದೆಯಾ? 11 ಆಲ್ಸೋ ತಗೊಳ್ಳಿ. ನೀವ್ಯಾರಿಗೆ? Appellant counsel submits that other two appeals are also pending. That is RSA 11 of 2018 and 12 of 2018. And there is likelihood of settlement in FDP proceedings. And hence seeks 2 weeks time and hence list this matter on. List all these matters together on ಯಾವಾಗ?
12/7.
12/7 ಮತ್ತೆ ಡೇಟ್ ಕೊಡಲ್ಲ. 2018 ಅಡ್ಮಿಷನ್ ಗಿದೆ. ಹಾ
73 to 79, 80 to 84,
24 my lord.
81 yes counsel. ಹಾ ಅದರ್ ಸೈಡ್ ಯಾರು ಇದ್ರಲ್ಲ? BK ಚಂದ್ರಶೇಖರ್ ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ? ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಿರಾ? ಮಾಡಿ ಆಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡಿ.
84 my lord.
84 ಹೇಳಿ.
Mr. Sidballappa is underwent for eye operation.
ಐ ಆಪರೇಷನ್.
Yes, my lord.
ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ನೀವು? ಪ್ರಾಕ್ಸಿ
Yes,
ಕೌನ್ಸಿಲ್
ma'am.
6 time. ಹಾ
3 weeks, ma'am.
on the ground that counsel who is on record underwent eye operation and hence list this matter. ಅದನ್ನ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 3 ವಾರ ಅಂತ ಕೊಡಿ.
Lordship,
7,
Hmm?
18/7.
18/7
Watch.
yes.
serial number 85, Lordship.
Serial number?
Serial number 85.
Wait
85 to 91,
85 to 91 yes madam. 85
For the appellant, my Lordship.
appearing for the
Appellant,
yes.
a senior has some personal inconvenience. Kindly list this matter.
Personal inconvenience is not a ground. Court already read the papers. You assist the court. Even junior is also can assist the court. That's all.
List the
Serial number
matter for next.
88, my lord.
Ground for personal inconvenience. Ah,
Serial number 88, I have to carry out the amendment. Today itself, I will do it, kindly have it on Monday, my lord.
no adjournment. Amendment
Yes.
carry out ಮಾಡಿ assist the court. That's all.
I have already
Next.
filed the amended
No, no.
appeal memo.
You amend it. I will permit you to amend. On the ground of amendment, no adjournment.
92 to 99, 100 to 103, 104 to 107, 108 to 110. Parted in order, serial number 1, L. Rajanna,
And for the appellant.
Third in part, perusal of the letter dated 6/5/24 received from the director, State Forensic Science Laboratories, Madiwala, Bangalore 68. ಏನ್ ಲೆಟರ್ ನೋಡಿ ಮೇಡಮ್? Huh? ಹಾ ಕಟ್ಬೇಕು ಇವರು. ಯಾರು ಕಳ್ಸಿರೋದು?
I have paid
Memo
5,000.
dated receipt of rupees 5,000 paid to the government treasury. ಆಯ್ತು, ಇನ್ನೆಷ್ಟು ಕಟ್ಬೇಕು?
ಅಲ್ಲ ಅದು there is the order is think my lord is misleading my lord.
Huh?
Kindly see it is misleading.
What is misleading?
ಐದಾರು signature ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Huh?
Another 5 to 6 signatures.
ಅವ್ರಿಗೆ ಬೇಕಾಗ್ತದೆ, ಇದ್ರು ಕೊಡಿ.
ಇಲ್ಲಿ admitted signatures ಎಲ್ಲಿದೆ?
ಯಾವ್ದಿದೆ ಅಡ್ಮಿಟೆಡ್ ಸಿಗ್ನೇಚರ್ಸ್?
ಇದ್ರಲ್ಲೇನೆ exhibit D1 and D37 ಅಲ್ಲೇನೆ ಒಂದ್ರಲ್ಲಿ 6 ಇದೆ, ಒಂದ್ರಲ್ಲಿ 4 ಇದೆ. ಈಗ another 5 to 6 ಎಲ್ಲಿಂದ ಕೊಡೋದು my lord? Admitted.
ಇದೆಯಾ ಲೆಟರ್ ಅಲ್ಲಿ?
ಇದೆ ಸ್ವಾಮಿ, kindly.
Reference to the subject and
Kindly
reference,
see.
it is submitted to the honorable court that for comparison of disputed signature in the document exhibit D1 will of the year 1975. The admitted signatures in exhibit D37, sealed of the year 1960, have been provided to account the natural variations due to time gap. 5-6 signatures executed near about period of 1975 are required. Further, it is submitted to the court that office does not undertake the examination of thumb impressions. The same will be examined in the office of Superintendent of Police, Fingerprint Bureau, Bangalore 1. The examination fee of this case as per the government order so and so is rupees 5,000. Therefore, the concerned party may be instructed to deposit government document examination fee of rupees 5,000 in the government treasury. ನೀವ್ ಮಾಡಿದ್ರಲ್ಲ already deposit
ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ, ಅದು ಲೆಟರ್ ನಲ್ಲಿ ಬಂದಿತ್ತು, ಮಾಡಿದೀನಿ.
ಹಾ,
ಫಸ್ಟ್ ತಾವೇನ್ ಮಾಡಿದ್ರಿ, ಆದ್ಮೇಲೆ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಿ. ಇವರು ಏನು ಮಾಡಿಲ್ಲ. 5 to 6 ಸಿಗ್ನೇಚರ್ಸ್ ಎಲ್ಲಿಂದ ಕೊಡೋದು ಸರ್?
ಆಯ್ತು ತಗೊಳ್ಳಿ.
ಆಮೇಲೆ ಇದು ತಂಬ್ ಇಂಪ್ರೆಷನ್ ಬಂದು
ಈಗ ಡಿಸ್ಪ್ಯೂಟ್ ಇರೋದು ಎಕ್ಸಿಬಿಟ್ D1 ಎಕ್ಸಿಬಿಟ್
D37
37.
ಅದ್ರಲ್ಲೇನೆ 6 ಸಿಗ್ನೇಚರ್ ಇದೆ D1 ಅಲ್ಲಿ.
ಹಾ,
D37 ಅಲ್ಲಿ 4 ಇದೆ. ದೇ ಕ್ಯಾನ್ ಈಸಿಲಿ ಕಂಪೇರ್. ಮತ್ತೆ ಟು ಕ್ರಿಯೇಟ್ ಸಮ್ ಅಬ್ಸ್ಟಕಲ್ಸ್ ಐ ಥಿಂಕ್ ಮೆಲಾಡ್. ಆಮೇಲೆ ಈ ತಂಬ್ ಇಂಪ್ರೆಷನ್ ಬಂದು ಇಲ್ಲಿ SP ಆಫೀಸು ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಅಂತ ಕನಿಂಗ್ಹ್ಯಾಮ್ ರೋಡ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ಅಲ್ಲಿ ಏನು ಆಕ್ಟಿವಿಟೀಸ್ ಇಲ್ಲ. ಈ ಇದ್ರಲ್ಲಿ ಫೋರೆನ್ಸಿಕ್, ಇದು ಸ್ಟೇಟ್ ಫೋರೆನ್ಸಿಕ್ ಅವ್ರು ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಅಂತಾರೆ. ಇಟ್ ಇಸ್ ಡೆಲಿಬ್ರೇಟ್ ಮೇಲೆ. ಗಂಗೋತ್ರಿನಲ್ಲೇ ನೀರಿಲ್ಲ ಅಂದಂಗ ಆಯ್ತು ಇದು. ಇಟ್ ಈಸ್ ಮಿಸ್ಲೀಡಿಂಗ್ ಮೇಲೆ. ಫೋರೆನ್ಸಿಕ್ ಲ್ಯಾಬ್ ಅಲ್ಲಿ ನಾವು ತಂಬಿಂಪ ಇಲ್ಲ ಆದ್ರೆ ಏನಾದ್ರು ಮಾಡ್ಬೋದೇನೋ ಅಂತ ನೀನು. SP ಆಫೀಸ್ ಅದು ಮೊದಲೇ ಈ 10 days ಬ್ಯಾಕ್ ಅದು ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ. ಸಮಯ ಬಿಲ್ಡಿಂಗ್ ಗೆ ಮಾರಕ್ ಹೋಗಿದ್ದಾರೆ.
ಆಫೀಸ್ ಡಸ್ ನಾಟ್ ಅಂಡರ್ಟೇಕ್ ದಿ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ಥಂಬ್ ಇಂಪ್ರೆಷನ್.
ಫೋರೆನ್ಸಿಕ್ ನಲ್ಲಿ ತಂಬ್ ಇಂಪ್ರೆಷನ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಸುಮ್ಮನೆ
ಏನ್ರಿ ನೀವೇನಾರು ಹೇಳೋದಿದ್ಯಾ? ಅಷ್ಟೇ
ಡೆಲಿಬ್ರೇಟ್ ಮೇಲೆ.
This court has received the letter of Director of State Forensic Science Laboratory 6/5/24, wherein sought for additional signatures. And on perusal of the document exhibit D1, there are 6 signatures. And also in exhibit D37,
Yes.
there are 4 signatures. And now the director cannot expect the more signatures for giving the opinion.
Yes.
And hence request cannot be considered. And this court already given the direction to compare the disputed signature available in exhibit D1 as well as D37, having considered the available signature on record. It is also mentioned in paras 2 of the letter that the said office does not undertake this examination of thumb impressions. The same will be examined in the office of Superintendent of Police, Fingerprint Bureau, Bangalore 1. And having considered the said request also, once the document is sent to the Director of State Forensic Science Laboratory, the director cannot say that the office does not undertake the examination of thumb impressions. And if any experts are not available, the director can take the assistance of Superintendent of Police, Fingerprint Bureau, and submit the report. And the same cannot be sent to any other office, and hence comply with the order of this court. ಮತ್ತೇನ್ರಿ ಮೆಮೊ ನೀವು ಕೊಟ್ಟಿದ್ದೀರಾ ದುಡ್ಡು?
ಕಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಯಾವಾಗ? ಆಮೇಲೆ ಅದು ನಂತರನಾ?
ಇಲ್ಲ ಅದು ಬಂದ್ಮೇಲೆ.
ನೀವು ಕಟ್ಟಿರೋದು 24/6
ಈಗ ಮೊನ್ನೆ ಈ ಲೆಟರ್ ಬಂದ್ಮೇಲೆ
ಆಯ್ತು. ದಿ Appellant Council already paid the
24/6
fee of rupees
5,000
5,000 on 24/6/24.
ಒರಿಜಿನಲ್ ಹಾಕಿದ್ದೀನಿ ಸರ್.
As per the reference made in the letter of 6/5/24.
Yes.
And hence await report by 1 month ಕೊಡಿ, another 1 month. ಇವತ್ತಿಗಿತ್ತ ಇದು ಡೇಟ್?
ಮತ್ತೆ
ಈ ಡೇಟ್ ಇವತ್ತಿಗೆ ಕೊಟ್ಟಿದ್ವು ನಾವು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಬಂದಿದ್ದಕ್ಕೆ
ನಾವು ಯಾವಾಗ ಡೇಟ್ ಕೊಟ್ಟಿದ್ವಿ? 3 months ಅಂತ ಟೈಮ್.
3 months ಅಂತ ಆಯ್ತು ಸ್ವಾಮಿ. ಲೆಟರ್ ಬಂದ್ಮೇಲೆ ಆಫೀಸ್ನವರು.
ಆಯ್ತು, ಈಗ 3 months ಯಾವಾಗ ಆಗುತ್ತೆ? ಯಾವಾಗ ಆರ್ಡರ್ ಮಾಡಿರೋದು?
5/4 ಆಗಿದೆ.
5, 6, 7 3 ಆಗುತ್ತೆ. ನಾವ್ ಮತ್ತೆ ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ.
ಇಲ್ಲ
ಈಗ 1 month ಕೊಡಿ ನೋಡಿ. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ ಇಲ್ಲ, 30th July ಅಂತ ಕೊಡಿ. 30th July
ಪ್ಲೀಸ್.
Orders matter serial number 2, Samir SN.
Samir SN, non taking steps in respect of LR as per order dated 3/10/23.
Kindly post this matter on Monday. Kindly post this matter on.
Death report ಆಗಿದೆ ಯಾವಾಗ್ರಿ? Today he has paid the PF, issue notice ಅಂತ ಆಯ್ತು. Takes appellant seeks further time to take steps against the legal representatives of deceased respondent number 2. Earlier ಕೂಡನು ನೀವು ಟೈಮ್ ತಗೊಂಡಿದ್ರಿ, further time ತಗೊಂಡು. In spite of this court granted further time on 3/10/23 to take steps against R2, till date not taken any steps, and hence appeal against R2 is dismissed. ನೆಕ್ಸ್ಟ್ ಏನಾಗ್ಬೇಕು ಮೇಡಮ್? ಮತ್ತೆ ಇನ್ನೊಂದು ಬೇರೆಯವ್ರದ್ದು ಏನಾಯ್ತು? ಜಾರಿ ಆಯ್ತು ಮೇಡಮ್? ಆರ್3 ಏನಾಯ್ತು? ಆಗಿದೆ ಅಲ್ಲ? ಸರಿ, ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್. Admission on 12/7.
3.
N. Kumar Swamy and B. K. Manjunath, non-filing of application to LRs of deceased R1 on record.
1 week time kindly ma'am.
ಯಾವಾಗ ಟೈಮ್ ತಗೊಂಡಿದ್ರಿ ಹೇಳಿ?
Post dated paper books like time.
36/24 ರಿಪೋರ್ಟ್, ಡೆತ್ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಯಾವಾಗ? Reporting the death of respond number 1. Note really, the learned counsel for respond number 1 to 3 has filed a memo dated 23/3/23 reporting the death of respond number 1. Copy was not served ಅಂತ at least one time ಕೊಟ್ವಿ ನಿಮಗೆ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಆದ್ರೂನು.
1 week time ಕಾಪಿ ಕೊಟ್ಟೆ ಸರ್ ಇದುವರೆಗೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲ.
He died on 22 na.
ಕಾಪಿ ಇದುವರೆಗೆ
Copy
ಕೊಟ್ಟಿಲ್ಲ.
serve ಮಾಡಿರಲಿಲ್ಲ.
1 week time ಕಡಿಮೆ.
The council seeks another 1 week time and hence another 1 week finally granted
Aye.
to bring the LRs of R1.
4.
Appellants in the fact, 2 weeks, 2 days time will be granted, my lord, date may be fixed.
ಏನ್ complaints?
I filed the amended class title, adರಲ್ಲಿ complaint.
ತಗೊಳ್ಳಿ, appellant council seeks
2
2 days time and
date may be fixed.
and hence 2 days time granted.
Amendment ಮಾಡ್ಬೇಕು ಅವ್ರು. Amended
To comply and for amendment.
amendment ಮಾಡಿ.
Amendment ಇದೆ ನೋಡಿ.
ಮಾಡ್ತೀನಿ.
Next,
5.
non-filing of memo along with acknowledgement for having served notice to R1 and R3.
I may be permitted to submit the memo along with the acknowledgement for having served the.
ಸರ್ವ್ ಮಾಡಿದೀರಾ?
Yes, my lord.
ಯಾರ್ಯಾರಿಗೆ? 1 and
For
3.
respond number 1 and 3, for respond number 1, my lord.
ಅವ್ರಿಗೆ ಮಾಡಿದಾರ ಲಾಯರ್ಗ?
Ali, local advocate in the we got it, sir.
Huh?
Local advocate in the we got it, sir. From the
ಲೋಕಲ್
state.
ಅಡ್ವೊಕೇಟ್ ಸರ್ವ್ ಮಾಡಿದಿರಾ?
ಅಲ್ಲ, ನಮ್ಮ ಲೋಕಲ್ ಅಡ್ವೊಕೇಟ್ ಇಂದ ಅವರಿಗೆ ಸರ್ವ್ ಮಾಡಿಸಿದೀವಿ ಅಂತ.
ಪಾರ್ಟಿಗೆ ಮಾಡಿಸಿದಿರಿ?
ಪಾರ್ಟೀಸ್ಗೆ ಮಾಡಿಸಿದೀವಿ. ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1, her son has accepted it.
ಲಿಂಗೇಗೌಡ.
Yes, my lord.
ಹೌದಾ?
ಎರಡನೇ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಗೆ ಅವರೇ ಸರ್ವ್ ತಗೊಂಡಿದ್ದಾರೆ.
Still appearing to the appellant files memo along with. ಈ ಪ್ರೆಸೆಂಟೇಶನ್ ಫಾರಂ ಹಾಕೋ ಉದ್ದೇಶ ಏನಿತ್ರಿ?
Sorry, my lords.
ಪ್ರೆಸೆಂಟೇಶನ್ ಫಾರಂ ಹಾಕೋ ಉದ್ದೇಶ ಏನಕ್ಕೆ? ಬ್ಲಾಂಕ್ ಬಿಟ್ ಹಾಕಕ್ಕೆ ಅಂತನಾ ಅಥವೇನು?
No, my lords, I have mentioned in the first portion of the presentation.
ಪೇಜಿನೇಷನ್ ಎಲ್ರಿ?
Pagination next memo.
ಹಾಕೋಬೇಕಾ ನಿಮ್
Sorry,
ಡಾಕ್ಯುಮೆಂಟ್ ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ?
I'll do it, my lords. I'll do it.
Huh? The counsel for the appellant has filed memo of acknowledgement for having served the notice on R1 and R3 na,
Yes, my lords.
and having perused the same. ಇದು ಯಾರು ಅವನ ಹೆಸರೇನು?
Respond number 1 ಪರವಾಗಿ ಅವ್ರು
ಚಿಕ್ಕಮ್ಮ ಅಂತ ಒಂದಿದೆ,
ಚಿಕ್ಕಮ್ಮ ಅಂಡ್ ಸಿದ್ದಲಿಂಗೇಗೌಡ.
ಇನ್ನೊಬ್ರು
ಸಿದ್ದಲಿಂಗೇಗೌಡ.
ಸಿದ್ದಲಿಂಗೇಗೌಡ. ಆಯ್ತು. ನಾನು ಪೆರುಸಲ್ ಸಿದ್ದಲಿಂಗೇಗೌಡ taken the notice on 22/6/24. ಅವನ ಪರವಾಗಿ ನೀವು ಮಾಡಿಸ್ಲಿಲ್ವಾ ಸಿಗ್ನೇಚರ್?
R1 ಗೆ ಅವ್ರ ಮಗ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, ಅವ್ರು ತಗೊಳಲ್ಲ ಅಂತ ಹೇಳಿ ಮಗ ತಗೊಂಡಿದ್ದಾರೆ.
Copy received on behalf of my mother. And also there is an endorsement that the copy is received on behalf of his mother.
ಶಿವಣ್ಣೇಗೌಡ ಅಂತ ಅವರ ಹೆಸರು. ಶಿವಣ್ಣಗೌಡ ಅಂತ ಹೆಸರು ಬಂತು.
ಶಿವಣ್ಣೇಗೌಡನ?
ಶಿವಣ್ಣಗೌಡ ಅಂತ ಮೆಮೋದಲ್ಲಿ ನಾನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀನಿ.
ಶಿವಣ್ಣಗೌಡ. And in view of acknowledgement on the party and also taking into note of recent service on 22/6/24. Another 1 week time, another 2 weeks time is granted to engage the counsel or to appear in person before the court. And hence list this matter on. That was bit kodi madam date
12/7.
My lords, TCS may kindly be called.
12/7. The service against R1 and R3 is held sufficient ಅಂತ ಮಾಡಿ. ಏನು TCR?
TCR, my lords.
TCR ಹಾಕ್ಬೇಕು?
ಅದು ಅಡ್ಮಿಷನ್ ಟೈಮ್ ಅಲ್ಲೇ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ವಿ ಸಾಬರ್ ಕೋರ್ಟ್, ಮೈ ಲಾರ್ಡ್ಸ್.
ಆಯ್ತು. ರೆಕಾರ್ಡ್ ಕಾಲ್ಫರ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಮೈ ಲಾರ್ಡ್ಸ್, ಅದಕ್ಕೆ.
ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾ ನೋಡೋಣ ಆಮೇಲೆ. ಫಸ್ಟ್ ನೀವು
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ಅವತ್ತಿನ ದಿವಸ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ನೆಕ್ಸ್ಟ್
Serial number 6.
R Hemant Raj. Non-filing of typed copy of OS decree as per order dated.
Appellant.
ಹಾ.
I'm sorry, Lordship. What is the objection, Lordship? I have to file.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದೀರಾ 1,000?
I have to file, your Lordship, the typed copy, Lordship.
ಕಾಸ್ಟ್
Typed-
ಕಟ್ಟಿದೀರಾ?
ಇಲ್ಲ, ಅದು ಎರಡು ಒಟ್ಟಿಗೆ ಮಾಡ್ತೀನಿ ಸರ್. ಲಾಸ್ಟ್ ವೀಕ್ ಫೈನಲಿ 1 week.
ಕಾಸ್ಟ್ ಹಾಕೋ ಉದ್ದೇಶ ಏನಕ್ಕೆ ಹೇಳಿ?
ಇಲ್ಲ, ಫೈನಲಿ 1 week, Lordship.
ಮತ್ತೆ ಕೊಡೋದಿಲ್ಲ, ಮತ್ತೆ ಬೇಕು ಅಂದ್ರೆ ಫರ್ದರ್ ಕಾಸ್ಟ್.
ಅಲ್ಲ, ಫೈನಲಿ 1 week.
ಆರ್ಡರ್ 13/6/24 ಲೇನೆ
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಒಂದು ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
Court-wide order dated 18/4/24 granted 2 weeks time to file typed copy of the decree of the OS.
ಟೈಪ್ಡ್ ಕಾಪಿ
Not filed. On 13/12/20 finally a week's time was granted and even after 6 months also the same is not done. Hence another 2 weeks time is granted to file the same on payment of cost of rupees 1,000 payable at registry. Directed to clarify with regard to the death of respondent number 3, which is shown in the judgment and decree in the first appellate court. And in spite of it, he has been arraigned as respondent number 7 in this RSA.
Problem is this, the decreed copy is not, it is not in legible. I have already applied it before the trial court get it a certified copy. That is the reason it is very difficult to get
Appeal
it
ಹಾಕಿದ್ದ
typed.
ಯಾವ ವರ್ಷದಲ್ಲಿ?
ಸ್ವಾಮಿ?
Appeal ಹಾಕಿದ್ದ
ಅದು
ಯಾವ
ಕ್ರಾಸ್
ವರ್ಷದಲ್ಲಿ?
ಎರಡು ಅಪೀಲ್ ಇದೆ, ಅದ್ರ ಒಂದ್ರಲ್ಲಿ ಆಲ್ರೆಡಿ
6 ವರ್ಷದಿಂದ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಳ್ತಲೇ ಇದ್ದೀರಾ? 6 ವರ್ಷದಿಂದ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಳ್ತಲೇ ಇದೀರೇನ್ರಿ? ತಗೊಳ್ಳಿ. This court-wide order dated 13/6/24 having taken note of non-compliance of office objection, imposed cost of rupees 1,000 by granting 2 weeks time to file the typed copy of the decree of the OS. Even though same was not complied, the order passed on 18/4/23 and 13/12/23 and cost is also not paid
ಅಲ್ಲ ಅದೆಲ್ಲ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
and
Cost
also
ಕಟ್ತೀನಿ.
not complied with office objections and hence appeal is dismissed for non-payment of cost and non-compliance of office objections.
In case fellowship, given a final fellowship, I
ಏನ್ ಹೇಳಿ?
will undertake to within 1 week.
ಕಾಸ್ಟ್ ಕಟ್ಕೊ ಬರ್ತೀರಾ? ಮಧ್ಯಾಹ್ನದವರೆಗೆ ಇಟ್ಟಿರ್ತೀನಿ.
ಕಾಸ್ಟ್ ಕಟ್ತೀನಿ.
ಕಾಸ್ಟ್ ಕಟ್ಟಿ ಬನ್ನಿ, ಬಾಕಿದ್ ನೋಡೋಣ, ಆಮೇಲೆ ಫರ್ದರ್ ಕಾಸ್ಟ್ ಆಗಿ ಟೈಮ್ ಕೊಡೋಣ. ಏನ್ ಮಾಡೋದ್ ನೀವು? 6 ವರ್ಷ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಲ್ರಿ, ನಾಚಿಕೆ ಆಗ್ಬೇಕು ಕರಿಕೋಟ್ಗೆ. 2018 ಹಾಕಿರೋದು ಏನ್ ಇಂಟ್ರೆಸ್ಟ್ ಆಫ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ನೀವು ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ತೀರಿ? 6 ವರ್ಷ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ ಅದಕ್ಕೆ ಯಾಕೆ ಕರಿಕೋಟು? ಒಂದ್ ಟೈಪ್ಡ್ ಕಾಪಿ ಆಫ್ ಡಿಗ್ರಿ ಹಾಕಲ್ಲ ಅಂದ್ರೆ 6 ವರ್ಷ. ಒಂದ್ಸರಿ ಅಲ್ರಿ, 3 ಸರಿ ಟೈಮ್ ಕೊಟ್ಟಿದೆ, ಕಾಸ್ಟ್ ಹಾಕಿದೆ, ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನ್ರಿ?
ಪಾಸಿಬಲ್.
ಇಟ್ ಈಸ್ ಅಸೈಮ್ ಆನ್ ಬ್ಲಾಕ್ ಕೋಟ್. You are here to protect your client's interest. ಹೌದಲ್ಲ? ನಿಮಗ್ ನೋವಾಗ್ಬಾರ್ದು, ನನಗಂತೂ ನೋವಾಗ್ತದೆ. ನೋವಾಗಿ ಮಾತನಾಡೋದು ನಾನೇ ಹಾಕ್ಸ್ಕೊತಾ ಇದ್ದೀನಿ. ದಿನ ಬರೀ 10:30 12 ಗಂಟೆವರೆಗೆ ನೀವು ಮಾಡ್ದಿಲ್ ರಿಪೇರಿ ಕೆಲ್ಸಕ್ಕೋಸ್ಕರ ನಾನು ಕೂತ್ಕೊಂಡು ಕೆಲಸ ಮಾಡೋದಾಗಿದೆ. 6 ವರ್ಷ. ಇಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು ಬೇಡ ಮೇಡಮ್, ಹಾಗೆ ಇಟ್ಟಿರಿ. ಪಾಸ್ ಓವರ್.
7, Halima Amin. Withdrawal memo.
Learned counsel for the appellant is granted 1 week time to comply with
No, no,
office
I-
objections on IL number 2 of 21 and 1 of 21.
Withdrawing it, my lord.
Huh?
Withdrawing. Maybe,
Withdrawing.
yes,
Put it
maybe
memo,
dismissed
put
as withdrawn.
Huh?
Maybe dismissed as withdrawn.
ಕೊಡಿ, ಏನಿದು? Yes, sir.
Money
Earlier
should-
also dismissed.
yes.
Sorry. The counsel for the
Parties-
appellant files memo seeking permission to withdraw the above appeal ಅಲ್ಲ, ಈಗಿರೋದು IAS ಅಲ್ವಾ? ಈಗ IAS ಅಲ್ವಾ ಇರೋದು? ನಿಮ್ಮ ಅಪೀಲ್ ಆಲ್ರೆಡಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಮತ್ತೆ ನಾವು ವಿಡ್ರಾ ಮಾಡೋದು.
I had filed a IA for
IA for recalling ಅಷ್ಟೇನೆ. ನೀವು recalling the order dated 19/11/2019.
entire film maybe.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ಮತ್ತೆ ಅದನ್ನ ರಿಕಾಲ್ ಮಾಡಕ್ ಐ ಹಾಕಿದ್ರಿ. ಬರ್ಸ್ಕೊಳ್ಳಿ ಅವ್ರ ಕೇಳಿ ಮೆಮೋನ. ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ IAS. ಕೌನ್ಸಿಲ್ ಫೈಲ್ಸ್ ಮೆಮೋ ನಾಟ್ ಪ್ರೆಸಿಂಗ್ ದಿ IA number 2/21 and 1 of 21 and hence IAS are dismissed as not pressed in view of the filing of memo.
8,
Non-compliance of the office above office objection number 1 along with counsel submission. ಹೇಳ್ರಿ counsel. ಏನ್ counsel submission ಏನ್ ಹೇಳಿ? ಅಲ್ಲ ರೀ, ನಾವು ಫೈಲ್ ತರ್ಸ್ಕೊಂಡು ನಿಮ್ಮನ್ನ ಇಡ್ಸ್ಕೊಂಡು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಸ್ಕೋಬೇಕಾ ಕೋರ್ಟ್ ಅಲ್ಲಿ? 2018 ಎಷ್ಟ್ ಸರಿ ಬಂದಿದೆ ಮುಂದೆ ಮೇಡಮ್ ಕೋರ್ಟ್ ಮುಂದೆ? ಎಲ್ಲ ಹಿಂಗಾರ ಒಂದು ಅರ್ಧ ತೊಳೆಯನ ಕೊಡಿ RSAಗಳನ್ನ. ನೇಮ್ ಕರೆಕ್ಷನ್ ಮಾಡಕ್ 6 ವರ್ಷ ಬೇಕೇನ್ರಿ? Objection number 1. ಹಾ ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ ಅಂತೂ ಅಪ್ರೂವಲ್ ಲಾಯರ್ಗಳು ಹೋಗಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಗೆ. ಆಮೇಲೆ 2 ಸರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿದೆ. ಏನದು?
Respondent number 6 and 31
Hmm.
in are yet to be filed.
Hmm.
And if required, necessary application to be filed to bring the amounts on record.
ಇದು ಯಾವಾಗ ರೈಸ್ ಮಾಡಿರೋದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೋಡಿ? 2018 ಹಾ ಹ್ಮ್ ಹ್ಮ್
Date of death of respondent number 6.
ಆಯ್ತ್ರಿ, ಅದು ಹೆಸರಿ ಗೊತ್ತಿಲ್ಲ. ಹೆಸರಿ ಬಂದಿದೆ ಫಸ್ಟ್ ಇಂದಲೂ ಇದೆ ಅದು. ಸಬ್ಮಿಷನ್ ಏನು?
The date of death of respondent number 6 LR is not mentioned in the application filed. Date of death of respondent number 31 is not available. However,
ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋರ ಮತ್ತೆ
date of death
ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ನಾಟ್ ಮೆನ್ಷನ್ಡ್ ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತಾರೆ? ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಲೆ ತೊಳಿ ಕೊಡಿ. This appeal was filed in 2018
Can I request for
and
password?
matter was listed before the registrar on 18/9/2018 and counsel was absent. And in spite of office objections are raised in 2018 itself, same has not been complied and matter was listed before this court on 10/1/23. And counsel was directed to comply with office objections on I1 of 2018, 2 of 18 and 3 of 18. ಏನ್ ಹಾಕಿದಾರೆ ನೋಡಿ 3 IAs. And those office objections are not complied. And once again, matter was listed before this court on 11/6/24. And this court accepted the counsel submission in respect of office objection number 3 and 4. However, 1 week time granted to comply with office objection number 1 and 2. And also directed to properly stitch the same. If the counsel doesn't comply the office objection within 2 weeks, the appeal will be dismissed without reference to the bench. And even in spite of this order was passed on 11/6/24 till date, office objections are not complied. And this appeal is pending from 2018 to 24 for a period of 6 years for non-compliance of office objections. And hence appeal is dismissed in view of the order passed by this court dated 11/6 ಹೇಳಿದ್ದು 11/6/24.
Can I only request for a passover?
Request ಏನಿಲ್ಲ.
By 2:30.
Order is specific last
I
time.
understand.
ಮಾಡಿಲ್ಲ ಅಂತಂದ್ರೆ dismissal ಅಂತ. ಅದಕ್ಕೆ dismiss ಮಾಡಿದೀವಿ ಅಷ್ಟೇ.
Just my-
ನೋ ಕೌನ್ಸಲ್.
Good.
ಇನ್ನೊಬ್ರು ಅಡ್ವೊಕೇಟ್ ಹೇಳಿದ್ ನಿಮಗೆ ಮತ್ ನಾನು ರಿಪೀಟ್ ಮಾಡೋದ್ ಬೇಡ. 6 ವರ್ಷ.
9.
ಈಗ R2 ಹಾಕಿದಿರಾ? ಯಾವಾಗ ಹಾಕಿದಿರಿ? ವಕಾಲತ್ ಯಾವಾಗ ಹಾಕಿದಿರಿ? A to C ತೋರಿಸಿದಾರಾ?
ತೋರಿಸಿದ್ದಾರೆ. ಈಗ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ ಈ ಟೈಮ್.
ವಕಾಲತ್ ನೀವು ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ರಿ? ಆಯ್ತು ತೋಳಿ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಫುಲ್ ಕಾಸ್ಟ್ ಐಟ್ಲಿ ಹಾಕಿಲ್ಲ?
ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
ಫುಲ್ ಕಾಸ್ಟ್ ಐಟ್ಲಿ.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ? I1 of 22 ಫೈಲ್ ಮಾಡಿರೋದು ನೀವು 22ನೇ ಇಸ್ವಿಲಿ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸರ್ ಅಬ್ಜೆಕ್ಷನ್ ಆನ್ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಎಲ್ಲ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಮೇಲೇನೂ ಅಬ್ಜೆಕ್ಷನ್
19/6 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಏನ
ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಐಟ್ಲಿ. ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಆಲ್ಸೋ ಸಬ್ಮಿಟೆಡ್ ದಿಸ್.
ಈ ಐಎಗೆ ಹಾಕಿದ್ರೇನ್ರಿ? I1 of 22 ಗೆ
22 ಫುಲ್ ಕಾಸ್ಟ್ ಐಟ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಫುಲ್ ಕಾಸ್ಟ್
ಬ್ಯಾಂಕ್ ಆಫ್ ದ ಪಾರ್ಟಿ ಸರಿಗಿಲ್ಲ ಅಂತ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇರೋದು ಸರ್.
ಅಲ್ಲ ಐಎಲ್ ಫುಲ್ ಕಾಸ್ಟ್ ಐಟ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ರೆಕ್ಟಿಫೈ ಮಾಡಿ.
I1 of 22 ನಲ್ಲಿ ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನೋಡಿ ಮೇಡಮ್?
LRs of R3 IMA.
ಸರ್ ಫುಲ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಹಾಕಿಲ್ಲ ಅಂತ ಅದ್ರಲ್ಲಿ ಇರೋದು.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ ಫುಲ್ ಕಾಸ್ಟ್ ಟೈಟಲ್?
ವೆರಿಫೈ ನಮ್ಮ ಆಫೀಸ್ ಕಾಪಿ ನಮ್ಮ ಆಫೀಸ್ ಕಾಪಿ ಫುಲ್ ಕಾಸ್ಟ್ ಐಟ್ಲಿ
1 of 22 I1 of 22 ಕೊಡಿ.
ಆಫೀಸ್ ಕಾಪಿನಲ್ಲಿ ಫುಲ್ ಇದೆ. ಕನ್ಫ್ಯೂಸ್ ರೆಕ್ಟಿಫೈ ಮಾಡ್ತೀನಿ sir. ಅದು ಅಯ್ಯ
ಅಯ್ಯೋ ಒಂದ್ ನೋಡಿ ಮೇಡಮ್, ಫುಲ್ ಕಾಸ್ಟ್ ರೇಟ್ ಹಾಕಿದಾರೆ. ಏನಂತ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನೋಡಿ. As per the amended cost rate law. ನಿಮ್ಮ ಅಮೆಂಡ್ ಮಾಡಿದಾರಲ್ಲ ಅದನ್ನ ಹಾಕಿಲ್ಲ. ಅಮೆಂಡ್ ಏನ್ ಮಾಡಿದಾರೋ ಅದರದ್ದು ಫುಲ್ ಕಾಸ್ಟ್ ರೇಟ್ ಹಾಕಿಲ್ಲ ಅಂತ.
ಹಾಕ್ತೀನಿ 2 days
ಅಮೆಂಡ್ ಆಗಿದೆಯಲ್ಲ,
ಹೌದಾ
ಅದಕ್ಕೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನೋಡಿ. ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಟ್ ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ರೇಟ್ ಆಲ್ಸೋ.
ಅಮೆಂಡೆಡ್ ಕಾಸ್ಟ್ ರೇಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
Is given 1 week time
ಪ್ಲೀಸ್
to comply with office objections raised on amended cost title and
Yes.
also comply with office objections on IA 1 of 22.
Please.
Filing of the full cost title including the amended amendment, including the amendment ಅಂತ ಹಾಕಿ. Non-filing of ವಕಾಲತ್ by ಸಿದ್ದರಾಮಯ್ಯ ತಗೊಳ್ಳಿ. Issue notice against the LRs of R3. ಯಾವ್ದ್ರ ಮೇಲೆ?
ಅಯ್ಯೋ.
IA 1 of 22 ಮೇಲೆ. IA 1 of 22. If the appellant counsel complied with office objection within 2 days.
Yes.
The registry is directed to delete the name of counsel VP Sidramaya for proposed LRs of deceased R3. Since counsel submits that LRs of R3 have not come forward to give wakalat.
Great.
ಅದೇ ಮೆಮೋನ in terms of the memo dated 24/6/24 ಅಂದ್ಬಿಡಿ.
Please.
Complaints of office objection raised on IA 1 of 22 for recalling the order dated 25/9/21.
I prefer the appellant, my lord.
ಏನ್ ರಿಕಾಲ್?
Really, I have filed the recall application.
ಆಯ್ತು, ಕಂಪ್ಲೇಂಟ್ಸ್ ಹಾಕ್ ಮಾಡಿಲ್ಲ ಆಫೀಸ್.
Complaints, that is the one complaints, my lord, that RA ಅಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ರಾಮಪ್ಪ ಅಂಡ್ ಅದರ್ಸ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಸುಮಿತ್.
ಈಗಿನ ಐಎನಲ್ಲಿ ಏನ್ ಹೇಳ್ರಿ?
That is the recall the dismissal order dated, that is 25/9/2021. ಅದ್ರಲ್ಲಿ ಆರ್ಯದಲ್ಲಿ ಆ ರಾಮಪ್ಪ ಅಂಡ್ ಅದರ್ಸ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆ ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ಅಂತ. ನೀವು ಹಾಕಿರೋದು ಅಪ್ಲಿಕೇಶನ್ ಯಾವಾಗ? ಇದು 22ರಲ್ಲಿ, ಹೌದಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು ಯಾವಾಗ? 25/9/21ರಲ್ಲಿ.
Yes.
ಹ್ಯಾವ್ ಯು ಫೈಲ್ಡ್ ಎನಿ ಕಂಡೋನೇಷನ್ ಅಪ್ಲಿಕೇಶನ್?
No, my.
ಮತ್ತೆ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ತಂದು ಬಿಸಾಕೋದು, ಆಮೇಲೆ ಹೋಗಿ ನೋಡಂಗಿಲ್ವಾ? ಆಫೀಸಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ನೋಡ್ಬೇಡ್ವಾ?
Tomorrow only I file it.
ಇನ್ನೊಂದೇನೋ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ನೋಡಿ. ಕೌನ್ಸಿಲ್ ಇಸ್ ಗಿವನ್ 1 week time to comply with office objections. IA 1 of 22. 16 ನೆಟ್ಗೆ ಹಾಕಿ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಿರಲ್ಲ ಅವಾಗ. GS but
11.
steps to be taken in respect of deceased R2.
Counsel for the
A notice issued against R2 was returned with an endorsement is no more. And hence 2 weeks time granted to take steps bringing LRs of R2. 2 ವಾರದಲ್ಲಿ ಹಾಕಿ.
Grateful man.
12.
Compliance of office objection raised on IA 1 of 22 for CD in filing LR application, IA 2 of 22 for setting aside abatement. ಯಾರ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವೇನ್ರಿ?
ಶ್ರೀನಿವಾಸ್
ಎಲ್ಲ 22 ಅಪ್ಲಿಕೇಶನ್ಸ್ ಗಳು.
ಸರ್ವ್ ಮಾಡಿಲ್ಲ.
Appellant counsel is absent and 1 week time granted to comply with office objection. If the same is not complied, list this matter for dismissal of the appeal on date code 5/7.
30.
Appellant.
Discrepancy in the name of R8 stated as Ravindra in RSA, whereas in OS RSA stated as Raghavendra Rao. ಹೇಳ್ರಿ.
ಇದರಲ್ಲಿ
ನೋಟ್ ಬಿಲೋ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಏನ್ ಹಾಕಿದ್ರಿ? ಏನದು?
ಹೌದು, ಅದು I have explained it. I have made an explanation. ಅದು appellate court judgment ಅಲ್ಲಿ
ರಿಕಾಲಿಂಗ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಅಂತ ಇದೆ.
ಹೌದು, subject to compliance.
ಅಯ್ಯೋ 1 of 23 ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ,
Appeal.
ಪೆಂಡಿಂಗ್.
ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Appeal dismissed, my lord. I filed application for recalling. But I am permitted to comply the office objections.
ಆಯ್ತು.
I have complied office objections.
Hmm.
Regarding one objection, I have written an explanation. But for acceptance of that, the matter is posted before your lordships.
ಅಂದ್ರೆ ಡೇಟ್ ನೇಮ್
Name.
ಕರೆಕ್ಟ್ ನೇಮ್ ಏನ್ ಹೇಳಿ? ಒಂದು
Correct name Ravindra.
ರವೀಂದ್ರ.
ಹೌದು, ಅದು RA ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ತಪ್ಪಾಗಿ ರಾಘವೇಂದ್ರ ಅಂತ
ಆಗಿದೆಯಾ?
ಹೌದು,
ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ?
ಅದು ರವೀಂದ್ರ ಅಂತಾನೆ ಇದೆ.
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ is accepted with regard to the discrepancy in mentioning the name of the R8. And actually his name is TK Ravindra and the same is mentioned in the original suit, but in mistake in the appellate court it is mentioned as Raghavendra Rao. Accepted and office objection is overruled. Post the matter for ಏನಾಯ್ತು ಮತ್ತೆ ರಿಕಾಲಿಂಗ ಆಯ್ತು ಇದನ್ನೆಲ್ಲ ಮಾಡಿದಿರಲ್ಲ
ಎಲ್ಲ ಮಾಡಿ.
ತಗೊಳ್ಳಿ. Heard on IA 1/23 and this court granted time to comply with office objections pending consideration of this IA and in view of the complaints and also the clarification with regard to the discrepancy of the R8 name, IA is allowed and earlier order is recalled. Post the matter for admission on. ಯಾವಾಗ ಮೇಡಮ್ 12/7 ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಲ್ಲ?
ಕಟ್ಟಿದ್ದೀನಿ.
ಮೆಮೋ ಫಾರ್ ರಿಟೈರ್ಮೆಂಟ್ ಅಟ್ ಫ್ಲಾಗ್ ಏನ್ ಪ್ರಶಾಂತಿ ಯಾರ
14.
ಗೋಪಾಲ ಕೃಷ್ಣಮೂರ್ತಿ ಹಾಕಿದಾರಲ್ಲ, ಪರ್ಮಿಟೆಡ್ ಟು ರಿಟೈರ್ as sought in memo since counsel Gopala Krishnamurthy C has filed wakalat and hence registry is directed to delete the name of Jairaj ತೆಗಿಬೇಕಾ ಮೇಡಮ್ ಇಲ್ಲಿ?
ಇಬ್ರುನು
ಹೌದು ಸರ್.
ಅದೇ ಜೈರಾಜ್ ಜಿ
ಪ್ರಶಾಂತ್
ಅಂಡ್ AL ಪ್ರಶಾಂತಿ ಇಬ್ರದ್ದು ತೆಗಿಬೇಕು.
ಅವ್ರಿಬ್ರು ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು. ಇನ್ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ.
a week's time.
Appellant counsel is given 1 week time. Non compliance ಎಷ್ಟು ಸರಿ ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್, ಎಲ್ಲ 2018. ಆಯ್ತು. 1 week time granted to comply with 3 ಸರಿ ಬಂದಿದೆ. 1 week time granted to comply with office objections. If not complied, list the matter for dismissal on 12/7. 1 week ಅಲ್ಲ 2 week ಆಗ್ತದೆ. 2 week ಆಗ್ಬಿಡಿ 12/7 ಅಂತ ಮೇಡಮ್. ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಬಂದಿದ್ದಾರೆ ಹಾಗಾಗಿ. ಜಯಣ್ಣ GR.
My lord, in this case, what happened?
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಕಾಸ್ಟ್ 5,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ರಾ?
ಇಲ್ಲಿ referred advocate is no more. ನನಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ಸ್ ಸಿಗ್ತಿಲ್ಲ ಕ್ಲೈಂಟ್ಸ್.
ಏನ್ ಮಾಡ್ಬೇಕು? ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಾ?
ದಯವಿಟ್ಟು ಒಂದು 3 weeks ಕೊಟ್ಟು ನಾನು ಅಷ್ಟರೊಳಗೆ
ಮತ್ತೆ 3 weeks
ಲೆಟರ್ ಆದ್ರೂ
ಕೊಟ್ಟಾಗಿ.
ಮಾಡಿ ನಾನು ಇಲ್ಲ ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊನ್ ಆದ್ರೂ ಮಾಡ್ತೀನಿ. ಏನಾಗಿದೆ ಅಂದ್ರೆ ನಮ್ಗೆ ಅವ್ರ ಡೈರೆಕ್ಟ್ ಕಾಂಟ್ಯಾಕ್ಟ್ ಕೊಡೋದಿಲ್ಲ ಪಾರ್ಟಿಗಳದ್ದು. ಈ ತರ ಸಮಸ್ಯೆ ಆಗ್ಬಿಡುತ್ತೆ ರೆಫರ್ ಆದಾಗ.
ನೀವು ರೆಫರೆನ್ಸ್ ಅಡ್ವೊಕೇಟ್ ಇದ್ರೂ ಪಾರ್ಟಿಗೆ ನಾವು ಅಫಿಡವಿಟ್ ಹಾಕುವಾಗ ಕರ್ಸ್ಕೊಳ್ಳಲ್ವ ನೀವು? ಅಫಿಡವಿಟ್ ಹಾಕುವಾಗ ಅಥವಾ ಸೈನ್ ಮಾಡುವಾಗ ವಕಾಲತ್ ಸೈನ್ ಎಲ್ಲ ನೀವು ಕರ್ಸ್ಕೊಳ್ಳಲ್ವ ಅವ್ರನ್ನ?
ಏನ್
ಮತ್ತೆ
ಮಾಡ್ತಾರೆ,
ಈಗ ಹೆಂಗ್ ಹೇಳ್ತೀರಿ ಇಲ್ಲ ಅಂತ?
ಸೈನ್ ಮಾಡಿ ಕಳಿಸಿರ್ತಾರೆ. ನಾವು
ಅಲ್ಲ ಆ line ಸ್ವಲ್ಪ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ನಿಮ್ಗೊಂದ್ ಸ್ವಲ್ಪ ಕೊಟ್ಟು
ಅದ್ ನಿಜ.
ಕಳ್ಸಿರ್ತಾರೆ. ಹೌದಲ್ಲ?
ಓಪನ್ ಸೀಕ್ರೆಟ್.
ಬಟ್ ನಿಮ್ ಪಾರ್ಟಿ ಬಂದಿರ್ತಾನಲ್ಲ ಅಫಿಡವಿಟ್ ಸೈನ್ ಮಾಡಕ್ಕೆ.
ಕೆಲವೊಂದ್ಸರಿ ಪೇಪರ್ ಕಳಿಸ್ತಾರೆ. ಸಿವಿಲ್ ಇದ್ರಾಗ ಪಾರ್ಟಿಗಳು ಬರೋದೇ ಇಲ್ಲ.
ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, ಇದು ಅಡ್ಮಿಟ್ ಆಗಿರೋದೇ 2019 ಅಲ್ಲಿ.
ಅದೇ ದಯವಿಟ್ಟು ನಾನು ಅವರಿಗೆ ಡೈರೆಕ್ಟ್ ಲೆಟರ್ ಆದ್ರೂ ಬರೋದು.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ನಾವು?
ಒಂದು ಏನೋ ನಾನು
ಕಾಸ್ಟ್ ಹಾಕಿದ್ದು ಯಾವಾಗ ಇದು? 8/7/22 ನಲ್ಲಿ. ಓಹ್ ತಗೊಳ್ಳಿ.
ದಯವಿಟ್ಟು
This
ಒಂದು
court
ನನಗೆ
will order
3 weeks
dated 8/7/22
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ನನಗೆ ಇದಾಗಬಾರದು.
4 weeks time is granted to file paper book failing which appellant shall be appellant.
ಒಂದು 3 weeks ಕೊಟ್ಟು ನಾನು ಲೆಟರ್
ಅವಾಗ್ಲೂ ಕಾಸ್ಟ್ ಹಾಕಿರೋದು ಹೇಗೆ ಅಂದ್ರೆ 4 weeks ಫೈಲ್ ಪೇಪರ್ ಬುಕ್ ಫೈಲಿಂಗ್ ವಿಚ್ ಕಾಸ್ಟ್ ಆಫ್ ₹5,000 ಅಂತಿದೆ. Appellant shall pay the cost of ₹5,000 and even after 2 years paper book is also not filed and the cost is also not
ಫೈನಲಿ ಕೊಡಿ.
filed.
ನಾನು ದಯವಿಟ್ಟು ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಇದಾಗಬಾರದು ಪಾರ್ಟಿಗಳಿಗೆ, ನಮ್ಮ ಮೇಲೆ ಒಂದು ಇದಾಗಬಾರದು.
ನಿಮ್ಮೇಲೆ ಏನಾಗುತ್ತೆ? ನೀವೇನ್
ಅವ್ರಿಗೆ
ಮಾಡಿದ್ರಿ?
letter ಆ party
ಈ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಪಾರ್ಟಿಗೆ ಲೆಟರ್ ಬರ್ದಿದ್ದೀರಾ ನೀವು?
ನಾನು
2022 ಲೆಟರ್
ಇಲ್ಲ
ಬರ್ದಿಲ್ಲ.
ಇವ್ರಿಗೆ, ಯಾಕಂದ್ರೆ ಇವ್ರಿಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡ್ತಾ ಹೋದೆ.
ಯಾರಿಗೆ?
ರೆಫರ್ಡ್ ಅಡ್ವೊಕೇಟ್ ನ.
ಆಯ್ತು, ಏನಾಯ್ತು 2 ವರ್ಷದಿಂದ ಏನ್ ಮಾಡಿರಿ ಹೇಳಿ?
ಅವ್ರದ್ದು ನನಗೆ ಇದು ಸಿಗ್ಲಿಲ್ಲ. ಈಗ ಅದನ್ನಾದ್ರೂ ಮಾಡ್ತೀನಿ.
ಮತ್ತೆ date ಕೊಡೋದು
3 weeks ನಲ್ಲಿ ನಾನು ಇದನ್ನ
2 ವರ್ಷ ಆಗಿದೆ. ಮತ್ತೆ
ಇದೆ ಇದೊಂದು
Hence,
ಅವಕಾಶ.
appeal is dismissed for non filing of the paper book
ಒಂದು 3 weeks
and also non payment of cost.
3 weeks ನಲ್ಲಿ ಏನೋ ಒಂದು
2 ವರ್ಷ ಆಗಿದೆ.
ಯಾಕಂದ್ರೆ ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಏನೋ ಬಂದಿರೋದು ಅನ್ಸುತ್ತೆ. ಹಾಗಾಗಿ
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದ್ರೆ ಏನು, ನಿಮಗೆ ಕೊಟ್ಟಿರೋದು 2 ವರ್ಷದಿಂದಾನೆ
ಆಗಿದೆ. ದಯವಿಟ್ಟು 3 ವಾರ ಏನೋ ಒಂದು
ಮತ್ತೇನ್ ಕೊಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ.
ದಯವಿಟ್ಟು
ಆಯ್ತು,
ನಮ್ಮ ರಿಕ್ವೆಸ್ಟ್.
ನಿಮ್ ರಿಕ್ವೆಸ್ಟ್ ಆದ್ರೂ ಏನು, ನಿಮ್ ರಿಕ್ವೆಸ್ಟ್ ಮೇಲೆ ಕೊಟ್ಟಿರೋದು 2 ವರ್ಷ ಟೈಮ್.
ಫೈನಲಿ ಇದು
4 weeks ಕೊಟ್ಟಾಗ ನಿಮ್ಗೆ 2 ವರ್ಷ ಆಗಿದೆ. ಈಗ
ಫೈನಲಿ ಅಥವಾ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ
ಫೈನಲಿ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ ಯಾವ ತರದ ಸ್ಟೇಜ್ ಗಳು ಯಾವ ಇಲ್ಲ. ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್
ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದಾಗ ಒಂದು 3 weeks ಕೊಟ್ರಿ ಸ್ವಾಮಿ. ಅದ್ರ ಮೇಲೆ ನಾನು ಅವರು ಇದು ಮಾಡ್ತಿದ್ದೆ.
18/7/22 ನಲ್ಲಿ ಆಗಿರೋದು. ನೆಕ್ಸ್ಟ್
ಈಗ 3 weeks ದಯವಿಟ್ಟು.
ಶೇಖರ್ KM
ಸೋಮಶೇಖರ್ ಕೆ
notice to R1 and R3.
For appellants.
PF pay ಮಾಡಿ.
Acceptance of paper book filed by counsel for appellant. ಏನಕ್ಕೆ ಮೇಡಮ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಯಾಕೆ? ಮತ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡೋರ? ಆಯ್ತು, ಏನ್ ಸರ್ವಿಸ್ ಹೇಳ್ರಿ R1 and R3 ಗೆ
ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿ
ಸರ್ವಿಸ್ ಯಾವಾಗಿಂದ ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್. ಎಷ್ಟು ಸರಿ ಬಂದಿದೆ ಸರ್ವಿಸ್ಗೆ?
ಬಂದಿಲ್ಲ ಸರ್. 18 ಆದ್ಮೇಲಿಂದ ಬಂದಿಲ್ಲ.
18 ಆದ್ಮೇಲೆ ಕೋರ್ಟ್ ಮುಂದೆ ಫೈಲೇ ಬರ್ಲಿಲ್ವಾ? ಎಲ್ಲ ಬೃಹಸ್ಪತಿಗಳು. ಆಯ್ತು, ಇಶ್ಯೂ ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಕೊಡ್ತೀರಿ PF?
PF ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಮತ್ ಈ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಯಾಕೆ ಹಾಕಿದ್ರು ಪೇಪರ್ ಬುಕ್ ನ?
ಅವರು ಅದಾದ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ ಸರ್, ಅವಾಗ ಟೈಮ್ ಕೊಟ್ಟ ಮೇಲೆ ಇವರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ ಪೇಪರ್ ಬುಕ್ ನ ಸರ್.
ಅಂದ್ರೆ ಆಫ್ಟರ್ ಟೈಮ್ ಆದ್ಮೇಲೆ ಇರ್ಬೇಕು. ಆಯ್ತು. Paper book is accepted. The appellant counsel is directed to pay the PF. ಒಂದ್ಸರಿ ಹೋಗಿ ಬಂದಿದ್ಯಾ ನೋಟಿಸು?
ಒಂದ್ಸತಿ ಹೋಗಿ ಬಂದಿದ್ದೀವಿ.
Pay PF within 1 week, and if PF paid within 1 week, issue notice against R1 and R3. If PF not paid within 1 week, appeal is dismissed against R1 and R3.
ಇವತ್ತೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದೀರಲ್ರಿ?
Yes ಸ್ವಾಮಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
PF ಹಾಗಾದ್ರೆ ಹೇಳ್ಬಿಡಿ. Council submits that he has paid the PF and hence issue notice against R1 and R3. ಸುಮ್ಮನೆ ಇದ್ದೀರಲ್ರಿ ಅವಾಗಿಂದ?
70 ಆರ್ಯ
ದೇವಾನಂದ್ ಹೇಳ್ರಿ. ನೋಟಿಸ್ ಇದೆ, ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್, ಅದೇ ಯಾವ ವರ್ಷದ್ದು? ಆರ್ಡರ್ ಯಾವಾಗ? 19.
ಪೇಪರ್ ಬುಕ್ 8 weeks ಇತ್ತು.
8 weeks.
ಆದ್ಮೇಲೆ ಬಂದಿಲ್ಲ.
ಬಂದೇ ಅಲ್ವಾ? ಆಯ್ತು. Another 4 weeks time granted finally to file the paper book. PF ಏನ್ ಹೇಳಿ? R3 second time. If PF paid within 1 week, issue notice against R3.
80.
Next. Furnishing of PF, correct address, etc. to issue notice to R1.
Sorry, for 2 days time, my lord, I'll take steps.
Council submits that he will pay the PF within 2 days, and if PF paid within 2 days, issue notice against R1.
90.
Next. Non-filing of paper book by order dated 28/11/2018. 4 months time was granted to file paper book. Office objection raised on KVTR Wakalat filed by the learned counsel Rangaswamy. KVTR ಬೇರೆ ಇದೆ ಇದ್ರಲ್ಲಿ. ಅದಿಂದೇನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಈಗ ಅಪಿಯರ್ ಆಗ್ತಾರಲ್ಲ ಅವರು, KVT ಮಾತ್ರ ಅಲ್ಲ. ಅಡ್ಮಿಟ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಹೇಳ್ರಿ ಏನು?
ಪೇಪರ್ ಬುಕ್ ಒಂದು ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡೋದು ಸಿಂಪಲ್ ಆಗಿ. ಎಲ್ಲ ಟೈಪ್ಡ್ ಕಾಪಿ
28/11 ಆರ್ಡರ್ ಆಗಿರೋದು. 4 months ಟೈಮ್ ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ನೀವು ಫೈಲ್ ಮಾಡಿಲ್ಲ, ಏನ್
ಡಿಸ್ಪೆನ್ಸ್
ಮಾಡಿ?
ಮಾಡಿ KVT ಇದಾರೆ,
ಇದುವರೆಗೂ
KVT ಇದಾರೆ, ಹಾಗಾಗಿ ಅಡ್ಮಿಷನ್
ಬಂದೇ ಇಲ್ವಾ? ಆಮೇಲೆ ಫೈನಲಿ 4 weeks time granted to file paper book. In view of the order, ಇನ್ನು ಬೇಡ, ಇನ್ನು ಬೇಡ.
ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಬಹುದು ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ, ಯಾಕಂದ್ರೆ ತುಂಬಾ ಟೈಪ್ಡ್ ಕಾಪಿ ಇದಾವೆ.
ಆಲ್ರೆಡಿ there is an order to file paper book within 4 months. ನೀವು ಆಗ್ಲೇ ಕೇಳ್ಕೋಬೇಕು, ಆಗ್ಲೇ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಬೇಕು ಅಂತ, ಈಗಲ್ಲ. After 6 years. 4 weeks,
ಹಾಕಿರೋದು KVT ಹಾಕಿರೋದು, ಅದಕ್ಕೂ ಸ್ಟಾಂಪ್ ಹಾಕಿಲ್ಲ.
ಸ್ಟಾಂಪ್ ಹಾಕಿಲ್ವಾ?
ಇದು ಹಾಕಿಲ್ಲ.
GPA ಯಾರು ಅಪಿಯರ್ ಆಗೋದಿಲ್ವಲ್ಲ? ಆಲ್ರೆಡಿ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. ಇನ್ನೇನು KVTR ಕೌನ್ಸಿಲ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏರ್ ಮಾಡೋದು, ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು ಅಷ್ಟೇ. ತೊಳಿ. The KVTR council is also directed to comply with office objections within 1 week.
20.
ಮತ್ತೆ 4 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ, ಹಾಕಿ
ಪ್ಲೀಸ್.
Sridhar NG conserved with postal cover deceased R5.
Lordships, kindly
6
see.
time granted to bring the LRs of R5 on record. Next.
R5 ಎಕ್ಸ್ಪೈರ್
R5
ಆಗಿದ್ದಾರೆ ಅಂತ
ಸತ್ತೋಗಿದ್ದಾನೆ.
ಬಂದಿದೆ. R6 ಇದಾರಲ್ಲ ಸ್ವಾಮಿ ರೆಕಾರ್ಡ್ ನಲ್ಲಿ. ಶಿ ಇಸ್ ದಿ ಓನ್ಲಿ ಸರ್ವೈವಿಂಗ್ ಲೀಗಲ್ ಹೇರ್ ಆಫ್ R5 my lordships.
ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ.
ಫೈಲಿಂಗ್ ಎ ಮೆಮೊ
ಕೊಡಿ ಮತ್ತೆ ಅದನ್ನ. ಈಗ R6 ಗೆ ಸರ್ವಿಸ್ ಆಗಿಲ್ವಲ್ಲ?
ಅದೇ ಅದನ್ನ ಅದು ಇನ್ಫ್ಯಾಕ್ಟ್ ಅವರು ನನಗೆ ವೆಂಡರೇ ಸ್ವಾಮಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಬೇಕು ಅಂತ.
ಆಯ್ತ್ರಿ, R6 ಗೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ. ಈಗ
I will take steps.
ತಗೊಳ್ಳಿ. The council appearing with the appellant would submit that the respondent number 6, who is already on record, is the daughter of the deceased respondent number 5, and she is the only surviving legal heir of the deceased respondent number 5. And hence appeal is, the memo is accepted, and appellant counsel is directed to amend the cast title in terms of the memo. Pay PF within 1 week.
Please.
Issue notice against R6 if PF paid.
Paper book may kindly be.
Issue notice. ಯಾರಕ್ಕೆ ಯಾಕೆ ಎರಡು ಹೆಸರು ತೋರಿಸಿದ್ರು ನೋಡಿ ಮೇಡಮ್. ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪಲೆಂಟ್ ಇಸ್ ಅದು ಅಕ್ಸೆಪ್ಟ್
ಆದ್ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು, ಅಕ್ಸೆಪ್ಟೆಡ್. ಇದೇನಾಯ್ತು ನೋಡಿ, ಇಬ್ಬರ ಹೆಸರು ಇದೆಯಲ್ಲ. ನೀವು ಫಸ್ಟ್ ವಕಾಲತ್ ಯಾರಿದ್ದು ಹಾಕಿದ್ ಫಸ್ಟ್ ನೀವು 30, ಅವ್ರದ್ದು ಯಾವಾಗ ನೋಡಿ ಮೇಡಮ್ ಡೇಟ್?
ಅವರು 30/10/2019.
ಅವ್ರದ್ದು 30/10 ಸಬ್ಸಿಕ್ವೆಂಟ್. ತೊಳಿ. ಕೌನ್ಸಿಲ್ ಪ್ರಕಾಶ್
ಇದೇ ಹಾಕಿದ್ದಾರೆ ಅವರು.
ಆಯ್ತು. ಕೌನ್ಸಿಲ್ ಪ್ರಕಾಶ್ MH is directed to clarify with regard to his wakalat, since he has filed wakalat without NOC from councillor PN Harish.
21.
MB Chandrachud. Issue notice to
Grateful done.
Grateful done. Council submits not needful is done and hence issue notice against R1.
R1 and R2.
Hmm?
R2.
R2?
R1 and R2.
True ಇದೆ. R1 and R2.
22.
Please.
GM Natraj.
GM Natraj, steps to be taken in respect of steps to be taken ಅಂತಿದೆ ನೋಡಿ mostly first. ಯಾವಾಗ ಬಂದಿರೋದು? Appellant counsel is given for 2 weeks time to bring the LRs of deceased R11. List this matter on 12/7.
23.
23, perusal of letter dated 8/12/20 received from the office of the senior civil judge Nalamangala, submitting the service of order in respect of so and so, so and so. ಏನ್ ನೋಡ್ರಿ ಲೆಟರ್ ಅದು? ಇದೇನ್ 8/12/2020 ನಲ್ಲೇ ಬಂದಿರೋ ಲೆಟರ್.
There was a right to submit the clearing to duly served orders in RSA on the file of the honorable to respondent 1 and 2. And 3 is reported to be returned.
1 and 2 ಜಾರಿಯಾಗಿದೆ. In terms of the order dated 8/12/2020 of the civil judge and senior civil judge and JMFC, notice is held sufficient against R2. It is also reported that R3 is no more and hence appellant counsel is directed to bring the LRs of R3 within 2 weeks.
Please.
ಅಲ್ಲಿಗೆ ಏನಾಯ್ತು ಮೇಡಮ್? 1, 2, 3 ಆಯ್ತು. 4 and 5 ಗೆ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು. 4 and 5 ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು.
Please, action.
The council is directed to pay PF to issue notice against R4 and R5 within 1 week. If PF paid, issue notice against R4 and R5. Non-filing of paper book ನೋಡ್ರಿ ಯಾವಾಗಿಂದ?
2020 ನಲ್ಲಿ.
It's fine. 3 weeks, my lord. I just file it now. Was admitted, my lord.
ಕೊಟ್ಟಿಲ್ವಾ?
Okay.
ಆಯ್ತು. Appellant counsel is directed to file paper book within 4 weeks.
Please.
4
Action.
weeks.
Pleasure.
24.
Compliance of office of rejection on A1/29. Impleading applicant filed by a counsel for appellant ಅಂತಿದೆ ನೋಡಿ. appellant ಹಾಕಿರೋದಾ?
Rakshit Kane.
Rakshit KN. ಇಲ್ವಾ? Appellant counsel is absent and IA though filed in 2019, office objection not complied. If office objection not complied within 1 week, IA 1/19 is dismissed. Directed to pay PF within 1 week. If PF paid within 1 week, issue notice against R2. If not paid, if not,
Council is no more.
ಈ ರಕ್ಷಿತ್ ಇವರ ಯಾರು ಬೇರೆ ಇದಾರಲ್ಲ ಮತ್ತೆ ಇಶ್ಯೂ ಕೋರ್ಟ್ ನೋಟಿಸ್ ಆಗ್ಬೇಕಾಗಾರೆ ಇಶ್ಯೂ ಬೇರೆ ವಕಾಲತ್ ಯಾರ್ದಾರು ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್. ಕಾರ್ತಿಕ್ ಅಂತ ಇದಾರ? It is learned from the bar that Rakshit counsel is no more and having perused the wakalat, counsel Karthik PM also signed the wakalat and hence registry is directed to show the name of the counsel Karthik PM in the cause list for the appellant. This matter on 12/7.
25.
Acceptance of paper book filed by the council accepted. Then late ಇದೆಯಾ? 2 week time is granted to file paper book ಯಾವಾಗ್ಲೂ. ಆಯ್ತು.
File ಆಗಿದೆ.
ಆಯ್ತು at least. Non taking of steps in respect of deceased R1. Ramesh MN.
Rest time.
Pray
for 2 weeks time. Steps.
ಸ್ಟೆಪ್ಸ್ಗೆಲ್ಲ ಮೊದಲೇ ಟೈಮ್ ಕೊಟ್ಟಿದೆ. ನಾನ್ ಟೇಕಿಂಗ್ ಆಫ್ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಬಂದಿದೆ. ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು ಟೈಮ್ ನೋಡಿ. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಯಾವಾಗ ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಿತ್ತು ನೋಡಿ.
19 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು 8 weeks ಅಂತ.
8 weeks ಆಮೇಲೆ ಏನಾದ್ರು ಇಷ್ಟ ಆಯ್ತಾ ಪೇಪರ್ ಬುಕ್?
ಆಮೇಲೆ ಇನ್ನೊಂದು 19 ಅಲ್ಲೇ ಆಗಿದೆ. 2 weeks to do the needful ಅಂತ ಆಗಿದೆ.
ಅದು ಮೋಸ್ಟ್ಲಿ PF ಇರಬೇಕು.
ಅವಾಗ ಡಿಸೀಸ್ಡ್ ಅಂತಾನು ಬಂದಿದೆ R1 ಗೆ.
ಅದಕ್ಕೆ R1 ಗೆ ಯಾವಾಗ ಬಂದಿರೋದು? 19 ಅಲ್ಲಿ. ಆಮೇಲೆ ಸ್ಟೆಪ್ಸ್ ಡೇಟ್ ಕೊಡ್ಲಿಲ್ವಾ ಡಿಸೀಸ್ಡ್ ಅಂತ ಬಂದ್ಮೇಲೆ? ಅವಾಗ ತೋಳಿ 2021 death of R1 was reported and 2 weeks time ಅದೇ in 1919 ತೋಳಿ on 8/4/19 when the death of R1 was reported, this court granted 2 weeks time on 8/4/2019 to do the needful. Until date not filed any application to bring the LRs of R1 and hence appeal against R1 is abated. Paper book ಗೆ ಏನಾದ್ರು ಬಂದಿದೆಯಾ ಮತ್ತೆ? ಮತ್ ಬರ್ಲೇ ಅಲ್ವಾ? Told in 2019 when the matter was admitted, 8 weeks time was granted. And paper book not filed. However, another 4 weeks time granted to file paper book. Finally, if paper book not filed within 4 week, respondent session idರಲ್ಲಿ 2 to 6 idare. If not filed within 4 weeks, appeal is dismissed without reference to the bench.
27.
Non-filing of wakalat by B.V. Vidyulata on behalf of R7. Ilva counsel, ನೀವು ಯಾರಿಗ್ರಿ?
For the RSA 114/90 my lord.
114.
4/90.
ನೀವೇ ಇದ್ದೀರಲ್ಲ.
ಅವರೇ ಒಂದು ವಕಾಲತ್ ಹಾಕ್ಬೇಕು. She is the appellant my lord in the connected.
R7 ಗೆ ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ರಲ್ಲ.
I will undertake to file.
ಆಲ್ರೆಡಿ ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದಿರಿ. ನಾನ್ ಫೈಲಿಂಗ್ ಅಂತಲೇ ಇರೋದು.
ಅವರು ನಾಳೆ ಅಥವಾ ನಾಳೆ ಕಳಿಸ್ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ನಾನ್ ಫರ್ನಿಶಿಂಗ್ ಆಫ್ PF correct address.
I'm seeking dispensation. I'm seeking dispensation.
So appellant counsel files memo to dispense the notice against R11. And hence dispense the notice against R11 at the risk of the appellant. ಆಯ್ತಾ? The counsel B.V. Vidyulata undertakes to file wakalat within another 1 week in respect of R7. Next complaints ಏನೋ ಇದೆಯಲ್ಲ ನಿಮ್ದ್ರಲ್ಲಿ?
In my case my lord, the issuance of notice to R9 my lord. The R9 has been placed ex parte before lower court.
The very same respondent my lord whom I sought dispensation.
ನೀವು
They are also seeking
That
dispensation.
extent
ಅಲ್ಲ ಬಟ್ ಇದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನಿದೆ?
ಅವರು process fee ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದ್ರ ಮೇಲೆ office objection.
office subject.
ತೊಗೊಳ್ಳಿ. ಅವರು ಒಂದು ಮೆಮೊ ಹಾಕ್ತಾರೆ ಈಗ. The appellant counsel in RSA 114 of 2019 also files memo to dispense the notice against R9. And in view of the filing of memo, notice against R9 is dispensed at the risk of the appellant. And no need of compliance of office objections with regard to the office objection raised on PF and PF.
It's a partition suit.
Admission ಆಗಿದೆಯಾ?
Admission ಆಗಿದೆ. Date
ಹಾ.
for final hearing may kindly be.
Paper book ಹಾಕಿದ್ದೀರಾ?
Paper book
ಹಾಕಿದ್ದೀರಿ.
ಹಾಕಿದ್ವಿ.
List this matter for final hearing on 1st of August.
ಅಲ್ಲ, July ಅಲ್ಲಿ.
July
Because my client my lord is in
ಹಾಕಿದೀವ್ರಿ.
11th.
ರೀಚ್ ಆಗ್ಬೇಕಲ್ಲ.
I'll take my chance.
ಚಾನ್ಸ್ ತಗೊಳ್ಳಿ ಅಷ್ಟೇ. 12/7.
28.
Dismissal of appeal for non-compliance of office objections.
Here for the appellant.
ಹೇಳಿ. Dismissal ಗೆ ಅಂತ ಇಟ್ಟಿದೀವಿ, ಯಾಕೆ ಮಾಡಿಲ್ಲ ಇನ್ನು?
Not sir.
Dismissal ಗೂ ಇಟ್ರು ಮಾಡಲ್ಲ, ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು ಮಾಡಲ್ಲ.
Appellant counsel may not under.
Directed the learned counsel for the appellant to make a note in the cast title and the same is not complied. However, 1 week time granted to learned counsel for the appellants to comply with order dated 26/23. If the same is not complied within 1 week, appeal will be dismissed. ಹೇಳಿ.
Appellant counsel had undergone head surgery, my lords, and moreover.
Undergone?
Head surgery.
Head surgery.
Please, my lords. And my lords, the original appellant, my lords, was dead.
ಅವ್ರಿಗೆ ಯಾರು ಕೊಲೀಗ್ಸ್ ಇಲ್ವಾ? ಅವ್ರಿಗೆ ಯಾರು ಕೊಲೀಗ್ಸ್ ಇಲ್ವಾ?
ಇದ್ರು ಸ್ವಾಮಿ, ಬಟ್ ನೋಟಿಸ್ ಅವ್ರಿಗೆ ಹೋಗ್ಲಿಲ್ಲ.
ಹಾ?
ಇವ್ರ ಹೆಸರಲ್ಲಿ ಕಾಸ್ ಲಿಸ್ಟ್ ಇದ್ದಿದ್ರಿಂದ.
ಕಾಸ್ ಲಿಸ್ಟ್ ಇವ್ರಿಗೆ ಬಂದ್ರುನುವೆ ಕೊಲೀಗ್ಸ್ ಇರ್ತಾರಲ್ಲ ಆಫೀಸಲ್ಲಿ.
Finally, 1 week's time may kindly be granted.
Dismissal ಗೆ ಇಟ್ಟಿದೀವಿ ಮೇಡಮ್ ಇವತ್ತು. ಅವ್ರಿಗೆ ಎಷ್ಟಿಲ್ಲ ಅಂದ್ಮೇಲೆ ನಾವೇನು ಇಟ್ಕೋಬೇಕು ಹೇಳಿ?
By Tuesday or Wednesday, my lords, it will be complied.
ಡಿಸ್ಮಿಸಲ್ ಇಟ್ಟಿರೋದ್ರಿಂದ ಮತ್ತೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದು ಏನೋ ಒಂದು ಸಿಂಪಲ್ ಆರ್ಡರ್ ಇದೆ ರೀ, ಅದನ್ನ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಅಷ್ಟೇನೆ. ನನ್ ಅಪಿಯರ್ಸ್ ಫಾರ್ ದಿ ಅಪಲೆಂಟ್ ಬರೀ ಇದೆ. Directed the learned counsel for the appellants to make a note in the cast title ಅಂತ ಏನೋ ಮಾಡಿದೀವಿ. And the same is not complied.
I'll get instructions, my lords, by Tuesday or Wednesday.
Proxy counsel submits that appellant counsel who is on record is underwent head surgery and seeks 1 week time and hence 1 week time granted. Finally, even though matter is listed for dismissal of appeal in view of the submission of proxy counsel, this matter on 1 week under 5/7.
Please. 29.
27 ಇದು ಕೂಡ ಏನೋ ಡಿಸ್ಮಿಸಲ್ ಇಟ್ಟಿದೀವಿ ನೋಡಿ. ಡಿಸ್ಮಿಸಲ್ ಆಫ್ against R2, R6, R10, R17 ಏನ್ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಅಂತನಾ? ತಗೊಂಡು this court wide order dated 13/6/24 having noticed appellant counsel is absent directed to pay within PF within 1 week. And also made it clear, if PF paid within 1 week, issue notice. If PF not paid within 1 week, list the matter for dismissal. Against respond number 2, 6, 10, 17 and 20 to 24. And in spite of it, PF not paid and hence appeal against R2, R6, R10, 17 and 20 to 24 is dismissed.
30.
List the matter, date code, list the matter on 12/7.
4 weeks.
ನಿಮ್ದಲ್ರಿ
Paper book.
ನಿಮ್ದಲ್ಲ ಹಿಂದಿಂದು. If learned counsel doesn't appear in the next date of hearing, appeal will be dismissed ಅಂತ ಹಾಕಿ. ಯಾವ ದಿವಸನೂ ಬರಲ್ಲ. Next,
30.
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಪೇಪರ್ ಬುಕ್ ಹೇಳ್ರಿ.
4 weeks time.
4 weeks ಯಾವಾಗ ಅಡ್ಮಿಟ್ ಆಗಿದ್ದು?
15 ಅಲ್ಲಿ ಆಗಿರೋದು.
20 ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟು?
ಇಲ್ಲ,
ಎಷ್ಟು
ಇಲ್ಲ.
ಟೈಮ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಆಯ್ತು. Another 4 weeks time granted to file
Entry
paper.
matter may be extended.
And entry matter granted earlier is extended till next date of hearing. List this matter after 4 weeks ಅಂದ್ರೆ ಕೊಡಿ, ಒಂದು ಡೇಟ್ ಕೊಡಿ.
29.
29/7. If paper book not filed within 4 weeks, appeal will be dismissed without reference to the bench. Appeal is dismissed ಅಂತ ಹಾಕ್ಕೊಡಿ, will be ಬೇಡ. Dismissed without reference to the bench. P. Nataraj, non-filing of account for having paid the decretal amount 25%.
ಮಾಡಿರ್ತಾರೆ ಈ ಪೇಪರ್ ಬುಕ್
ಮಾಡಿರ್ತಾರೆ, ಬೇಡ ಮಾಡಿದಿರಾ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳಿ.
4 weeks ಟೈಮ್ ಕೊಟ್ರೆ ಅದನ್ನು
ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಈಗ ಬಂದಿರದೆ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ಲಾನ್ಮೆಂಟ್
ಅಲ್ಲ ಇದು ಪೇಪರ್ ಬುಕ್ ಬಂದಿದೆ. ಪೇಪರ್ ಬುಕ್ ಬಂದಿದೆ.
ಪೇಪರ್ ಬುಕ್ ಏನಾಯ್ತು?
3 months ಅಂತ 21 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
21 ಅಲ್ಲಿ 3 months ಆಮೇಲೆ ಬಂದೇ ಇಲ್ಲ. Another 4 weeks time is granted to file paper book. If paper book not filed another 4 weeks, appeal is dismissed without reference to the bench.
32.
Non-furnishing of PF correct address to issue notice to R3.
Not, I am informed the R2 has relocated to a different address, my lords. Lordship may
Not
kindly-
R2, R3.
R3, my lord. Kindly 5 days time, my lord.
The council seeks 5 days time to ascertain the correct address
Correct
of R3 and pay PF. If PF paid, issue notice against R3.
Great.
33.
Memo dated 25/6/24 along with affidavit hand summons in respect of R1A to C.
R1C served.
R1C served.
Served through her
What about A and B?
mother-in-law. A and B refused. I filed the affidavit.
affidavit ಹಾಕಿದಿರಾ?
ಹಾಕಿದ್ದೀನಿ sir.
ತೊಗೊಳ್ಳಿ. The notice issued against R1C is served. ಇದೆಯಾ ಮೇಡಮ್? R1C ಏನ್ ತೋರ್ಸೇ ಇಲ್ಲ. ಈಗ ಹಾಕಿದಿರಿ. ಹೇಗ್ ಸರ್ವ್ ಮಾಡಿದಿರಿ ನೀವು? R1C ಗೆ ನೀವೇ ಸರ್ವ್ ಮಾಡಿದ್ರಾ?
ಹೌದು, ಮಂಜುಳಮ್ಮ ಅಂತೇಳಿ R1A to C ನೋಟಿಸ್ ಕೊಟ್ಟಿದೆ.
ನೀವು ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಒಬ್ಬರಿಗೆನೆ?
ಒಬ್ಬರಿಗೆ ಸರ್ವ್ ಆಗಿರೋದು, ಇಬ್ಬರು ರೆಫ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
served and in respect of R1A to A and B,
ರೆಫ್ಯೂಸ್.
affidavit is filed stating that both of them have refused to receive the same and hence sufficient against A1 and B. ಬಾಕಿಯವರು
ಸರ್ವ್ ಆಗಿದೆ.
and C is served. What about D and
D
D?
and E ಆಲ್ರೆಡಿ ಸರ್ವ್ಡ್, ಕೋರ್ಟ್ ನೋಟಿಸ್ ಸರ್ವ್ಡ್
D and D ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
And in spite of C is served unrepresented. Sufficient ಮಾಡಿದ್ನಾ A and B? ಆಯ್ತು. D and D already been served. ಎಲ್ಲಿದೆ ಮೇಡಮ್ D and C? ಫಸ್ಟ್ ಪೇಜ್ ಎಲ್ಲ ಇದೆಯಾ? ಅದೇ ಬ್ರಿಂಗಿಂಗ್ ಎಲ್ಲರ್ಸ್ ಅಲ್ವಾ? ಯಾರಿಗೆ? ಅಪಲೆಂಟ್.
Outgoing application. IA 122 is for appellant. IA 123 is for respondent.
Third. This court has issued notice against the LRs of R1. And in spite of service of A1, C, D and E, they have not filed any objections and also fails to engage the council. And this court held A and B as held sufficient and for the reason stated in the accompanying application, A1 of 23. And there is a delay of 237 days and also relief is sought for setting aside the abatement and seeking permission to bring the LRs of deceased R1 and court is satisfied with the reasoning and hence delay is condoned, abatement is set aside and permitted to bring the LRs of R1D on record. Next, heard on IN,
IA number one.
Heard on IA number. One ಅದು, 1/22.
Sole
And
appellate.
there is a, idral delay ilva, and there is a delay, and also sought for the relief of setting aside the abatement and bringing LRs of deceased sole appellant
Sole appellant.
on record, and for the reasons stated in the accompanying application of probate, IA is allowed and permitted to bring the LRs by condoning the delay and setting aside the abatement.
Please.
Appellant counsel is directed to amend the cast title and file amended cast title within 2 weeks.
Please.
Respondent ಯಾರು appear ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ?
Two appellant.
ಕೆಲವರು ಇದಾರಲ್ಲ. List the matter for admission on 12/7.
Two is subsequent purchaser. They are not a parties of
ಇದಾರಲ್ಲ, ಅವರು ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದಾರಂತ.
record evidence.
Who ಇದಾರಲ್ರಿ? PN for R2.
But he is the subsequent purchaser, but other respondents are the family members, the partition suit.
ಆಯ್ತ್ರಿ, ಈಗ ಇದಾರೆ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಅಡ್ಮಿಷನ್ಸ್ ಇಟ್ಟಿದ್ವಿ. ಬರ್ಲಿ.
Please, please.
34.
ನಾನ್ ಪೇಮೆಂಟ್ ಆಫ್ DCF as per proviso to schedule 2 article. ಹಾ ಹೇಳ್ರಿ.
But,
ವಿಜಯ್ ಕೃಷ್ಣ ಭಟ್.
but office objection was raised
ಹಾ
on the question of court fees bill.
ಹಾ.
A petition for succession certificate number 372. That was rejected and appeal is also rejected, against which this petition is filed. But I have paid court fee. But as per schedule 2,
The Learned Counsel for the appellant submits that there are more number of office objections in view of conversion of.
ಅದು ಮಾಡಿದ್ದೀನಿ sir.
ಅದೆಲ್ಲ ಮಾಡಿದಿರಾ?
ಅದೆಲ್ಲ ಇದೊಂದೇ ಉಳ್ಕೊ-
ಈಗ ಹಾ ಹೇಳಿ.
succession certificate petition ಗೆ
ಆಯ್ತು.
schedule 2,
ಹ್ಮ್
article 11,
ಹ್ಮ್
L,
ಹ್ಮ್
2 mil.
ಹ್ಮ್
Application for probate or letters of administration or for revocation of thereof,
ಹ್ಮ್
or for application for certificate under part 10, that is section certificate
ಹ್ಮ್
of the Indian Succession Act.
Hmm.
The fee, if the amount of the value is doesn't exceed 2,005 rupees,
ಹ್ಮ್
if it's exceed 10,010 rupees, value of is exceed 10,000 rupees, not then 25 rupees is payable.
ಹ್ಮ್
So accordingly, I have paid 25 rupees.
ಹ್ಮ್
And one more objection was, ಕೆಳಗಡೆ 25 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದಕ್ಕೇನು ಡಿಕ್ರಿನಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ಬರ್ದಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಹ್ಮ್
But here I have paid 100 rupees.
ಹ್ಮ್
So under 11(4), that can be adjusted because there is additional 25 rupees is there. Not only at the time,
ಆಯ್ತು, ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಎಷ್ಟು ಕಟ್ಟಿದೀರಿ ಅನ್ನೋದು ಎಲ್ಲಿದೆ? ದಾಖಲೆ ಎಲ್ಲಿದೆ?
ಡಿಕ್ರಿಯನ್ನು ಡ್ರಾ ಮಾಡಿಲ್ಲ.
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಎಲ್ಲ ಎಲ್ಲಿದೆ?
ಡಿಕ್ರಿ ಡ್ರಾ ಮಾಡಿಲ್ಲ sir.
ಡಿಗ್ರಿನೂ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಇಲ್ಲ ಡಿಕ್ರಿ ಡ್ರಾ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಆಫೀಸ್ ಆದ್ಮೇಲೆ ಡಿಗ್ರಿ ಡ್ರಾ ಮಾಡ್ಲೇಬೇಕಲ್ಲ?
ಇದು P&S ಇಂದ ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಹ್ಮ್
Can get
ಕೋರ್ಟ್ ಹೋಗ್ಲಿ ಎಲ್ಲಿದೆ?
ಆರ್ಡರ್ ಶೀಟ್ ತರಿಸ್ಬೇಕಷ್ಟೇ ಸರ್.
ಅದನ್ನೇ ತರಿಸಿ ನೋಡಿ ಹಾಕಿ. ಕಂಟೆಸ್ಟ್ ಹಿಂಗ ಇದಾಯ್ತು, ಸೂಟ್ ಆಯ್ತಾ? ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಸೂಟ್ ಆಗಿ ಕಂಟೆಸ್ಟ್ ಅದು ಆಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ರು.
ಹಾ.
ಬಟ್ ದಟ್ ವಾಸ್ ನಾಟ್ ಕನ್ವರ್ಟೆಡ್ ಇನ್ ಟು ಸೂಟ್. ಅದು ಪ್ರೊಬೇಟ್ ಆದ್ರೆ ಕನ್ವರ್ಟ್ ಮಾಡ್ತಾರೆ.
ಹ್ಮ್
This is succession certificate in respect of mutual funds and shares of wife.
ಹ್ಮ್
Not parents of the wife filed objection and sought for claim. Not the trial court relied upon section 15 clause 2,
ಪಿಟಿಷನ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಹಸ್ಬೆಂಡ್.
husband.
ಹಾ
15 clause 2 rely ಮಾಡಿ, it goes to the parents answer. 15 clause 1, husband is the first heir.
Appellant counsel is directed to produce the order sheet for having paid the court fee, both in the trial court as well as in the appellate court, to verify the valuation and payment of court fee. ಇವ್ರು ಏನಾರು ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಹಾಕಿದಾರೆ ಎಷ್ಟು ಕೊಡ್ಬೇಕು ನೀವು ಅಂತ ಏನಾರು?
ಅವರು the office is quoting a section which I do not find in relevant ಅಂತ ನನಗೆ ಕಾಣುತ್ತೆ.
ಆರ್ಟಿಕಲ್ ಆಯ್ತು.
ಹಾ.
And list this matter on 12/7. 2 ವಾರದಲ್ಲಿ ಆಗುತ್ತಾ? 12/7.
35.
Please.
Shankar Reddy.
Shankar Reddy, dismissal of appeal in view of non-compliance of office
In this
objection.
case, my lord.
Non-arraying of defendant number 4.
My
Apply
lord.
ಮಾಡಿದೀರಾ?
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ my lord?
ಹಾ.
This appellant filed FDP, it came to be allowed, and defendant number 8 in FDP challenged by filing RA. ಆ RAದಲ್ಲಿ ಅವರು ಬಂದು defendant number 4 ನ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ.
ಆಲ್ರೆಡಿ ಡಿಸ್ಮಿಸಲ್ ಗೆ ಅಂತ ಇಟ್ಟಿದೀವ್ರಿ, ಕೊಡಿ ನೋಡಿ ಏನದು ಆರ್ಡರ್ ನೋಡಿ.
ಅದು ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ. There is a submission. So that RA came to
At
be.
the request of the learned counsel for the appellants, 1 week time granted to comply with the office objection subject to payment of cost of rupees 1,000 payable to the State Legal Services Authority failing which
Last ಎಲ್ಲ
dismissed ಅಂತ 4/1/24 ಒಂದು
ಕಾಸ್ಟ್
ಆರ್ಡರ್ ಆಗಿದೆ.
ಕಟ್ಟಿದೀವಿ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದ್ವಿ, ಇದು ಫರ್ದರ್ ಅಬ್ಜೆಕ್ಷನ್, ಇದು
ಕಸ್ ಕಟ್ಟಿದ್ರಾ?
ದೇರ್ ಇಸ್ ಅ ಸಬ್ಮಿಷನ್.
ಈಗ ಮತ್ತೆ ಫರ್ದರ್ ಮಾಡಿದಾರ?
ಫರ್ದರ್ ಮಾಡಿರ್ತೀವಿ ಅಷ್ಟೇ.
ಫರ್ದರ್
ಫರ್ದರ್ ಅಲ್ಲಿ
ಮಾಡಿದಾರೆ ಹೊಸದಾಗಿ?
ಎರಡಿದೆ ಸಬ್ಮಿಷನ್, ಎರಡು ಸಬ್ಮಿಷನ್ ನೋಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಹೊಸದಾಗಿ ಮಾಡಿದಾರ ನೋಡಿ. ಇನ್ನು 13 ಇದೆಯಾ?
ದೇರ್ ಇಸ್ ಎ ಸಬ್ಮಿಷನ್.
ಈಗ 15 ಇದೆಯಾ?
ಇಲ್ಲ 15 ಆಗಿದೆ ಸರ್. 15ರಲ್ಲಿ ಈಗ ಬರೀ 3 ಇದೆ.
18 ಇತ್ತು, ಅದರಲ್ಲಿ ಈಗ 13 ಇದೆ. ಹಾ,
ಮಾಡಿದ್ದೀನಿ, ವೆರಿಫೈ ಮಾಡಿ. ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಸಬ್ಮಿಷನ್ ಬೇರೆ ಒಂದು 2 ಅಬ್ಜೆಕ್ಷನ್.
ಫರ್ದರ್ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕಾ? 15 ಇದೆ, ಒಂದಲ್ಲ ಎರಡಲ್ಲ.
ಒಂದೇ
Council again seeks time on verification out of 18 office objections, 15 only complete 3 office objections and remain. One ನಿಮಿಷ. And there are remaining 15 office objections. The council has given submission to 2 office objections, that is.
Is not made party in RA and RFA. Clarifying further. Narayans only died during the pendency of RA. And Sarojamma and Ratnamma were brought on record as appellant number 2 and 3 in RSA. Therefore, they are arraigned as respondent number 3.
The council submission regarding non-arraying of defendant number 4 Narayan Swamy says that he is no more and his LRs are already brought on record as appellants in this appeal. And hence office objection is overruled. Next ಯಾವ್ದು?
ಫಾದರ್ಸ್ ನೇಮ್ ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ.
ಸರೋಜಮ್ಮ ಅಂತ ಮಾಡೋರ appellant number 2 and 3 ಅಂತ ಏನೋ ಹಾಕಿದ್ರಲ್ಲಿ?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
27 2 and 3 ನಾ?
ಕೆಂಪಯ್ಯ ಅಂತ, ಕೆಂಪಯ್ಯ ರಾಂಗ್.
Respond number 2 and 3. Respond number 2 and 3. ಆಯ್ತು, next. And hence office section is overruled. Next.
Father name of the respondent number 27 differs in cost RA and race. Clarifying further.
Elena.
ಕೆಂಪಯ್ಯ ಅನ್ನೋದು ರಾಂಗ್ ಸ್ವಾಮಿ. ಕಂಬಯ್ಯ.
33 is Narasimharaju.
ನರಸಿಂಹರಾಜು.
ಅದು ಕೆಂಪಯ್ಯ ಅಂತ ಅವ್ರ ತಂದೆ ಹೆಸರು ಬಿದ್ದಿದೆ, ಅದು ತಪ್ಪು. ಕಂಬಯ್ಯ ಅಂತ ಮಾಡಿದೆ, ಕರೆಕ್ಷನ್ ಮಾಡಿ.
Shown as Kempaya, which is typo.
The council submission with regard to mentioning of respondent number 33 father name, there is a typographical error and hence the same is accepted and office objection is overruled. Remaining office objections, another 2 weeks time granted on cost of rupees 1000. ಮೊದಲೊಂದು ಸಾವಿರ ಹಾಕಿದಾರ? And further cost of rupees 500 payable at registry. This matter on 12/7. ಅಷ್ಟೊಳಗೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. ಇನ್ನು 13 ಉಳಿದಿದೆ.
36
GB Manjunatha, non-filing appointment for having paid cost, non-compliance of office objections, 4th time.
Pray for 2 weeks time, my lord.
ಮತ್ತೆ ಕೊಡೋದಿಲ್ಲ, ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ ಇಲ್ಲ?
ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ, ಕಟ್ತೀನಿ. ಅದು ಅದ್ರಲ್ಲಿ ನಾನು ಬರೀ
ಪಾಸ್ ಓವರ್
ಅಲ್ಲ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಒಂದೇ ಕೊಡ್ಬೇಕಾಗಿತ್ತು. ಅದರಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ only one objection is there.
Copy of the
Trial court certified copy not filed at the time of filing. Thereafter, we have filed for certified copy, fresh copy. The files were not traced for some time. I will verify and my lord, finally your lordship may grant 2 weeks time, my lord. I will pay the cost and also I will pay this one.
ಈಗಿನ ಕಾಸ್ಟ್ ಕಟ್ ಬನ್ನಿ, ಆಮೇಲೆ ಟೈಮ್ ಕೊಡ್ತೀನಿ ಫರ್ದರ್ ಕಾಸ್ಟ್ ಹಾಕಿ, ಆಯ್ತಾ? ಫಸ್ಟ್ ಈಗ ಕಾಸ್ಟ್ ಕಟ್ಟಿ ಹಾಕಿರೋದ್ನ ನೀವು ಕಾಸ್ಟು ಕಟ್ತಲೇನೆ, ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಲೇನೆ, ಮತ್ತೆ ಟೈಮ್ ಕೊಡ್ಬೇಕು ನಾನು?
ಇಲ್ಲ, ನಾನು ಕಟ್ತೀನಿ. ನಾನು I will undertake to
ಬನ್ನಿ, ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀನಿ. ನೆಕ್ಸ್ಟ್, acceptance of cost paid to the so and so ಮಾಡಿದಾರಾ? ಅಕ್ಸೆಪ್ಟೆಡ್. ಏನ್ ಲೇಟ್ ಆಗಿ ಕಟ್ಟಿರ್ಬೇಕು, ಬೇರೆ ಕಡೆ ಕಟ್ಟಿದೀರಾ?
Instead of Karnataka High Court Clerks Benevolent Fund, it has been paid to Advocates Clerks Welfare Fund. That's state level High Court state level clerk association ಗೆ ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಯಾರಿಗೆ ಕಟ್ಟಿದಿರಿ ನೀವೀಗ?
ಅದೇ ಸ್ಟೇಟ್ ಲೆವೆಲ್ ಅಡ್ವೊಕೇಟ್ ಕ್ಲರ್ಕ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ಗೆ ಕಟ್ಟಿದೀವಿ.
ಮತ್ತೆ ಇನ್ನೊಂದ್ ಬೇರೆ ಇದೆಯಾ ಸ್ಟೇಟ್?
ಇಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಅದು ಬೇರೆ.
ಆಯ್ತು, ಅಕ್ಸೆಪ್ಟೆಡ್. ನೆಕ್ಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಹೇಳಿ.
ಕಂಪ್ಲೇಂಟ್ಸ್ we filed the application, my lords, respond number 5 my lords.
ಆಯ್ತು, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದಿರಾ? ಬರೀ ಕಾಸ್ಟ್ ಕಟ್ಟಿದಿರಾ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದಿರಾ? ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ compliance ಮಾಡಿ.
ತೊಗೊಳ್ಳಿ.
I'll be making the complaints today itself. my lord.
ಏನದು ಆಫೀಸ್
Still-
ಅಬ್ಜೆಕ್ಷನ್ಸ್?
Proof of withdrawal, but to be filed and necessary LR application with respect to respondent number 5 to 7 to be filed.
ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ ಈಗ
ನಮ್ಗೆ
ಡೇಟು?
ಗೊತ್ತಿರಲ್ಲ.
ಡೇಟ್ ಗೊತ್ತಿಲ್ಲ. ವೆರಿಫೈ ಮಾಡಿ ತೊಗೊಳ್ಳಿ. Another 2 weeks time granted to comply with office objections and further cost of rupees 500 payable to the registry. ಯಾವ ವೆಲ್ಫೇರ್ ಫಂಡು ಇಲ್ಲ, ಆಯ್ತಾ? ನೀವುಗಳ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ, ಮತ್ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ಸ್ ಕ್ಲರ್ಕ್ಸ್ ವೆಲ್ಫೇರ್ ಫಂಡಿಗೆನೆ ದುಡ್ಡು ಕಟ್ಟಿಸ್ಕೊಳ್ಳೋದು. ಹೆಂಗಿದೆ ನೋಡಿ. ಕಾಸ್ಟ್ ಹಾಕದೆ ಉದ್ದೇಶ ಅಡ್ವೊಕೇಟ್ಸ್ ಕೆಲಸ ಮಾಡಿಲ್ಲ ಅಂತ. ಮತ್ತೆ ಅಡ್ವೊಕೇಟ್ಸ್ ವೆಲ್ಫೇರ್ ಫಂಡ್, ಅಡ್ವೊಕೇಟ್ಸ್ ಲೈಬ್ರರಿ, ಅಡ್ವೊಕೇಟ್ಸ್ ಇನ್ನೊಂದೇನೋ ಕ್ಲರ್ಕ್ಸ್ ವೆಲ್ಫೇರ್ ಫಂಡ್. ಆಯ್ತು, ರಿಜಿಸ್ಟ್ರಿ ಕಟ್ಟಿ.
Like,
This matter on 12/7.
38 Vasantappa.
Non-furnishing of process fee to issue notice to the respondent first time.
Complaint file
ಯಾವಾಗ ಮೇಡಮ್?
today.
Bringing LRs of deceased R5. ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
Notice ಆಗಿತ್ತು ಅದು.
ಆಗಿದ್ದಕ್ಕೆ PFA ಕೊಟ್ಟಿಲ್ವಾ?
PF
PF ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ?
31/5/23.
23 ಅಲ್ಲಿ.
PF paid my lord.
ಹಾ?
Today sir.
ಯಾವಾಗ?
Today.
ಇವತ್ತು ಕೊಟ್ರೇನು? 1 ವರ್ಷದಿಂದ ಏನ್ ಮಾಡಿದ್ರಿ? ತೊಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಪೇಡ್ ದಿ ಎಲ್ಲಿದೆ ಅಕ್ಲಾನ್ಮೆಂಟ್ ಇವತ್ತು ಕೊಟ್ಟಿದ್ದಕ್ಕೆ? Submit that PF paid today in the office and hence issue notice. And IA 3 of 22 against the LRs of R5, yeah? R5, holy good, photo. Non-compliance of office objection second time. V. Rajaram. Counsel is object into 2 weeks time granted to comply with office objections. Next,
40
along with office note. Office note ಏನಿದು ನೋಡಿ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಯಾಕೆ ಮಾಡಿಲ್ಲ?
39 ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
39 ಆಯ್ತು. 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ ಮಾಡಿ.
40 ನಾರಾಯಣ ಸ್ವಾಮಿ.
ನಾರಾಯಣ ಸ್ವಾಮಿ PM. Appellant counsel absent. ಏನ್ ನೋಟ್ ಏನ್ ನೋಡ್ರಿ. Given 2 weeks time to comply with office objections. Office note ಏನು?
In this connection, it is hereby submitted that the plaintiff and to in OA, in respondent by 1 and 2 in OA mark, however, had death status not reflected in claim statement. And there are death proof also not filed.
ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬೇಕು ಯಾಕೆ ಅಂತ. ಅದು ಕಂಪ್ಲೇಂಟ್ಸ್ ಇರೋದು. ಆಯ್ತು. 2 weeks time granted. ಆ ನೋಟ್ ಹಾಕ್ಬೇಕಿತ್ತು ಅವರು. 2 weeks time granted finally to comply with office objections. List this matter on 12/7.
41
Non-compliance of office objection SC Partha Sarathi. First time ಯಾವಾಗ? 21.
ಅರ್ಜಿ ಮುಂದೆ ಒಂದು 2-3 ಸತಿ ಹೋಗಿದೆ.
ಅರ್ಜಿ 2-3 ಸಲ. ಆಮೇಲೆ
ಕೋರ್ಟ್ ಮುಂದೆ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದೆ, ಸೆಕೆಂಡ್ ಟೈಮ್.
ಇದು ಸೆಕೆಂಡ್ ಟೈಮ್.
ಸೆಕೆಂಡ್ ಟೈಮ್.
Told. Though this matter listed before the RJ for non-compliance thrice and also listed first time before, listed before the court, not yet complied, the office objections. And hence another 2 weeks time granted finally to comply with office objections. List this matter on 12/7.
42
Non-compliance for 4th time.
And I am filing a memo, kindly permit you to withdraw the appeal.
Memo ಹೇಳ್ರಿ, ಏನ್ ಬರ್ದಿದ್ದೀರಿ?
The conducted matter, RSA.
Counsel appearing for the appellant files memo, seeking permission of this court to withdraw the petition. Final decree ಆಗ್ಲೇ ಆಗೋಗಿದ್ಯಾ? Already division of property was taken place between the parties in the final decree proceedings. In view of the memo permitted to withdraw.
43
43, Prasanna VR, complaints of office objections. Yes, sir, list ಆಗಿದೆ madam.
My lord, this sole appellant died, my lord, on 1/6/2024. I am filing the memo on that.
The counsel for the appellant files memo reporting the death of sole appellant. ಏನ್ ಮಾಡ್ಬೇಕು? Bring ತರ್ತೀರಾ LRs ನ ಅಥವಾ ಏನು?
Instruction ಬಂದಿಲ್ಲ, ಫೋನ್ ಮಾಡಿದ್ವಿ, ಟೆಲಿಫೋನ್ ರಿಸೀವ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಯಾರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ರಿ?
ಅವರ ನಂಬರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ವಿ, ಅಪಲೆಂಟ್ ನಂಬರಿಗೆ, ಬಟ್
ಅಪಲೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರಲ್ಲ ನಿಮ್ ಪ್ರಕಾರ. ತೀರ್ಕೊಂಡಿದ್ದ
ಫೋನ್ ಇತ್ತು, ಫೋನ್ ರಿಂಗ್ ಆಗ್ತಾ ಇತ್ತು.
ತೀರ್ಕೊಂಡವ್ರ ಹೆಂಗ್ ಫೋನ್ ಎತ್ಕೋತಾರ ಮೇಡಮ್?
ಬಟ್ ಅವ್ರ ಮನೆಯವ್ರು ಯಾರು ತಗೊಂಡಿಲ್ಲ.
ಮತ್ ನಿಮ್ಗೆ ಹೇಳ್ದವ್ರ ಯಾರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ?
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಪೇಪರ್ ಅಲ್ಲಿ ಬಂದಿತ್ತು, ಗಣೇಶ್ ಕಾಜ್ವಾ ಡೈಡ್ ಆನ್ 1/6/2024.
ಪೇಪರ್ ನೋಡಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? ಆಯ್ತು ನೋಡ, ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡ್. ಏನಾಯ್ತು ಮೇಡಮ್? Reporting the death of the appellant on 1/6/24 and no instructions in the above case. However, in the ends of justice, in order to bring the LR sub sole appellant, another 4 weeks time granted. If no steps taken in the state of hearing, appeal will be dismissed for non-prosecution. List this matter, and the appeal will be dismissed as abated. List this matter on 27th of next madam. 27th ಅಲ್ಲ, ರಜಾ ಬಂದ್ಬಿಡುತ್ತೆ. 29th. 29/7. ನೋಡಿ ಅಷ್ಟೊಳಗೆ ಇನ್ನೂ ಏನಾದ್ರು ಎಫರ್ಟ್ ಹಾಕಂಗಿದ್ರೆ ಹಾಕಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. ತಿರುಮಲೇಶ್ವರ ಭಟ್ ಕೇಸ್ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ 4th time. ಹಾ,
Your Honor, the initially the case filed for money recovery suit of 5 lakhs. Subsequently, it's a decreed.
subject 8 ಇದೆ ತೊಗೊಳ್ಳಿ. Another 4 weeks time granted for complaints of office objections on cost of ₹500 payable at registry. If not complied and cost not paid, appeal is dismissed without reference to the bench.
Is court
ಕೊಟ್ಟಿದೀವಿ ನೋಡಿ.
ಕೋರ್ಟ್ ಫೀ ಇಲ್ಲೇ ಹೇಳ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ ಅದಕ್ಕೆ
ಕೋರ್ಟ್ ಫೀ
ಇಲ್ಲೇ ಕ್ಲಾರಿಫೈ ಆಗ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ ನಾವು ಅಲ್ಲಿ ಹೋಗಿರ್ಬೇಕಾದ್ರೆ ಆಕ್ಚುಲಿ ಡಿಕ್ರೀಡ್ ಫಾರ್ ಓನ್ಲಿ 1,41,000 ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ಫಸ್ಟ್ ಅಪಿಯಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೂಡ ನಾವು ಅದರ ಮೇಲೆ ಕೋರ್ಟ್ ಫೀ ಕಟ್ಟಿದೀವಿ.
ಡಿಕ್ರಿನಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ರೆ ಇಲ್ಲ, ಡಿಕ್ರಿನಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಟ್ರೆ ಇಲ್ರಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಕೊಟ್ಟಾರ ಸರ್. ಪೇಜ್ ನಂಬರ್ 47.
at the rate of 18% interest ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ ಅದ್ರ ಮೇಲೂ ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟಿದ್ರ ಟ್ರಯಲ್ ಅಪಲೇಟ್
ಡಿಕ್ರಿ ಅಮೌಂಟ್ ಮೇಲೆ ಕಟ್ಟಿದ್ವಿ. ಡಿಕ್ರಿ ಅಮೌಂಟ್ ಮೇಲೆ ಅಷ್ಟೇ ಕಟ್ಟಿದ್ವಿ.
ಡಿಕ್ರಿ ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಎರಡು ಕೊಡ್ಬೇಕು. ಯು ಆರ್ ಚಾಲೆಂಜಿಂಗ್ ದಿ ಸೇಮ್ ಅಲ್ವಾ? ಅಲ್ಲೆಷ್ಟು ಕೊಟ್ರೆ ಇಲ್ಲೆಷ್ಟು ಕೊಟ್ರೆ ಹೇಳಿ.
ಅಲ್ಲಿ ನಾವು 9,400 ಟ್ರಯಲ್ ಇದು ಫಸ್ಟ್ ಅಪಲೇಟ್ ಅಲ್ಲಿ 9,400
47,985 ಇದೆ.
ಅದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಅಪಲೇಟ್ ಅಲ್ಲಿ
ಟೋಟಲ್ ಎಷ್ಟು ಕೊಟ್ರಿ?
9,495.
9,000 ಹೆಂಗ್ ಕೊಡ್ತೀರಿ?
ಹೌದು, 9,495 ಕಟ್ಟಿದ್ವಿ.
ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್ ಗೆ
ಅಲ್ಲಿನೂ ಅದು ಮತ್ತೆ ಕ್ಲಾರಿಫೈ ಆಗಿತ್ತು.
ಅಪೀಲ್ ಅಥವಾ ಯಾರ್ದು ಇದು ಅಪೀಲ್?
ಮನಿ ರಿಕವರಿ
ಡಿಫೆಂಡೆಂಟ್ಸ್ ಅಪೀಲ್ ಅಲ್ವಾ?
ಹೌದು.
ಹಾ,
ಇವಾಗ ಫಸ್ಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅದು ಕ್ಲಾರಿಫೈ ಆಗಿ 9,495 ಕನ್ಫರ್ಮ್ ಆಯ್ತು. The same amount we have paid here also, second appeal.
ನೋಡ್ರಿ, ಉದಯ್ ಕುಮಾರ್, ಸಾವಿತ್ರಮ್ಮ ರೆಗ್ಯುಲರ್ ಅಪೀಲ್ ಡಿಫೆಂಡೆಂಟ್ ಹಾಕಿರೋದು 47,000 ಕಟ್ಟಿದ್ದಾರೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 9,000 ಹೆಂಗ್ ಬರುತ್ತೆ?
ಅದು ಅವರು ನಾವೆಲ್ಲ ಕಟ್ಟಿದ್ದು ಪ್ಲೆಂಟಿಫ್, ನಾವು ಡಿಪೆಂಡೆಂಟ್.
ಪ್ಲೆಂಟಿಫ್ ಎಷ್ಟು ಕ್ಲೈಮ್
ಅದು ಅಲ್ಲಿ ಡಿಗ್ರಿ ಆಗಿರೋದೇ ಅದಲ್ಲಿ ನಾವು
ಆಯ್ತ್ರಿ. 1,41,000 ಮೇಲೆ 18% ಇಂಟ್ರೆಸ್ಟ್ ಅದನ್ನ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದಾಗ ಕೋರ್ಟ್ ಫೀ ಎಷ್ಟು ಬಂತು ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದಿರೋದು ಅಂಡ್ ಕನ್ಫರ್ಮ್ಡ್ 9,495.
9,495.
ಹೌದು.
ಈಗ ಎಷ್ಟು ಕಟ್ಟಿದಿರಿ ಇಲ್ಲಿ?
ಈಗ ನಾವು ಇಲ್ಲಿ ಅದನ್ನೇ ಕಟ್ಟಿದೀವಿ. ಅಗೇನ್
ಅದೇ ಕಟ್ಟಿದಿರಾ?
ಹೌದು.
ಕನ್ಫರ್ಮ್ ಅಂತಿದೆಯಲ್ಲ. ಇವ್ರದೇನು ಆಫೀಸ್ ಅಬ್ಸೆನ್ಸ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದಾರ ಮೇಡಮ್?
ಮಾಡಿಲ್ಲ ಸರ್.
ನೋಡಿ, regarding court fee is concerned, office is directed to calculate the court fee and make a note. And remaining office objections, 2 weeks time granted. List this matter on 12/7 without reference in beda. 45 Gurudatta K non-compliance of office objection on 1/23 for second time. Second time non-compliance. ಏನು IA ಏನದು? IA 1/23.
IA 1 for ಇದು ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಮತ್ತೆ ಇದು
ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಎಷ್ಟು ಸರಿ ಬರ್ಬೇಕು ಕಂಪ್ಲೇಂಟ್ಸ್ ಗೆ?
ಫಸ್ಟ್
ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ನೋಡಿ ಮೇಡಮ್. ಹಾ, ಮತ್ತೆ ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ ಇದೆ.
ಇಲ್ಲ ಸರ್, ಇಲ್ಲ ಕ್ಲಾರಿಫೈ ಮಾಡ್ತೀನಿ ಸರ್.
Not pressed by counsel since ISR filed for the same relief.
ಹೌದು, ಯಾಕೆಂದ್ರೆ RN ಅಲ್ಲೇ ಮಾಡಿರಲ್ಲ ನಾವು.
2 IA ಇದೆ ಮೇಡಮ್.
3 ಇದೆ.
17/4/23 2 days time granted to comply with office objections.
ಎರಡು ಹಾಕಿದ್ದಾರೆ ಸರ್. IA 1/23 ಅದು ಮತ್ತೆ IA 4/23 ಎರಡು ಒಂದೇ.
ಈಗೇನ್ ಅದಕ್ಕೆ ಹಾಕಿದಾರ ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ ನೋಡಿ, ನೋಟ್ ಕೊಟ್ಟಿದಾರ ನೋಡಿ. ಮತ್ತೆ ಯಾಕೆ ಬಂತಿದ್ದು ನಿಮ್ಗೆ? ಇದು ಏನು ಟು ಬಿ ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತ ಇವ್ರ ಆಫೀಸ್ನವ್ರು ನೋಟ್ ಮಾಡಿರೋದ? ನೋಡ್ರಿ ಅದೇನು ಟೈಮ್ ಗ್ರಾಂಟೆಡ್ ಟು ಕಂಪ್ಲೈ ವಿತ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 5/7 ಅಷ್ಟೊಳಗೆ ನೋಡಿ.
ಸರಿ.
ಗಿರಿಕುಮಾರ್ SV, 4th time compliance of office objection raised on IA 1 of 24.
3 weeks time.
Huh?
3 weeks time.
3 weeks. Appellant counsel seeks 3 weeks time. And matter is listed for 4th time for non-compliance. And hence 2 weeks time granted on cost of rupees 500 payable at registry. If cost not paid and not complied within 2 weeks, appeal is dismissed without reference to the bench.
47.
Chandraya HS.
For appellant, my lord.
Yes, madam.
Cost is paid, my lord.
Yavaga.
Ivattu, my lord.
Counsel submit that he has paid the cost today in the office.
Press-
Yes, compliance.
Phrase a week time, my lord.
And counsel again 6 weeks time to comply with office objection, and hence on further cost of rupees 500, another 2 weeks time granted to comply with office objection. This matter on 12/7.
48. Dilip Kumar.
My lord, press 2 weeks of time, my
Paid
lord.
the cost.
Cost has been paid.
Yavaga.
ಬೆಳಿಗ್ಗೆ file.
Compliance ಹೇಳ್ರಿ.
2 weeks ಅಲ್ಲಿ complete.
I am not sitting here only for ಇದು ಕಾಸ್ಟ್ ಹಾಕೋ ಉದ್ದೇಶ ಅಟ್ಲೀಸ್ಟ್ ಕಂಪ್ಲೈ ಮಾಡ್ತೀರಿ ಅಂತ ಹಾಕೋದು. ಕಾಸ್ಟ್ ಕಟ್ಬಿಟ್ಟು ಬಂದು ನಿಂತ್ಕೊಂಡ್ಬಿಡ್ತೀರಿ ಕೋರ್ಟ್ ಮುಂದೆ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ.
2 weeks ಅಲ್ಲಿ ಮಾಡಿ.
ಹಾ?
2 weeks ಅಲ್ಲಿ.
Submit that he has paid the cost and again 2 weeks time, and on further cost of rupees 500, another 2 weeks time granted. If cost not paid and not complied with office objection, appeal is dismissed without reference to the bench. ಇನ್ನೇನ್ ಮಾಡಕ್ಕಲ್ಲ, ವಿತೌಟ್ ರೆಫರೆನ್ಸ್ ಟು ದ ಬೆಂಚ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಸರಿ ಆಗುತ್ತೆ.
49. Nagraj.
ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ನಾಗರಾಜ್ ಎನ್ ಇಲ್ವಾ? ಸೇಮ್ ಆರ್ಡರ್ ವಿತೌಟ್ ರೆಫರೆನ್ಸ್ ಟು ದ ಬೆಂಚ್. ನೆಕ್ಸ್ಟ್ ಕಾಸ್ಟ್ ಹಾಕಿದೀವಲ್ಲ ಮೇಡಮ್,
Cost ಇದೆ.
ಕಾಸ್ಟ್ ಕಟ್ಟೇ ಇಲ್ಲ ತಗೊಳ್ಳಿ.
Cost ಕಟ್ಟಿಲ್ಲ.
ಹಾಗಾದ್ರೆ ಕಟ್ಟಿಲ್ಲಲ್ಲ?
ಕಟ್ಟಿಲ್ಲ.
Appellant counsel is absent and also not paid cost and not complied with office objection, and hence appeal is dismissed for non-compliance and non-payment of cost. Next 50. Non-compliance of office objection 4th time. Naeem Pasha. Ilva? Appellant counsel is absent and in spite of matter listed 4th time for compliance not complied. ಹಾಕಿದಾರ ಕಾಸ್ಟ್ ನೋಡಿ, ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರ? ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರಾ? ಕಾಸ್ಟ್ ಕಟ್ಟಿದಾರೆ. ಇನ್ನು ಒಂದಿದೆ, ಏನದ ಒಂದಿರೋದು ಏನು? Appellant counsel is absent and listed for 4th time for non-compliance, but he paid the cost, and there one more office objection remains, and hence on further cost of rupees 500, another 2 weeks time granted.
51.
This matter on 12/7.
51.
Lordship, payment of cost has been made.
Hmm.
There's one office objection pending.
Hmm.
I seek for 2 weeks time, my lordship.
Hmm?
Seek for 2 weeks time. Certified copy apply ಮಾಡಿದೀವಿ. You're not able to get it. We need another 2 weeks time.
Counsel submits that she has paid the cost, any receipt cost ಕಟ್ಟಿದ್ದು.
ಬೆಳಿಗ್ಗೆ ಕಟ್ಟಿತ್ತು.
And again seeks 2 weeks time to pay the PF.
Memo
ಅಲ್ಲ,
file
to
ಮಾಡಿದ್ದಾರೆ.
comply with office objection, and
ಇವತ್ತು ಬೆಳಿಗ್ಗೆ.
hence 2 weeks time granted on further cost of rupees 500 payable at registry. If cost not paid and not complied with office objections, appeal is dismissed without reference to the bench.
52.
Non-compliance of office objection.
My lord.
6th time.
My lord, today morning I have deposited the cost. My lord, the only objection is the name of a third appellant, my lord, does not tally in tally. I have filed IA number 1 of 23 seeking permission to amend it, my lord. That is also put up with there was some misdescription.
Yeah, 1,000 ಕಾಸ್ಟ್ ಆಗಿದೆ, ಕಟ್ಟಿದೀರಾ?
ಕಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಬೆಳಿಗ್ಗೆನೆ ಕಟ್ಟಿದ್ದೀನಿ.
ಬೆಳಗ್ಗೆ.
ಹೌದು.
ಎಲ್ಲಿದೆ receipt?
ಇಲ್ಲಿದೆ ಸ್ವಾಮಿ.
ತಗೊಳ್ಳಿ. Appellant counsel submits that he has paid the cost of rupees 1,000 today in the morning. Next. ಈಗೇನ್ ವಕಾಲತ್ತು to that of IA to clarify along with.
I have filed IA number 1 of 23, man.
ಏನಕ್ಕದು?
ಅದು ಹೆಸರು
Details of appellant number 3 does not
ಹೌದು.
tally to cost.
Only to clarify that, my lord.
ಯಾಕೆ ಅವ್ನು ಇಲ್ವಾ?
ಅಲ್ಲ, ಅದು ಬರಿತಾ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗಿದೆ, ಮದರ್ ಅಂತ ಹೋಗಿದೆ. ಇಫ್ ಐ ಆಮ್ ಪರ್ಮಿಟೆಡ್ ಅಲ್ಲಿ
ಏನ್ ಬರೀತಾ?
ಬರೀ ಸ್ಟೆಪ್ ಬ್ರದರ್ ಅದು, ಇದು ಮದರ್ ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅಲ್ಲಿ, ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲೇ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ.
ಹೌದು, ಹೌದು.
ಏನಂತ?
ಆ,
1/23 ಕೊಡಿ ಮೇಡಮ್. ಅವ್ರು ಹೇಳಲ್ಲ, ನಾವೇ ಓದ್ಕೊಳ್ಳೋಣ ನೆಟ್ಟಿಗೆ. 1/23 ಕೊಡಿ.
I have sought amendment to correct the name of third appellant, my lord, description.
Appellant ಈಗ ಆಲ್ರೆಡಿ ಏನಂತ ಹೇಳಿದಿರಿ?
G Prem Kumar ಅಂತಿದೆ, represented by minor elder brother first appellant ಅಂತ ಆಗ್ಬೇಕು. ಅದು ಬೈ ಮಿಸ್ಟೇಕ್ ಮದರ್ ಅಂತ ಆಗಿದೆ. ಅಪೀಲ್ ಮೆಮೊ ಮತ್ತೆ ಐಎಗಳಲ್ಲಿ.
In the manner indicated here under and grant such other G Prem Kumar ಅಂತಿದೆ, son of late ಗುರುಸಿದ್ದಪ್ಪ ಅಂತಿದೆ. ಹಾ. ಆಯ್ತು ಆಯ್ತು. ಟು ಕ್ಲಾರಿಫೈ ಅಂತಿದೆ.
ಹೌದು, ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು.
ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಂತ ಮಾಡಿದ್ರಿ ಅಪ್ಲೆಂಟ್ ನಂಬರ್ 3ಗೆ?
ಅಪ್ಲೆಂಟ್ ನಂಬರ್ 3ಗೆ ನೇಮ್ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ.
ಪ್ರೇಮ್ ಕುಮಾರ್ ಅಂತಿದೆ.
ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಮದರ್ ಅಂಡ್ ನ್ಯಾಚುರಲ್ ಗಾರ್ಡಿಯನ್ ಸೆಕೆಂಡ್ ಅಪ್ಲೆಂಟ್ ಅಂತ ಆಗಿದೆ.
ರೆಪ್ರೆಸೆಂಟೆಡ್ ಬೈ ಹಿಸ್
ಈಗ
ಮದರ್
ಬ್ರದರ್ ಅಂಡ್ ಗಾರ್ಡಿಯನ್ ಫಸ್ಟ್ ಅಪ್ಲೆಂಟ್ ಅಂತ ಆಗ್ಬೇಕು.
ಅಂತಿದೆ.
ಹೌದು, ಈಗ ಫಸ್ಟ್ ಅಪ್ಲೆಂಟ್ ಅಂತ ಆಗ್ಬೇಕು.
ಎಲ್ಡರ್ ಬ್ರದರ್ ಅಂತ ಮಾಡಿದಿರಿ ಈಗ?
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು.
ಯಾಕೆ ಮದರ್ ಬೇಡವಾ?
ಮದರ್ ಸ್ವಲ್ಪ ಅವರಿಗೆ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲ, ಅವರು ಬರೀಲಿಕ್ಕೂ ಆಗ್ತಾ ಇಲ್ಲ, ಹಾಗಾಗಿ ಮೊದ್ಲಿಂದಾನೇ ಇವರೇ ಇದ್ ಮಾಡ್ತಿದ್ರು, ಹಾಕಿದ್ರು ಸ್ವಾಮಿ.
ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ಸ್ ಕೇಳಿದಿರಿ?
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು.
ವರ್ಡ್ ಆನ್ ಐ ನಂಬರ್ 2 of ಯಾವ್ದು 1/23 wherein prayed this court to amend the cast title of the appeal memorandum. Earlier it was mentioned being minor represented by his mother, and the same has to be amended as brother.
First appellant.
That is first appellant G Sunil Kumar, and for the reasons stated in the accompanying application of Probate, IA is allowed and permitted to amend the same. ಅದೊಂದೇ ನನಗೆ ಆಫೀಸ್
ಅದೊಂದೇ. ಅದು ವಕಾಲತ್ತು
and appellant counsel is directed to amend the cast title
of IAS also.
and also file amended copy and IAS
Yes,
within 2 weeks.
highly updated.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಗಾರ್ಡಿಯನ್ ಇದೇ ಸಂಬಂಧಪಟ್ಟಿದೆ.
ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅದಕ್ಕೆ. ಐ ನಂಬರ್ 2 ಇದೆ.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕೇಳಿದಿರಾ?
ಕೇಳಿದ್ದೇನೆ. ಐ ನಂಬರ್ 2 ಇದೆ.
2 of
ಅದ್ರಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಕೇಳಿದೆ.
ಮದರ್ ಕೇಳಿದಾರೇನಾ?
ಇಲ್ಲ, ಬ್ರದರೇ ಕೇಳಿದ್ರು.
ಬ್ರದರೇ ಕೇಳಿದಿರಿ?
ಹಾ ಹಾ.
ನೋಡಿ. Heard the appellant counsel on IA number 2 of 21 wherein prayer is made to pass an order appointing the first appellant as a guardian.
ಹೌದು ಸ್ವಾಮಿ.
First appellant Sunil Kumar as the next friend of the minor appellant number 3, Master G Prem Kumar. And in lieu of the permission granted by this court while allowing IA number 1 of 23. And for the reasons stated in the accompanying application of Probate, the third appellant being the minor has to represent through next friend. Hence, IA is allowed.
Public.
Post the matter for admission,
Yes.
Post the matter for admission on 12/7.
53
non-filing of paper book.
2 weeks, my lord, sir, type.
23
Final 2 weeks, my lord.
ಬಂದಿಲ್ವಾ?
ಅದಾದ್ಮೇಲೆ ಬಂದಿಲ್ಲ ಸರ್.
ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ಲ.
4 weeks time granted
Please.
finally to file paper book.
Oblige.
54
Memorandum of compromise petition by counsel for appellant along with note. ಏನ್ರಿ ಅದು?
Complaint ಮಾಡಿ.
Compromise said.
ಪಾರ್ಟೀಸ್ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ ಮಂಡ್ಯಾಗ.
ಏನ್ ಮಾಡ್ಬೇಕೀಗ?
ಮಂಡ್ಯಾಗ ಸ್ವಾಮಿ.
ಹಾ?
ಮಂಡ್ಯ ಕೇಳಿ.
ಪಾರ್ಟೀಸ್ ಬಂದಿದ್ದಾರೆ ಅಂತೀರಿ?
ಇಲ್ಲ ಬಂದಿಲ್ಲ.
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 ಆಯ್ತು. ಮಂಡ್ಯಕ್ಕೆ ಬರ್ತಾರಾ?
ಹಾ ಬರ್ತಾರೆ, ರೆಸ್ಪಾಂಡ್ ಕೌನ್ಸಿಲ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
This matter on Monday ಗೆ date ಕೊಡಿ ಮೇಡಮ್. 1st of July.
ಅಚ್ಚಾ.
As prayed.
55
non-filing of copy subjection second time. Mohan Chandra.
In course of the day will do, my lords. Permitted to comply.
Council's
Course of the day.
permission of this court that he is going to comply with office subjection during the course of the day and permitted to comply the same.
Obliged.
56
Sadanand Sastri.
Beg to appear for the appellant, my lord. Submission in the Swami. Delivery warrant has been issued against me. I'll definitely comply with office objections. at the
Definitely
earliest.
ಬೇಡ. ಏನ್ ಹೇಳಿ office subjections ಎಷ್ಟಿದೆ ಹೇಳಿ?
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇದೆ ಸ್ವಾಮಿ ಇದು.
13.
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಐ ಆಮ್ ಅ ಟೆನೆಂಟ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಿಮೈಸಸ್ my lord. ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿದೆ ಈ ಮ್ಯಾಟರ್ ಅನ್ನ. ಮೈ ಪೊಸಿಷನ್ ಇಸ್ ಅಂಡರ್ ಥ್ರೆಟ್. Concurrent findings by the trial court.
ಹಾಕಿರೋದು possession petition 2018.
ಹೌದು ಸ್ವಾಮಿ.
You are not disputing the fact that you are a tenant.
No, my lord. Now what has happened?
You are not the tenant?
No, I am the tenant. However, my lord, The owner,
Landlord and defendant is tenant under them in suit scheduled property. Proves that the tenancy is lawful terminated, whether the plaintiff is entitled for the vacant portion of suit scheduled property as sought. ಹೇಳಿ ಏನದು ಹೇಳಿ.
no, my lord, certain substantial questions I have invoked before this honorable
ಏನ್
court.
substantive question
ಅಲ್ಲ,
ಅಲ್ಲ, whether
there is no jural relationship
Did
of
you-
landlord and tenant. ಯಾಕಂದ್ರೆ
admit ಮಾಡಿದಿರಾ ಇಲ್ಲ?
ಅಲ್ಲ, no, the owner himself, that is the Bandarkars College, my lord, they were issued with a notice from the state government stating that you are in illegal possession of the property. Actually, what has happened, my lord, they were only in permissive possession and they have been given some authorization to construct some wells and to make playgrounds. In that particular portion, my lord, now they have built certain commercial complex, all of 100 and 200 square feet. ನಾನು 200 square feet ಅಲ್ಲಿ ರೆಫ್ರಿಜರೇಟರ್ AC ಇದನ್ನ ಸರ್ವಿಸ್ ಮಾಡಂತ ಒಂದು ಪರ್ಸನ್, my lord, for 2,400 rupees as rent. Now what has happened is, my lord, this Bandark
2,400
rupees ಅಷ್ಟೇನೆ.
ಏನದು?
ಅಲ್ಲ, that is my monthly rent, my lord.
Monthly rent.
Rent. Owner actually is the state government. Falsely they state that they are the owner of the property and give
You
the
are paying the rent to whom?
to respondent, my lord.
Respondent payment ಕೊಟ್ಟಿದ್ಮೇಲೆ ಮತ್ತೆ now how you can dispute that you are not?
Now that is what, my lord, both the courts under 116A of the Evidence Act, my lord, they say that law of estoppel comes into effect. Our, my lord, my contention before this honorable court is that section 10 of the Contract Act should apply, my lord. So basically fraud, coercion, undue influence and misrepresentation by the respondent college that they are the owner of the property. Only upon such implicit trust on the college, my lord, I have entered into.
To whom you are paying rent?
I am paying rent to the respondent, my lord.
Respondent.
Yes.
Then how now you can dispute that you are not a tenant under them?
No, now, my lord, if the owner of the property, my lord, he himself is not the owner, even according to him, he has made a statement before the trial court.
Whatever it may be, counsel, you cannot question the title of the owner.
I'm not questioning the title.
You are admitting that.
I
you
bow
are a
down, my
tenant.
lord. I am not questioning the title. All that I am saying is I am in unauthorized possession of the property ಅಂತಾನೆ ಇಟ್ಕೊಳ್ಳೋಣ. So this
ಇಟ್ಕೊಳ್ಳೋದು ಬೇಡ.
ಅಲ್ಲ.
ನಿಮ್ಮ ಕೇಸ್ ಏನ್ ಸ್ಪೆಸಿಫಿಕ್ ಕೇಸ್ ಏನ್ ಹೇಳಿ.
ಅದೇ now I am in possession of the property, my lord.
It's that you are paying rent to the respondent.
ಅಲ್ಲ, ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಅನ್ನು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅವರು ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಓ, ನೀವ್ ಟೆನೆಂಟ್ ಅಂತ ಅವ್ರ ಜೊತೆಗೆ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ಹೋಗ್ಲಿ ಒಂದ್ ನಿಮಿಷ, ನೀವಂತೂ ಹೇಳ್ತಾ ಇಲ್ಲ, ಸತ್ಯ ಓದ್ಬಿಡೋಣ.
ಇಲ್ಲ ನಾನು ಒಂದ್ಸತಿ
ಇಶ್ಯೂ ನಂಬರ್ 1 ಏನಂತ ರೀಸನಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
kindly, my lord.
In this case, defendant is not disputing the relationship of landlord tenant in between the plaintiff and himself.
Yes.
And then what is there to decide?
ಅಲ್ಲ ಸ್ವಾಮಿ, ನಾವು
Exhibit, he has agreed to execution of exhibit P5 rent agreement.
yes.
It is well settled principle that admitted fact need not be proved, hence in the considered opinion of this court, the plaintiff college is landlord and the defendant is a tenant under it. That's all.
ಹೌದು ಸ್ವಾಮಿ.
Now what is the substantive question of law?
ನಾವು ಒಂದೇ ಒಂದ್ಸತಿ ಅಲ್ಲಿ the total premise on which the trial court has gone is on 116A, my lord. ಒಂದೇ ಒಂದ್ second, I may be permitted to read 116A. 116 of the Indian Evidence Act. Estoppel of a tenant and of licensee of a person in possession. No tenant of immovable property or a person claiming through such tenant shall during the continuancy of the tenancy ಅಂತ ಹೇಳ್ತಾರೆ. So tenancy has been terminated by giving me a legal notice. So now I am in unauthorized possession of the property.
Oh, that is your ground now.
Alala, my owner is not the actual owner, my lord. Because he has stated that he is the owner, there is a breach of trust on their part against me. ನಾನು ಅದನ್ನ ನಂಬ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೀನಿ. All that I am seeking is, my lord.
ನಂಬ್ಕೊಂಡು ಹೋಗೋದನ್ನ ಬೇಡ ಹೇಳಿ.
ಅಲ್ಲ, now even according to the trial court, my lord, if they go on the presumption of 160.
Or dismissed with exemplary cast. Once you admit that you are a tenant under the respondent, now you cannot raise other issues.
Other issues ಅಲ್ಲ ಸ್ವಾಮಿ. ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ, ಈಗ I may be permitted to produce this document, my lord, just for a moment.
Precious time of the court. You are not disputing that you are not a tenant.
Yes, I'm not disputing I am a tenant.
And what is there to decide, counsel? Is it your case that termination is not in accordance with law?
Please, my lord. He has to be a landlord to vacate me from the premises. He is not a landlord. Kindly, one annexure D one produce ಮಾಡ್ತೀನಿ ತಮ್ಮ ಮುಂದೆ.
Counsel, exhibit P5 is the agreement.
Agreement, ಆದ್ರೆ
admitting that you are paying the rent in
he
favor of
sends
the
a
respondent.
true, my lord, he sends a termination notice to me, the respondent, only on the basis of the state government which has told the respondent that you are not the owner of the property. Kindly, my lord, ಇದು ಬಂದಿಲ್ಲ, ತಮ್ಮ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕಾಗಿಲ್ಲ. annexure D ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ. Show cause notice was issued to the respondent stating that the possession given to him was for construction of ಒಂದು ಬಾವಿ, ಒಂದು ಪ್ಲೇ ಗ್ರೌಂಡ್ ಗೆ. ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಕೆಳಗಡೆ ಬರುತ್ತೆ.
ಆಯ್ತು.
Now he has treated me, my lord. ಅವ್ರು ನಮ್ಗೆ ನಾನು ಓನರ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನನಗೆ ಇದು ನಂದು I'm a ಕೂಲಿ ಕಾರ್ಮಿಕ, my lord, 2,000 ರೂಪಾಯಿ.
What is your defense in the return statement? Go to original suit.
Please.
ಯಾಕೆಂದ್ರೆ you are killing the time of the court.
ಅಲ್ಲ, I am seeking only not to take precipitative action, my lord.
Then you have to pay,
ಅಲ್ಲ,
pay the
ನಾನು
exemplary cost, that's all. What is your defense?
please. My defense is that, my lord,
Statement by partly admitting the plaint. The defendant has admitted that the CH-12 premises belong to the plaintiff and has sought the lease of the same from the plaintiff to run his business under name and style of Siddhartha Refrigerations. But he denied the commencement of lease date. In fact, he has taken possession of the CH-12 property in 1997 as the tenant of the same. This is your defense.
yes.
And has been running his business therein. He has been paying the rent regularly to the plaintiff. This is the defense.
Now, my lord, ಈಗ plaintiff,
That the rent was paid rupees 2,400 per month and deposit of rupees 24,000, which is refundable.
now plaintiff sends me a termination notice on behalf of this annexure D, my lord. He is not stating anything else. All that he is stating is,
That's all, counsel.
ಅಲ್ಲ ನಾನೇನ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ ಅಂದ್ರೆ ಐ ಆಮ್ ಪೇಯಿಂಗ್ ರೆಂಟ್ ಆಫ್ 2,400 rupees. I require some protection. See, now,
What protection you are entitled,
ಅಲ್ಲ,
counsel?
legally speaking, my lord, I am not speaking factually now. Legally, if my owner is not in possession of the property at all by himself, he has put me in unauthorized possession of the property. ಅವ್ರಿಗೆ ಅಧಿಕಾರ ಇಲ್ಲ ಸ್ವಾಮಿ ನನ್ಗೆ ಇದನ್ನ ಟೆನೆನ್ಸಿ ಕೊಡಕ್ಕೆ. So I have admitted the document under which I have been put in possession.
ಎಷ್ಟು ವರ್ಷದಿಂದ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಿದ್ದೀರಿ ನೀವು? Even I read your written statement also.
Please.
Hmm.
But none defense is there, Swami. When the owner of the property himself is not in possession of the property, he has committed fraud, coercion, undue influence and misrepresentation to me, stating that you become a tenant under me and he is receiving rents. ಅದನ್ನೇ ನಾನು ಒಪ್ಕೊಂಡಿರೋದು. I am not disputing that I am not a tenant.
Whether the court can decide all these issues once you categorically admitted that the plaintiff is the landlord and you are paying a tenant, paying rent, and you are in possession of the premises as a tenant?
116 ಏನ್ ಹೇಳುತ್ತೆ ಅಂದ್ರೆ, so long as tenancy continues.
So, this matter is listed for admission along with objections of office objections, non-compliance of office objections.
Some protection may be given, Swami, kindly. ಅಲ್ಲ, I am paying honestly rent, ಇದಕ್ಕೆ ರೆಂಟ್ ಕಟ್ಕೊಂಡ್ ಬರ್ತೇನೆ. ಆ ಎಂಟೈರ್ ಏರಿಯಾದಾಗೆ ನಾನು I am doing some AC refrigeration works, repair works, ಅಷ್ಟೇನೆ ಸ್ವಾಮಿ. Now the state government is not against me, my lord, it is their property.
Yes, sir, adne ಹೇಳ್ತಿರ್ರಿ, council allow me to dictate. Heard the appellant counsel, the factual matrix of case of the plaintiff before the trial court, while seeking the relief of possession against the respondent appellant herein, contended that the plaintiff is the trust has constructed the commercial described premises described in the schedule belongs to the plaintiff college. The entire building in the social premises built by the plaintiff college. The defendant sought the lease of the scheduled commercial premises for conducting business in the name and style of Siddhartha Refrigerations. Accordingly agreed to grant the lease of the scheduled premises and both the parties entered into the written agreement of lease dated 37/2016. The said agreement created the landlord and tenant relationship between them in respect of the PSP, Petition Scheduled Premises, PSP. According to the agreement, the defendant put in possession of the scheduled premises and carrying his business therein as monthly tenant. The term of the tenancy was fixed from 1/8/2016 to 30/6/2017. He is liable to pay rupees 2,400 per month. In addition to that, defendant has paid the security deposit of rupees 24,000, which is liable to be refundable to him at the time of the redelivery of the leasehold premises without interest. Now it is decided to stop all commercial operations in the suit building and to evict all tenants occupying the said complex. In view of the directions issued by the Deputy Commissioner Udupi, therefore it has terminated the monthly tenancy of all their tenants and issued notice to termination dated 3/11/2017 to the defendant, but the defendant failed to comply with the demand therein. Further, after receipt of the said termination of notice, defendant started proclaiming that the scheduled property belonged to the government and refused to pay any rent and also refused to vacate the suit leasehold premises. The continuation of the defendant is an illegal and unauthorized For such unauthorized occupation, defendant is liable to pay future profit of rupees 5,000 per month. In response to this petition, the appellant defendant appeared before the trial court and filed written statement admitting the plaintiff averments in partly. He also admitted that A scheduled premises belongs to the plaintiff and has sought the lease of the same from the plaintiff to run his business under name and style of Siddharth Refrigerations. But he denied the commencement of lease date. In fact, he has taken possession of the suit A scheduled premises in 1997 as the tenant of the same and has been running his business therein. He has been paying the monthly rent of rupees 2,400 per month and deposit of rupees 24,000, which is refundable. But the plaintiff is doing due coercion by the Deputy Commissioner Udupi. Therefore, the notice dated 3/11/2017 is illegal and void. Therefore, no termination of lease agreement. The trial court, having considered the pleadings of the parties, framed the issues and allowed the parties to lead evidence, and the plaintiff college trust examined office superintendent as PW1 and got marked exhibit P1 to 5. And close its side. And defendant has examined himself as DW1, got marked document exhibit D1. The trial court, having considered the both oral and documentary evidence, answered the issue number 1 as tenant in lieu of the admission on the part of the appellant herein as tenant. It also comes to the conclusion that tenancy has been terminated and hence plaintiff is entitled for vacant possession. And issue number 4 is partly answered as affirmative. Page granting the decree in order to pay the rate of rent 2,400 per month from the date of filing of the suit till handing over of the possession. Directed to hand over the vacant possession of the suit premises within 2 years from the date of the order, being agreed by the judgment and decree of the trial court. The present agreed by the judgment of the trial court, and appeal is filed in RA 34/2012. And first appellate court, on considering the grounds urged in the appeal memo, framed the point for consideration whether the trial court has committed in error in decreeing the suit. $5,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. Plaintiff has sought future profit at the rate of 5,000 per month from the date of suit till delivery of so building in the college complex with future profits at the rate of 2,004 per month with from the date of filing of the suit. ಎಷ್ಟು ಆರ್ಡರ್ ಮಾಡಿದಾರ್ರಿ ಕೊಡ್ಲಿಕ್ಕೆ? 5,000 ಆರ್ಡರ್ ಮಾಡಿದಾರ.
ಕೆಳಗಡೆ ಕೋರ್ಟಲ್ಲಿ ಅಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. OS 56/2018 ಅಲ್ಲಿ
5,000
ಅಲ್ಲ, ಡಿಗ್ರಿ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಇಂಟರ್ನಲ್ ರನ್ನಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 48 with future profits at the rate of 5,000 per month. Last portion of it. Suit for A directing the defendant and his agents to vacate the suit scheduled premises and to deliver the same to the plaintiff or its agents with future profits at the rate of rupees 5,000 per month.
Reasoning ಇಲ್ವಲ್ಲ 5,000 ಕೊಡಬೇಕು ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಆ ತರ? Only they have sought for 5,000. 13, 14, 15. Issue number 4. Plaintiff has sought for future profit at the rate of rupees 5,000 per month from the date of suit delivery of possession. It is stated that defendant has not been paying rent after receipt of notice. College trust is evicting the tenants in view of so-and-so. Otherwise, it would have been continued the rent agreements. The plaintiff has stated that the defendant has agreed to pay rupees 2,000 per month and has made a security deposit so-and-so. Therefore, it is opined that the plaintiff is entitled for future profit at the rate of rupees 2,400 ಅಂತ ಇದೆ. per month till taking of the possession of scheduled premises. ಅಷ್ಟೇ ಮಾಡಿದ್ದಾರೆ, ಜಾಸ್ತಿ ಏನ್ ಮಾಡಿಲ್ವಲ್ಲ?
ಅಲ್ಲ ಕೆಳಗಡೆ ಪೋರ್ಷನ್ ನಲ್ಲಿ ಅವರು ಡಿಕ್ರಿದಲ್ಲಿ 5,000 per month ಅಂತ ಹೇಳ್ತಾರೆ.
ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅಷ್ಟೇ ಇದೆ ರೀ, ಕ್ಲೈಮ್ ಮಾತ್ರ ಅಷ್ಟೇ. ಆಯ್ತು, ಏನಾಯ್ತು ಹೇಳಿ? And also formulated the point and also framed the point for consideration whether the respondent has made out sufficient ground to allow the cross appeal. Oh, they have also filed cross appeal.
ಕ್ರಾಸ್ ಅಪೀಲ್ ಇದೆ also. ಆಮೇಲೆ
Also
ಇನ್ನೊಂದು
filed cross appeal. Under Article 41 Rule 22 of CPC to set aside the finding of trial court on the issue number 4 and grant rupees 5,000 per month as future profit instead of rupees 2,400. That is also negative, alva.
Oh, my lord, though I have admitted to the landlord and tenant relationship,
The said point is negatived by the appellate court and having reassessed the material available under record, dismissed the appeal and also dismissed
some time may be given for me to vacate.
cross appeal. Now the counsel appearing for the appellant would vehemently contend that both the courts have committed an error and fails to take note of the grounds which have been urged before the trial court and misdirected itself by confirming the judgment by the appellate court. And it is the specific case of the appellant that trial court failed to note that the agreement of lease dated 1/8/2016 clearly earmarked in clause number 6 to the agreement that only if the appellant intended to end the lease agreement on the stipulated date of 30/6/2017, the appellant ought to give written notice to the respondent 2 months prior to him vacating the scheduled premises. Thus, the tenancy has been continued orally by the acts of parties. And appellate court has taken a view on section 116 of the Evidence Act 1872. No tenant of immovable property, comma, or person claiming through such tenant, comma, shall, comma, during the continuance of tenancy, comma, be permitted to deny that the landlord of such tenant had, comma, at the beginning of the tenancy, comma, a title to such immovable property, and no person who came upon any immovable property by the license of the person in possession thereof shall be permitted to deny that such person had a title to such possession at the time when such license was given. And the appellate court committed an error in coming to such a conclusion. First of the respondent could have issued legal notice for termination at all, as it has unequivocally admitted that due to the show cause notice of the deputy commissioner, is compelled to evict the tenants as it is commercial lease. And also, counsel would vehemently contend that appellate court committed illegality in holding that there exists dual relationship between landlord and tenant between the appellant and the respondent. And also, counsel would vehemently contend that the illegality is not appreciated. And the agreement of sale dated agreement of sale,
agreement of lease.
Lease dated 11/8/2016 is a void contract. And appellate court committed illegality by upholding the principles of estoppel under section 116 of the Act, and hence this court has to frame substantive question of law. Having heard the appellant counsel and counsel also in this argument relies upon the annexure D. Based on this document, notice was issued to evict him. And the counsel, referring this document, would contend that the respondent plaintiff is not a owner of the premises and the said fact has not been considered. That is the communication given by the deputy commissioner not to continue any commercial activities in the college premises. And the very initiation of proceedings against this appellant is the said communication. And hence the order requires to be interpreted and this court has to frame substantive question of law. Having heard the appellant counsel and also on perusal of the material available on record, admittedly the relationship between the plaintiff and respondent is not in dispute. And though counsel disputes now that plaintiff is not the owner, and when there is a categorical written statement is filed before the court admitting the tenancy, that he took the possession from the respondent plaintiff based on the agreement. And agreement is also marked as exhibit P5. And now cannot contend that the plaintiff respondent is not the owner. It is also specific case of the plaintiff before the trial court that the deputy commissioner has issued the direction not to run any commercial premises in the college premises. And the same is the basis for filing of the petition also for terminating the tenancy and filing of eviction petition. And that communication itself cannot create any right in favor of the deputy commissioner, and the same is only the reason for deciding to stop all commercial operations in the suit building and to evict all tenants occupying the said complex in view of the directions issued by the deputy commissioner. And the counsel appearing for the appellant would contend that in view of the said communication, the plaintiff respondent is not the owner. The same cannot be accepted, and the appellate court also rightly comes to the conclusion invoking section 116, wherein also clear estoppel with regard to once they have admitted that the plaintiff is a landlord and he is a tenant, and particularly on perusal of exhibit P5, rent agreement came into existence between the plaintiff and defendant, and rightly comes to the conclusion that there exists jural relationship between the plaintiff and defendant. With regard to the factual aspect is concerned, the termination notice was also issued and notice was also served on the appellant, and termination was also made in accordance with law, and only references for termination is communication of the deputy commissioner. And when such being the material available on record, the very contention of the appellant counsel that both the courts have committed an error cannot be accepted. When there is a clear admission in terms of exhibit P5 that exists jural relationship between the parties, and question of considering the second appeal doesn't arise, and no substantive question of law arises for the consideration of the second appeal, and hence I do not find any ground to invoke section 100 of CPC. And hence appeal is dismissed. Appeal is dismissed. The council also seeks time to vacate the premises, and having considered the initiation of proceedings was initiated in 2017 itself by causing the notice, and eviction petition was filed in 2018, almost 6 years has been elapsed. And hence, and also the trial court granted the relief with a condition to vacate the premises within 2 months. In the, madam, in the year 2000,
$18.
$2023. 2022. And
21/9/22.
thereafter appeal is filed in 2022 itself, and the impugned order also passed on 8th day of June 23. ಈಗ ನೀವು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಹಾಕಿದ್ರಲ್ಲ, ಯಾವಾಗ ಹಾಕಿದ್ದು?
Second, 27th March
ಟೈಮ್
24.
ಲಿಮಿಟೇಷನ್ ಇರ್ಲಿಲ್ವಾ? June 24. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಇದೆಯಾ ಮೇಡಮ್ ಡಿಲೇಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ?
ಹೌದು ಸರ್. ಹೌದು ಸರ್, ಇದೆ. Delay days to be correctly stated in the limitation para. Highest ಅದೆಲ್ಲ ಹಾಕ್ಬೇಕು ಅಂತ ಇದೆ ಸರ್.
And this appeal is also filed belatedly, though impugned order was passed on 8th day of June 23, and 1 year has been elapsed even after dismissing the regular appeal, and hence the appellant is not entitled for any further time.
2 to 3 months ಕೊಟ್ರೆ ಸ್ವಾಮಿ. I'll vacate the premises.
3 months ಇಲ್ಲ.
Kindly, my lord. Only I'm seeking for some time. ಅಲ್ಲ, there is some commercial ಒಳಗಡೆ ಇದಿರುತ್ತೆ ಸ್ವಾಮಿ, equipment. At least for that some time may be
ಇಲ್ಲ,
granted.
ಈಗ 1 ವರ್ಷ ಆಗಿದೆಯಲ್ಲ, ಖಾಲಿ ಮಾಡಿ, ಕಾಸ್ಟ್ ಹಾಕಿಲ್ಲ, ಬಿಟ್ಟಿದ್ದೀನಿ. ಕಾಸ್ಟ್
ಅಲ್ಲ, some
ಹಾಕ್ತೀನಿ ಇನ್ನು. ಹಾ,
short duration, my lord. I'll vacate the premises.
you are not entitled. ಇಂಥ ಕೇಸಲ್ಲೆಲ್ಲ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಬರ್ಲೇಬಾರ್ದು. ಹಾ, ಅಂಡ್ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ, ನಾಟ್ ದಿ ಓನರ್ ಅಂತ.
Serial number 8.
57.
Others matter. That is dismissed.
57.
Please.
Serial number 57, council.
Please, my lord.
Comply ಮಾಡ್ತೀವಿ.
ಅದೇನ್ ಮಾಡಕ್ಕಲ್ಲ, ಈಗ ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿದೆ, ಈಗ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ.
Names ಕೊಡೋದು ಸ್ವಲ್ಪ difference ಇತ್ತು. ಬರೀ ನೇಮ್ ಕರೆಕ್ಷನ್ ಅಷ್ಟೇ, ಈಗಲೇ
ಏನಿಲ್ಲ, ಈಗ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ, ಆಲ್ರೆಡಿ ಪಾಸ್, ಐ ಹ್ಯಾವ್ ಪಾಸ್ಡ್ an order, don't middle in the proceedings. 57, serial number 57. Sudhir
Filed an application to recall the.
Recalling application.
Recall. Sir.
ಆಯ್ತಾ? ಈಗ ಹಾಕಿದಾರಾ? ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಯಾವಾಗ್ರಿ?
It was dismissed on.
ನಿಮ್ ಅಪೀಲ್ ಹಾಕಿದ್ದ ಯಾವಾಗ? 2018.
Please, my lord.
ಎಷ್ಟ್ ಸರಿ ಬಂತ್ ಕೋರ್ಟ್ ಮುಂದೆ?
Dismissed on 24/2/22.
ಎಷ್ಟ್ ಸರಿ ಬಂತ ಹೇಳ್ರಿ?
The reason is that, my lords, there was a mistake in the decree copy, my lords, in the RA at page 39, my lords. At page 39 of the decree, my lords,
ಅಲ್ಟಿಮೇಟ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದೆ ಯಾವಾಗ?
it was dismissed on
22.
24/2/22.
ಆಯ್ತು.
And then, my lords, the records were called from the trial court in the connected matter in RSA 240, my lords.
ಆಯ್ತು.
So I requested the court to send back the records, my lords, then that went back to the appellate court, and then I corrected the decree, and then I produced it, my lords. And there was a correction in the name of the defendant also, my lords, before the trial court also.
Did you bring it to the court notice?
Yes, my lords, I brought
ಎಲ್ಲಿದೆ?
it to the, in
ಎಲ್ಲಿದೆ
RSA.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ? ಏನು ಇಲ್ಲ.
RSA 240 ಅಲ್ಲಿ ಹೇಳಿ records ವಾಪಸ್ ಕಳ್ಸಿದ್ರು.
ಹೌದ್ ಸರಿ, ಎಷ್ಟ್ ಸರಿ ಬರ್ಬೇಕ್ರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ಗೆ?
Because I moved an application, then I got it corrected. then I-
2018 ಜನವರಿಯಲ್ಲಿ ಹಾಕಿದಿರಿ, 25/1 ಹೌದಾ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಆಯ್ತು ಕೋರ್ಟ್ ಮುಂದೆ, ತೊಗೊಳ್ಳಿ. ನೋ ರೀಸನ್ಸ್, ತೊಗೊಳ್ಳಿ. Heard on IA 1/22 for CD of 212 days in filing the recalling application.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ
IA 2/22 for recalling the order dated 24/2/22. And having perused the order sheet, matter was listed before the court on 27/6/2018 and counsel was absent. And matter listed before the court on 28/1/2019. 4 weeks time was granted to do the needful. And again matter was listed before the court on 39/2019, when the counsel sought time of 3 weeks. And the same was granted, and made it clear also that if the office objections are not complied with within such period, the appeal shall be listed for dismissal. That is, and the said order was passed in 2019. And even matter was listed in 2021 on 12/2/21, again sought 4 weeks time, and the same was granted. And once again listed on 22/9/21, once again 4 weeks time was granted. And matter listed on 24/2/22. As a last chance, 2 weeks time finally granted to comply with office objection, and made it clear that if office objection are not complied with, appeals and stand automatically dismissed for non-prosecution without reference to any further orders from this court. And office is directed to ensure that the papers are furnished to the council as and when they approach them without giving any cause for complaints. And in spite of this order was passed, same is not complied, and ultimately the appeal is dismissed, and now and applications are filed before this court. The reasons assigned before this court
My lords, I have stated, my
for
lords,
delay.
because there were two appeals, my lords, there was I filed, it's a plaintiff suit, my lords, for suit for specific performance. Suit was partly decreed, my lords, for refund of the amount to the plaintiff, my lords. And there were two appeals arising of it. And one of in RA 250 of.
Nowhere in your affidavit you have stated about all these dates are given.
My lords,
Ex-
I've
ex-
stated, my lords, in
except
para
stated-
5, my lords.
Except stating in paragraph number 3, matter was listed on 24 to 22.
Yes, my lords, on the next para 5, I've stated that, my lords, I state that I've preferred one more RSA 240 of 18 before this honorable court and.
Maybe another appeal, filing of another appeal, how it will come in the way of
My lords,
compliance?
my lords, because LCR was called in that matter, my lords. Because LCR came before this court, my lords. Since there was no LCR, I may, though they, I made an application for correction of that decree, my lords. Since LCR was here before this honorable court, there was no correction, my lords. And then I requested this honorable court to send back the records in RSA 240 before the appellate court, then it was corrected, my lords.
ಅದು ಯಾವಾಗ?
ಅದು
18 ಇಂದ 22 ವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಅಲ್ಲ,
And the
ಅದು
office objections are raised in 2018.
my lords, 21/7/22 was records corrected, my lords. RA was corrected on 21/7/22.
Dismissal ಆಗಿದ್ದ ಯಾವಾಗ್ರಿ?
Dismissed on 24/2/22, my lords.
ಎಲ್ಲ after February.
Please, my lords.
What you have done only after the dismissal?
My lords, 24/2/22 was a dismissal, my lords. RA was corrected on 21/7/22.
Council ಈ appeal dismiss ಆಗಿದ್ದ ಯಾವಾಗ್ರಿ?
ಈ appeal dismiss ಆಗಿದೆ 24/2/22.
ನೀವೆಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಆಗಿ ಕರೆಕ್ಷನ್ ಮಾಡ್ಕೊಂಡಿರೋದು ಯಾವಾಗ?
ಅದು ಅಪ್ಲಿಕೇಶನ್ ಆಗಿ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ದು 21/7/22.
After the dismissal.
After the
After the dismissal.
because records were, my lords, records were before this honorable court in connected matter, my lords.
Maybe you have all made all efforts only after the dismissal.
No,
How it will helpful to you?
my lords, because records were in RSA.
Brought to notice of this court in paragraph number 5.
Reasonable
stated-
cost may be
stated
imposed
about-
because there are two appeal, there is another appeal, my lords.
Get it correct the order of the lower court. And these are all the efforts are made only after the dismissal of this second appeal. And no explanation from 2018 to till the date of dismissal that an attempt is made to make an application to send the record to get it correct the same before the dismissal of this appeal. And when such being the case, I do not find any ground to
My lords, one submission,
recall the
one submission.
order dated 24 to 22 and the the reasons stated in the affidavit are all subsequent events and hence not made out any grounds to recall the order and hence IA 1 of 22 and IA 2 of 22 are dismissed.
Lords, if that application, my lords, it may reasonable cost may be imposed and recalled, my lords, I will, because there is another appeal, my lords, I have challenged it. RSA.
No meaning in supporting the lethargic people.
My lords, because my lords, the reason is that, my lords, there was they are wrong in the decree copy that has been written.
Council, I
Dismissal
heard-
ಅನ್ನೋದು
I
allowed
heard
ಅಂತ
that
ಮಾಡಿದ್ರು.
Reasons also what I have given affidavit, I have considered all this you have done only after the dismissal, not before that. If you have made any effort before that, I would have considered it.
My lords, the reason is that, my lords, the records were here because
ಆಯ್ತ್ರಿ ನೀವೆಲ್ಲ ಮಾಡಿರೋ dismissal ಆದ್ಮೇಲೆ
RS ನ records ವಾಪಸ್ ಕಳಿಸ್ಬಿಟ್ಟಿದ್ರು.
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, ನೀವು ಏಪ್ರಿಲ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ರಿ dismissal ಆದ್ಮೇಲೆ.
ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲಿದ್ದಿದ್ರಿಂದ ನಾನು ಅದು
ನಾನು
ವಾಪಸ್
ವಾಪಸ್-
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಎರಡು ಕನೆಕ್ಟ್ ಆಗಿರ್ಲಿಲ್ಲ ಹಾಗಾಗಿ
ಏನ್ ಮಾಡೋದು?
ಅದು ಅಲ್ಲ ರೀಸನಬಲ್ ಕಾಸ್ಟ್ ಮೇ ಬಿ ಇಂಪೋಸ್ಡ್ ಅಂಡ್
ಏನ್
ರೀಕಾಲ್ಡ್.
ರೀಸನಬಲ್ ಇಲ್ಲ ಏನಿಲ್ಲ. ಎಷ್ಟ್ ಸರಿ ಬರ್ಬೇಕು ಕೋರ್ಟ್ ಮುಂದೆ? ಡಿಸ್ಮಿಸಲ್ 2019 ಇಟ್ರು 3 ವರ್ಷ ನೀವು ಹ್ಯಾವ್ ನಾಟ್ ಮೇಡ್ ಎನಿ ಎಫರ್ಟ್.
ರೀಸನಬಲ್ ಕಾಸ್ಟ್ ಆಗಿ ರೀಕಾಲ್.
2019 ಆರ್ಡರ್ ಆಗಿದೆ, ಮತ್ತೆ ನೀವು ಫಾಲೋನೇ ಮಾಡೋದಿಲ್ಲ. ಕೋರ್ಟ್ ಆರ್ಡರ್ಸ್ ಗಳಿಗೆ ಮರ್ಯಾದೆನೇ ಇಲ್ಲ ನಿಮ್ಗಳಿಗೆ.
ಇಮಿಡಿಯೇಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಅವು ಎರಡು ಆಫೀಸ್ ಆಬ್ಜೆಕ್ಷನ್ ಇದೆ.
ಡಿಸ್ಮಿಸ್ ನೆಕ್ಸ್ಟ್ ಮಾಡ್ರಿ ವಿನಯ್ ಕೀರ್ತಿ.
ಅಲ್ಲ ಇಮಿಡಿಯೇಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಅದೊಂದು ಅಲ್ಲ ರೀಕಾಲ್ ಮಾಡಿದ್ರೆ ರೀಸನಬಲ್ ಕಾಸ್ಟ್ ಆಗಿ.
ಅಬೋ ಅಪೀಲ್ ಏನ್ರಿ ಇದು? ಹಾ
Yes, Your Lordship, kindly connect the RSA 1134 of 2018. One of the defendant is also
same arising out of same.
same.
Appellant counsel submits that one more RSA 1134 of 2018 is pending. And the same, and this appeal also may be listed along with the same, and hence registry is directed to list the same along with the same. ಯಾವಾಗ 12/7. ಏನ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವ ನಿಮ್ಗೆ?
ಕೊಡ್ತೆ ಸರ್ವ್ ಮಾಡ್ತೀನಿ.
The counsel for the appellant also directed to furnish copy of IA 1 of 18 to counsel for R1 and counsel for R1 and R2. Right, next.
59, MS Venugopal.
A two for 24 for
Bring
bringing
the
the
LRs.
of deceased R2 on record as R2 A2 A and B. ಹೇಳ್ರಿ. Notice ಹೋಗ್ಬೇಕಾ?
Notice of it.
Undertake ಮಾಡ್ತೀರಾ?
For both the.
Counsel Venkat Reddy CM undertakes to appear on behalf of the LRs of deceased R2 on record. And hence 2 weeks time granted. Granted to file wakalat. ನಿಮ್ಗೆ ಕಾಪೀಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದಾರಾ? ಕೊಟ್ಟಿದ್ದಾರೆ. And hence this matter on 12/7.
27.
60.
Yatisha J Nadiga.
I appear for
Stay
petition.
is not pressed by the counsel for the appellant since twice,
Yes.
twice filed.
Aye.
A
Two
one of
application
20
filed for.
A 1 of
stay.
20 is dismissed as not pressed.
One is a delay application, other malad is the respond number.
Delay 1359 days, sir. ಕೊಡಿ ಅದೇನ್ ನೋಡೋಣ. ಏನ್ reason, sir?
I think the LRs malad is LRs application is pending.
ಇದೇನ್ ಡಿಲೇ ಇರೋದು ಎಲ್ಲಾರ್ಸ್ಕ ಅಥವಾ
ಈ LRC ಗೂ ಇದೆ ಮತ್ತೆ appeal ಗೂ
appeal ಗೆ
ಇದೆ.
ಎಷ್ಟು ದಿವಸ ಇದೆ ಹೇಳಿ?
1359.
appeal ಗೆ ಫೈಲ್ ಮಾಡಕ್ಕೇನೆ ಕೊಡಿ ಅದು ಫಸ್ಟ್ ಕೊಡಿ ಮೊದ್ಲು. ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಮಾಡಿದ್ವಿ.
ಲಾಯರ್ ಇಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲ?
ಇಟ್ಟಿದ್ದೀರಿ.
ಇಟ್ಟಿದ್ದೀರಿ. ಮತ್ತೆ ಯಾಕೆ ಡಿಲೇ 1359 ದಿವಸ?
ಅಲ್ಲಿ defendant plaintiff is the appeal in RA. Original suit is dismissed, suit for
ಆಯ್ತು.
partition.
ಆಯ್ತು. ಅಪೀಲ್ ಏನಾಯ್ತು?
Appeal is allowed.
ಆಯ್ತು.
After that, malad is the page 55, malad, application for delay.
ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಸೂಟ್ ಡಿಸ್ಮಿಸ್ ಆದ್ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ ನೀವೇನಾ?
Plaintiff.
ಪ್ಲೇಂಟಿಫ್ಸ್ ಫೈಲ್ಡ್ ಅಪೀಲ್.
Yes, please.
ಏನೋ ಬ್ರಹ್ಮಚಾರಿ ಅಂತಿದೆ?
Brahmachari is the respondent number
Tama.
3.
ಆಯ್ತು. ನಿಮ್ಮ ಅಪೀಲ್ ಅಲೋ ಆಯ್ತು.
ಅಲ್ಲಿ ನಂದಲ್ಲ. I am the second plaintiff, I filed the RSA.
ಸೆಕೆಂಡ್ ಪ್ಲೇಂಟಿಫ್.
Yes. Sorry, second defendant.
ಅಪೀಲ್ ನಿಮ್ದೇ ಅಲ್ವಾ? ಅಲ್ಲ ಅವ್ರದ್ದೇನು ಪ್ಲೇಂಟಿಫ್?
Plaintiff appeal.
ಆಯ್ತು. ಸೆಕೆಂಡ್ ಡಿಫೆಂಡೆಂಟ್ ಫೈಲ್ಡ್ ದಿಸ್ ಅಪೀಲ್.
Yes, sorry,
This
first defendant,
This judgment was passed in 2014.
14,
ನೀವು ಹಾಕಿರೋದು 2018.
18.
Why there was a delay? Reasons ಏನು?
ಇದರಲ್ಲಿ FDP proceeding ನಡೀತಾ ಇತ್ತು. After that,
Admit that I am an aged illiterate lady engaged in agriculture, residing in a remote village. At the Honorable Civil Judge Court allowed the appeal against me, and another I was under the impression that I have no further remedy against that judgment, and I am not aware that said judgment can be challenged. ಏನ್ರಿ ಹಿಂಗೆಲ್ಲ ಹಾಕಿದ್ರೆ ಹೆಂಗ್ರಿ ಇದು? Reasons?
ಅಲ್ಲ,
I did
next
not
year.
approach. ನಂಗೇನೋ ರೆಮಿಡಿ ಇಲ್ಲ, ಅದರಿಂದ ನಾನು ಲಾಯರ್ ಹತ್ರ ಹೋಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನಿದು ರೀಸನ್? Next, I submit that subsequently, which arises out of judgment filed an application for pending FDP. FDP file ಮಾಡಿದ್ದೆ ಯಾವಾಗ?
FDP 2015.
Nowhere you have stated that you are not having any knowledge about the judgment and decree. Alwa, you
Yes.
kept quiet. FDP in 2015.
15.
ಮತ್ತೆ
ಹಿಂಗ ನೋಟಿಸ್ ಬಂದ್ಮೇಲೆ once again
ಯಾವಾಗ ನೋಟಿಸ್ ಬಂದಿದೆ ಹೇಳಿ? ನೀವು FDP ಅಪಿಯರ್ ಆಗಿದ್ದೆ ಯಾವಾಗ? ನಿಮಗೆ ನೋಟಿಸ್ ಬಂದಿದೆ ಯಾವಾಗ? ಹೇಳಿದ್ರೆ ಏನಾರು?
ಅದನ್ನ ಹೇಳಿ.
FDP which arises out of sound will alleged to have been executed by source after dismissal of the said application. One of our well-wisher informed that I should have preferred appeal. ಅದು ಕೂಡ ಹೇಳಿಲ್ಲ, ಏನ್ ಮಾಡಿದ್ರಿ ಅಂತ?
Filed better affidavit.
No
I filed, I filed better affidavit.
ಬೆಟರ್ ಅಫಿಡವಿಟ್ ಬಂದ್ರು ಏನಿಲ್ಲ, ಉಪಯೋಗ ಇಲ್ಲ. Third,
Please.
this matter is listed for hearing.
I filed 1 week time, lad, I better file affidavit.
ಹಾಕಿದ್ರು ಅಷ್ಟೇನದು.
Which date I will appear FDP?
Nowhere
After FDP, my lord.
There you have stated that you are not having the knowledge of the judgment.
Yes,
and
after
decree of the
FDP,
first
my lord.
court.
Yes, FDP, my lord. Yeah, after the issue notice the FDP,
Not both
I filed along with the order sheet, FDP order sheet and
ಅದು
affidavit.
ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ. ಯಾಕೆ ಅಂತಂದ್ರೆ it is not your statement before the court that you are not having any knowledge about it. But you comes to a conclusion that no remedy, further remedy ಇಲ್ಲ ಏನು ಅಂತ ಹೇಳಿ ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಏನು ಮಾಡ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಯಾರೋ ವೆಲ್ವಿಷರ್ ಹೇಳಿದ್ರು ಅದರಿಂದ ಬಂದೆ ಅಂತಂದ್ರೆ ನಿಮ್ FDP no such pleading.
ಅಲ್ಲ 1 week ಇಲ್ಲ. I filed ಅಲ್ಲ FDP ಆರ್ಡರ್ ಹಾಕ್ತೀನಿ. I will support it.
ಹಾಕಿದ್ರು ಏನು ಉಪಯೋಗ ಬರಲ್ಲ ನಿಮ್ಗೆ. It is not your case that you are not having any knowledge about the dismissal of the appeal.
Plaintiff is not issue, issueless is a died, my lord, is a respond number 3 in the OS with plaintiff.
ಆಯ್ತು.
After that, my lord, I was keep quiet. That after the writ petition filed in the through will, the coming the LRs of the plaintiff.
Whatever it may be, counsel, delay of
aspect, my lord,
1359, no reasons. Toli madam, toli.
Please, I will
What is the
1 week time, lord, is better with affidavit and all.
Affidavit ಹಾಕಿದ್ರು
FDP, I filed the FDP order sheet, my lord.
letter affidavit ಹಾಕಿದ್ರು ಉಪಯೋಗ ಇಲ್ಲ.
ಅಲ್ಲ FDP order sheet ಹಾಕ್ತೀನಿ 1 week, please.
Not stated anything about you have filed this appeal after the issuance of FDP only. That is not your pleadings. You go to paragraph number 6 also.
Yes.
ಎಲ್ಲಿದೆ ನೋಡಿ.
It's only last line.
An application in pending FDP
in
We
Cuba,
subsequently
still pending.
Subhendrachari, son of so and so, which arises out of judgment so and so.
Yes.
After the dismissal of the said application, one of our well-wisher ಏನ್ application ಹಾಕಿದ್ರು ಅದು dismiss ಆಯ್ತು.
Yes.
ಆಮೇಲೆ ಹೇಳಿದ್ರಿ ಅಂತ. Nowhere you have stated anything about this.
I better affidavit, please. 1 week.
ಏನ್ ಹಾಕಿದ್ರು ಬರಲ್ಲ ತೊಗೊಳ್ಳಿ.
ಅಲ್ಲ ಒಂದು ಆರ್ಡರ್ ಶೀಟ್ ಒಂದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಲಿ ಅದೊಂದು.
ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದ್ರು ಏನ್ರಿ ಬರುತ್ತಿರ್ಲಿ, ನಥಿಂಗ್ ಇಸ್ ದೇರ್.
Without knowledge, my lord, after FDP, I will only come the knowledge.
How did the
I will.
appellant counsel on a one of 20, where there is a delay of 1359 days in filing this second appeal. In support of the application, an affidavit is sworn to by the second defendant ಅಲ್ಲ? Second
Sorry,
defendant.
first dependent, you filed the appeal.
First, ಇದು affidavit ಹಾಕಿರೋದಾರ ಕಾಳಮ್ಮ, first defendant
First dependent.
defendant number 1 by the first defendant, wherein she has stated that she is a aged illiterate lady and engaged in agriculture and residing in remote village. And appeal was allowed, and against the appeal, she was under the impression that she has no any further remedy against that judgment. And she is also not aware of that such judgment can be challenged before the High Court. And hence she did not approach her advocate. It is also further stated that FDP, in the FDP proceedings, plaintiff number 2 filed an application, and the same was rejected. And after the dismissal of the said application, one of her well-wisher informed to file an appeal, and hence approached the advocate and filed this appeal. The counsel appearing for the appellant would vehemently contend that only after the receipt of the notice in the FDP comes to know about the same and filed this appeal. And there is no such any averment in the affidavit, and the affidavit is very specific that she was under the impression that she has no any further remedy, and nowhere it is stated that she was not having any knowledge about the judgment and decree of the first appellate court. And apart from that, it is also stated in paragraph number 6 that she had the knowledge about the FDP proceedings, wherein plaintiff number 2 filed an application in pending FDP, which arises out of the judgment challenge claiming right in the property on the basis of the will alleged to have been executed by late Brahmachari. That is plaintiff number 1. And the said application was also dismissed, and thereafter only well-wisher advised her to file an appeal. And delay has not been properly explained, and each delay has to be explained when she kept quiet immediately after passing of judgment passed by the appellate court, and not made any efforts and pleading of that she is aged illiterate lady and engaged in agriculture and residing in a remote village is not a ground to condone the delay of 1,359 days. The Supreme Court also recently held that each delay has to be explained by the party when the appeal is filed belatedly. And this appeal is filed in 2018, even though the first appellate court appeal was disposed of on 17th day of October 2014. And delay of 4 years has not been explained, and hence I do not find any ground to condone the delay. And hence IA is rejected. Consequently, second appeal is dismissed. Consideration of other IAs doesn't arises for the consideration in view of decision taken in IA number 1 of 18.
61.
Appellant, my lords. We have complied the office objection has been raised on IA number 1, my lords. And 333.
Pending consideration ಅಂತ ಏನಾರು ಆರ್ಡರ್ ಆಗಿತ್ತಾ?
ಇಲ್ಲ ಇಲ್ಲ sir.
ಇಲ್ಲ. ಆಗಿದೆಯಾ ಮೇಡಮ್?
ಹಾ sir.
ಇಲ್ಲ ಅಂತಾರೆ. ಏನೋ ನೋಡ್ಕೊ ಬರಲ್ಲ, ಬರೋದು ಕೋರ್ಟಿಗೆ ಬರೋದು ನಿಂತ್ಕೊಳ್ಳೋದು ಅಷ್ಟೇ. ಎಲ್ಲ ಕೋರ್ಟ್ನವರೇ ಓದ್ಕೊಂಡು ಕೋರ್ಟ್ನವರೇ ಆರ್ಡರ್ ಬರೀಬೇಕು. ನಾನೇ ಲಾಸ್ಟ್ ಟೈಮು ಫಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲೇ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ IAS. I have given an opportunity for you to comply with office objections ಅಂತ ಕೊಟ್ಟಿದ್ದೀನಿ. ನೀವು ಅದು ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ. ಮಾಡಿದ್ರೆ ಹೋಗ್ಲಿ. ಡ್ಯೂರಿಂಗ್ ದಿ ಕೋರ್ಸ್ ಆಫ್ ದ ಡೇ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಮಾಡಿದಿರ ಈಗ?
ಡ್ಯೂರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. IA 333 days.
ಕಂಪ್ಲೇಂಟ್ಸ್ IML ಕಂಪ್ಲೇಂಟ್ಸ್ ಬಂದಿತ್ತ? ಈಗ IML ಮಾಡಿದಿರಿ, ಇನ್ ಮತ್ತೆ ಮೇನ್ ಮೇಲ್ ಮಾಡ್ಬೇಕು.
ಸ್ವಾಮಿ ಅದು IA ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಯ್ತು ಅಂದ್ರೆ ಆಮೇಲೆ ಮೇನ್ 3 ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಸ್ವಾಮಿ. ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಒಂದು
ಪೆಂಡಿಂಗ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ IA 1 of 23, 2 of 23, 2 weeks time granted to comply with office objections. ಅದೊಂದು ಇದಕ್ ಮೇಡಮ್, ಅದು IA ಇರ್ಬೇಕು ನೋಡಿ, ಅದು IA ಮೇಲೆ ಇರ್ಬೇಕು ಅದು ನೋಡಿ. ಈಗ ಮೇನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡವಲ್ಲ, IA ಮೇಲೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇತ್ತು ಅನ್ಸುತ್ತೆ ನೋಡಿ.
ಹಾ ಸ್ವಾಮಿ, IA ಮೇಲೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಸ್ವಾಮಿ. ಇದು ರೀಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಡೇಸ್ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ, ಡಿಲೇ ಡೇಸ್ ಅಂತ, ಅದು ಕಂಪ್ಲೈ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಯಾವುದು ಹಳೇದ್ 3 ಇದೆ ಅದಕ್ಕೆ. And hence 2 weeks time granted, comply with the same. First ಮಾಡ್ಕೊ ಬನ್ನಿ. List this matter on 12/7.
62.
For the appellants, my lord. My lord, appellant is no more. He died on 30/4/2021. And LR application and abatement application have been filed on 16/9/2021.
ತಗೊಳ್ಳಿ. ಅದರ್ ಸೈಡ್ ಯಾರಿದಾರ? ಹರಿಪ್ರಸಾದ್ MS for R1 to R3. ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರೆ ಅದರ್ ಸೈಡ್ ನೋಡಿ ಮೇಡಮ್. ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಅದರ್ ಸೈಡ್ಗೆ? ಯಾವಾಗ? ಎಂಡರ್ಸ್ಮೆಂಟ್ ಇಲ್ಲ. ಅದರ್ ಸೈಡ್ಗೆ ಕಾಪೀಸ್ ಕೊಡಿ. ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ ಏನಾರು ಹೇಳೋದಿದ್ರೆ ಹೇಳಿ. ತಗೊಳ್ಳಿ. The copies are not served on the other side, since the counsel for R1 to 3 is represented on behalf of the respondent. And hence list this matter for consideration of the pending IAS. List this matter on 12/7. ನೀವು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ, ಅದರ್ ಸೈಡ್ ಕಾಪಿನೂ ಕೊಟ್ಟಿಲ್ಲ. ನೆಕ್ಸ್ಟ್
63.
ವೆಂಕಟೇಶ MT 184 days ಡಿಲೇ. ಏನ್ರಿ ನೀವು ಸರ್ಕಾರಕ್ಕೆ ನೀವಿದ್ದೀರಾ, ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡ್ಬೋದಾ? 184 daysಗೆ ಏನ್ ತಕರಾರು ಇದೆಯಾ? ರೀಸನ್ಸ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿದಿರಾ? ಅಪೀಲ್ ಮೆಮೊ IA ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ. AGA submits that IA copy. IA 1 of 23 copy is not furnished, and hence appellant counsel is directed to serve the copy forthwith. List this matter for consideration of IA on 12/7.
64.
P. Nataraj.
ಇದರಲ್ಲಿ
For impleading proposed
R2 died after the disposal of the RML. That's why I filed the application for impleading.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ಲ?
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು, ಅಡ್ಮಿಷನ್ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ
ನಾನು TI ಕೇಳಿದ್ದೀನಿ, ಅಡ್ಮಿಷನ್ ನಲ್ಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಅದೇಂಗಾಗ್ತದೆ ಫಸ್ಟ್
ಅಲ್ಲ, ಇನ್ನು ಉಳಿದವ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇರ್ತಾರೆ.
ಆಲ್ರೆಡಿ ಇದಾರ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದಾರ.
ಅದು ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವರು ಇದ್ದಾರೆ. ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆರ್ ಆಲ್ಸೋ ದೇರ್.
R2 A and B ತಗೊಳ್ತೀರೇನ್ರಿ ನೀವು? ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅವ್ರ ಪರವಾಗಿ? ಸೇಮ್ ಅಡ್ವೊಕೇಟಾ?
ಇಲ್ಲ ಇವರು
R6 ಅಡ್ವೊಕೇಟ್ ಏನಾ?
ಇಲ್ಲ ಎಲ್ಲ ಇವ್ರು ಬರೋದಿಲ್ಲ. R6 ಬರೋದಿಲ್ಲ.
R6 ಇವ್ರು ಇರ್ಲಿಲ್ಲ. ಅಲ್ಲ ಇದು ಈಗಲೇ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದಲ್ಲ. ಇವನ್ ಅಪೀಲ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಸತ್ತೋಗಿದಾರ.
ಅಪೀಲ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಸತ್ತೋಗಿ
ಈಗ ಆಲ್ರೆಡಿ ಪಾರ್ಟಿ ಮಾಡಿದಾರ ನೋಡಿ ಮೇಡಮ್. R2 A and B ನೋಡಿ.
ಇಲ್ಲ, ಅದೇನಾಯ್ತು, ಅಪೀಲ್ ಫೈಲ್ ಮಾಡುವಾಗ ನನಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ. R2 ಹಾಗೆ ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ. ಆಮೇಲೆ ಅವರು ಇಲ್ಲ ಅವ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ ಬಂದು ಹೇಳಿದ್ರು. ಆಮೇಲೆ ಬಿಟ್ಟಿಗೆ ಅಪ್ಲಿಕೇಶನ್.
ಅಂದ್ರೆ ಈಗ ಸತ್ತವ್ರನ್ನೇ ಪಾರ್ಟಿ ಮಾಡಿದ್ರಿ ನೀವು?
ಹೌದು.
R2 ಅಂತ. ಮತ್ತೆ ಈಗ ನೋಟಿಸ್ ಹೋಗ್ಲೇಬೇಕು.
ನೋಟಿಸ್ ಹೋಗಿ
issue notice on A1 of 24 against the LRs of R2 A and B and also ಬೇರೆಯವ್ರಿಗೂ ಇದಾರಲ್ಲ ಇವ್ರು KVTR R6 ಮಾತ್ರ.
ಹೌದು.
and issue notice against other respondents.
ನಾನು ಸಾಟ್ ಪರ್ TI ಅದ್ರಲ್ಲಿ ನಾಟ್ ಟು ಏಲಿನೇಟ್ ಅಂತ ಕೇಳಿದ್ದೀನಿ.
on main
ನಾಟ್ ಟು ಏಲಿನೇಟ್ ಅಂತ ಕೇಳಿದ್ದೀನಿ.
not to alienate ಕೆಳಗಿನ ಎಷ್ಟು?
ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟಲ್ಲೂ ದೇರ್ ವಾಸ್
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ 42 ಜನ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್.
ಅದಕ್ಕೇನೆ ನಾಟ್ ಟು ಏಲಿನೇಟ್ ಅಂತ ಕೇಳಿದ್ದೀನಿ.
ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಏನಾದ್ರು ಆರ್ಡರ್ ಇತ್ತ?
ಇದು ಅಪ್ಲೇಟ್ ಕೋರ್ಟಲ್ಲಿ ಇತ್ತು. ಅಪ್ಲೇಟ್ ಕೋರ್ಟಲ್ಲಿ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟಲ್ಲಿ
ಇತ್ತು ಆರ್ಡರ್.
ಇತ್ತು.
ಆರ್ಡರ್ ಕಾಪಿ
ಅಫಿಡವಿಟ್ ಹೇಳಿದ್ದೀನಿ. ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ.
ಕೊಡಿ. Heard on A1 of 23 where prayer is sought not to alienate this the properties and in support of the application an affidavit is sworn to that
ಯಾರ 4 ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ.
stated that now taking the advantage of the impugned judgment and decree passed by the courts below, the sixth respondent is trying to alienate. ನಿಮ್ಮ ಮೇಲೇನೆ ಹೇಳ್ತಾ ಇದಾರಲ್ರಿ ನೋಡಿದ್ರ item number 1 19 to 21 of the suit shall properties full stop. It is also sworn to that during the pendency of RA number 98 of 2018 the first appellate court was pleased to grant the interim order restraining the respondent number 6 defendant number 1 from alienating the item number 1 of suit shall property. Only item number 1 ಮಾತ್ರ.
ಹೌದು ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ ಕೇಳಿ.
Therefore, it requires the respondent number 6 to restrain from alienating the property in respect of item number 1 of the property. Appellate court ಅಲ್ಲಿ ಇತ್ತಂತಲ್ರಿ ಆರ್ಡರ್, ಮತ್ತೆ ಯಾಕೆ ಮತ್ತೆ ಅದ್ರಲ್ಲಿ ತಕರಾರು? And hence ಆಯ್ತು, directed to not to alienate the item number 1 of the property till the next date of hearing. In the meanwhile, the counsel for R6 is given an opportunity to file a statement of objections to A1 of 23. PF immediate ಕೊಡ್ಬೇಕು. 42 ಜನ ಅವ್ರೆ.
Immediate
ಆಯ್ತು. The counsel for the appellant is also permitted to take hand summons to the respondents. ಇಲ್ಲಾಂದ್ರೆ ಇದು 40 ಇಲ್ಲ, ನೀವು 42 ಜನ ಸರ್ವಿಸ್ ಹಾಕಿ 10 ವರ್ಷ ಬೇಕಾಗುತ್ತೆ. ನೀವು ಮಾಡಿ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಟು ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆಲ್ಸೋ ಥ್ರೂ ದಿ ಅಪಲೆಂಟ್.
65
ಶಿವರಾಮ್ HC ಏನ್ ಹೇಳ್ರಿ?
I have filed this application for vacating stay.
Vacating interim stay order.
ಹೌದು. ಅಲ್ಲ ಅದರಲ್ಲಿ
acceptance of cost paid to the Karnataka state level advocates.
For matter comes to my lord, office objection was there, it was complied with.
ಏನು ಅವ್ರಿಗೇನು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅದಕ್ಕೆ ವೇಕೇಟಿಂಗ್ ಹಾಕಿ. What is order you have taken?
Interim orders admitted, matter was admitted and stay has been granted.
For specific performance,
copy no service
ಹೌದು. Concurrent findings against them.
Concurrent finding, that copy has not been served on me, my lord.
Whether trial court and the first copy ಕೊಟ್ಟಿಲ್ವ ನಿಮ್ಗೆ?
Copy ಕೊಟ್ಟಿಲ್ಲ.
Vacating stay
ಇಲ್ವೇ ಇಲ್ಲ.
Vacating stay application ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ಲ ನೀವು?
ನಮ್ ಕೊಲ್ಲಿಗೆ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಕೊಟ್ಬಿಟ್ಟು ಬಂದಿದ್ದಾರೆ. ಅವ್ರ ಆಫೀಸ್ಗೆ ಹೋಗಿ ಕೊಟ್ಬಿಟ್ಟು ಬಂದಿದ್ದಾರೆ. ಎಂಡೋರ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
ಇದೆಯಲ್ರಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್?
ಇಲ್ಲ ನನಗೆ.
ನಿಮ್ ಫೈಲ್ ಅಲ್ಲಿ ಇಲ್ಲದೆ ಇರ್ಬೋದು. ಇಲ್ಲ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ, ಕಾಪಿ ಸರ್ ಮಾಡ್ರೋಕೆ Ah,
Monday, my lord, may have this.
ah.
I will argue the matter.
Received copy on 24/6/24.
Stay of judgment and decree.
So, the council appearing to the copy ಇಂದಲೇ acknowledgement ಹೆಂಗ್ರಿ ಇರ್ತದೆ?
My lord, that's correct.
ನಿಮ್ ಕೊಲಿಗ್
If it is
copy
there, my lord.
ತಗೊಂಡ್ ನಿಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನಾವೇನ್ ಮಾಡಕ್ಕ? ನೀವು ನಿಮ್ ಕೊಲಿಗ್ ನ ಸರಿಯಾಗಿ ನೋಡ್ಕೊಂಡಿಲ್ಲ ಅದಕ್ಕೆ.
By mistake, it has been not noticed.
Ah.
It appears. Matter has been admitted, but the judgment and decree suit.
ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ಬೋದಲ್ಲ?
Final
Council
disposal
why
ಮಾಡ್ಬೋದು.
pass an order? Ah?
ಹೌದು ಮಾಡ್ಬೋದು.
Matter admit ಆಗಿದೆ.
Specific performance.
Specific
ಹೌದು
performance.
concurrent findings against them.
ಆಯ್ತು ನೋಡು. Instead of considering IA number 1/24 vacating stay, it is appropriate to ಈ ಪೇಪರ್ ಬುಕ್ ಏನೋ ಇದೆಯಲ್ಲ ಹಾಕಿದೀರ
Paper book ಇದೆ ಹಾಕ್ಬೇಕು ಸ್ವಾಮಿ. ಇದು ಈಗಲೇ ಅಡ್ಮಿಟ್ ಆಗಿರೋದು ಇವಾಗ.
ಗೊತ್ತಾಯ್ತು ಯಾವಾಗ ಹಾಕ್ತೀರಿ ಪೇಪರ್ ಬುಕ್?
Lower court records ಬಂದ್ರೆ ಸಾಕು. Lower court records ಬಂದಿದೆ ಅಷ್ಟೇ ಸಾಕು. More than enough.
Lower
Paper
court
book-
records, only one point you will ask.
ಆಯ್ತು ಈಗ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡೋಣವಾ?
ಹೌದು.
Instead of considering IA number 1/24, matter can be heard and disposed of on main.
The question of law.
Main
Mr.
appeal. In view of already substantive question of law framed by this court. The suit is for the relief of specific performance and both the council submits that the filing of paper book is not necessary and the same can be dispensed and hence same is dispensed. List this matter for final hearing on.
Records.
ಯಾರಿಗೆ ಹಾಕಿದಾರ ಅವರು? ಹಾಕಿದಾರ?
Along with my colleague I filed, BM Arun. ನಮ್ colleague ಜೊತೆ ನಾನು ಹಾಕಿದ್ದೀನಿ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಒಬ್ಬರೇ ಇರೋದಾ?
ಒಬ್ರೇ.
Respondent operate down company. It is a company you lost.
ಅಲಾಂಗ್ ವಿತ್ ಅಂದ್ರೆ ಯಾಕ್ ಬೇಕು? ನಿಮ್ದೇ ಇದೆಯಲ್ಲ ಮತ್ತೆ ಯಾಕ್ ಬೇಕಾ? ಮತ್ತೊಂದು
ನಂದಿರ್ಲಿಲ್ಲ ಮೊದ್ಲು ಅದಕ್ಕೋಸ್ಕರ ಕಂಪನಿ
ನಿಮ್ದಿರ್ಲಿಲ್ಲ ಮೊದ್ಲು?
ಇರ್ಲಿಲ್ಲ ನಮ್ ಕೊಲೀಗ್ ಇತ್ತು.
ಮೊದ್ಲು BM ಅರುಣ್ ಇದ್ರ?
ಅಲ್ಲ ಸುರೇಂದ್ರ ಅಂತ ನಮ್ ಕೊಲೀಗ್.
ಇವಾಗ BM
ಹೌದು
ಸುರೇಂದ್ರ ಇದೆ.
ಹೌದು ನಮ್ ಕೊಲೀಗ್ ಅವರು.
ಈಗ ಇವರು ಹಾಕೊಂಡವ್ರೆ. ಆಯ್ತು ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ BM Arun also filed wakalat along with R Surendra and hence registry is directed to show the name of BM Arun along with Surendra R. List this matter on. ಯಾವಾಗ on date ಕೊಡಿ? 29th of July.
Records may be.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ವಾ? ಅಡ್ಮಿಟ್ ಆದ ತಕ್ಷಣ ಬಂದಿರುತ್ತೆ ರೆಕಾರ್ಡ್ಸ್. ಬಂದಿಲ್ವಾ ಮೇಡಮ್? ಬಂದಿದೆ. ಆಯ್ತು ರೆಕಾರ್ಡ್ಸ್ ಇದೆ.
Yes sir.
ರೆಕಾರ್ಡ್ಸ್ ಇದೆ.
Yes sir.
66 Nagaraj Hegde, Ajit A Shetty. Recalling the order dated 15/3/24 along with statement of objections. ಏನು the statement of objections? 15/3 ನಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಏನಾಗಿದೆ? Hello, what is the order 15/3/24?
But matter was moved on the 15th of March 2022. Listed at the adjournments.
ಅಂದ್ರೆ ಮಾರ್ನಿಂಗ್ ಮೂಡ್.
I was not informed, but what my learned friend now says is that he had informed the other council was on record. But I asked myself the question, what if the fact that a council is on record is properly issued of the army court? The army court who had issued notice to the respondent. What has been done? So my respectful submission is, the manner in which not the match was moved and not the was here. Was some
ಅಲ್ಲ ಆಲ್ರೆಡಿ when the council is on record, what is the need of issuance of notice to the respondent?
ಕೇವೇಟರ್ ಸ್ವಾಮಿ ಕೇವೇಟರ್ ಅವತ್ತು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರು.
ಕೇವೇಟರ್ ಅಲ್ಲ ಇವರು ಕೂಡ ವಕಾಲತ್ತಲ್ಲಿ ಇದಾರಲ್ಲ.
ಇಲ್ಲ he has not obtained any no objection from the ಕೇವೇಟರ್ the advocate who is on record
23 ಅಲ್ಲಿ ಏನೋ ವಕಾಲತ್ ಹಾಕಿದಾರಂತ
without obtaining the NOC from the council on record. And even my lord, on the same date his name was not shown. Caveator name has been shown. Even in the interim order passed by this honorable court, also the name of the council on record for Caveator has been shown. His name has not been shown. So therefore, question of informing him without our knowledge, how we can intimate the council. We have informed the Caveator. He was absent. Therefore, this court has issued the notice.
15/3/24 ಕಾಸ್ ಬೇಸ್ ತಗ್ಸಕ್ಕಾಗುತ್ತಾ? ಅವತ್ತು ಯಾರ ಹೆಸರು ತೋರಿಸಿದೆ?
24.
24. ನಮ್ ಕೋರ್ಟ್ದಲ್ಲ ಬಿಡಿ, ಇದು ನಮ್ ಕೋರ್ಟಲ್ಲ ಆಗಿರೋದು, ಬೇರೆ ಕೋರ್ಟು. ತಗ್ಸ್ಬೋದಾ? NOC ಇಲ್ಲ, ಅದ್ಯಾವಾಗ ಹಾಕಿರೋದು ಇದು?
January 2024.
24 ಜನವರಿಯಲ್ಲಿ. ನಿಮ್ದು ವಕಾಲತ್ ಇಲ್ಲ, ನಿನ್ನ ಹೆಸರಲ್ಲಿ ತೋರಿಸ್ತಾರೆ ಅಲ್ಲ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರ್ತಾರಲ್ಲ ವಿತೌಟ್ NOC ಅಂತ. ಆಯ್ತು. Registry is directed to produce the cause list dated 15/3/24 of this court. ಅದು ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಂಬರ್ ಏನು ಗೊತ್ತಾಗ್ತದ ಇಲ್ಲಲ್ಲ ಅವತ್ತು?
24 or 25 months.
ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಹಾಕಿದಾರೆ ನೋಡೋಣ. ಈವನ್ NOC ನಾಟ್ ಒಬ್ಟೈನ್ಡ್ ಅಂತ ಹೇಳಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇರುತ್ತೆ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ಅಲ್ಲ, what was the urgency in moving
My lord,
the
I have
matter
produced
in the
the
early morning and
Yes,
taking
my
of the matter at 2:30?
I have produced the document to show that the attachment warrant has been issued to take the possession of the.
Possession ಗೆ?
Yes. Attachment warrant has been issued, therefore we have moved the memo in the morning.
In the early morning
Yes, ma'am. Yes, ma'am. That court has taken after considering my submission. And after hearing, my lord, it was heard for a moment, half an hour it was heard.
But
And thereafter,
KVTR council ಇದ್ರ?
KVTR council ಇಲ್ಲೇ ಕೂತ್ಕೊಂಡಿರ್ತಾರೆ ಸ್ವಾಮಿ. ಅವ್ರಿಗೆ 2 ಸತಿ ಹೋಗಿ ನಾನು ಹೋಗಿ ಹೇಳಿ ಬಂದಿದ್ದೀನಿ. ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ, ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ ಅಂತ ಹೇಳಿ ಕೇಳ್ಕೊಂಡಿದ್ದೀನಿ ಅವ್ರ ಹತ್ರ. ಬಂದಿಲ್ಲ ಅವರು. ನನಗೆ ಅಟ್ಲೀಸ್ಟ್ he is my good friend, my lord. I cannot say, my lord, why I have not informed Mr. Ajit Shetty. Definitely I would have informed Mr. Ajit Shetty, my lord. He at least should have said.
Water sheet ಅಲ್ಲಿ put up ಆದ 15/3/24 water sheet ತೆಗೀರಿ ಹಿಂದೆ.
ಇನ್ನು ಇಂದ ಇಂಟ್ರಿ ಮಾಡರ್ಸ್ ಇವ್ರ ಹೆಸರಿಲ್ಲ ಸ್ವಾಮಿ. ಇಂಟ್ರಿ ಮಾಡರ್ ಕೂಡ ಇವ್ರ ಹೆಸರಿಲ್ಲ, ಅವ್ರ ಹೆಸರೇ ಇದೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರ?
ಆ ಇಂಟ್ರಿ ಮಾಡರ್ ಪಾಸ್ ಬೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ವಿ ಹ್ಯಾವ್
ಯಾವಾಗ ಗ್ರಾಂಟ್?
ಸೇಮ್ ಡೇ. ಅದರಲ್ಲಿ ಇವ್ರ ಹೆಸರಿಲ್ಲ.
ಮತ್ತೆ ತೋರಿಸ್ಬೇಕಲ್ಲ. Respondent ವಕಾಲತ್ is placed below since notice not yet ordered ಅಂತಿದೆ.
ಇವ್ರು ವಕಾಲತ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿಲ್ಲ, ಇನ್ನೂರು ಕೂಡ ಅಕ್ಸೆಪ್ಟ್ ಆಗಿಲ್ಲ.
KVTR ಆಲ್ರೆಡಿ ಆನ್ ರೆಕಾರ್ಡ್ ಇದ್ದು, ನೀವೇನ್ರಿ ವಕಾಲತ್? ಯಾವಾಗ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇದ್ರೆ ಯಾವಾಗ ತಗೊಂಡಿದ್ರಿ ಹೇಳಿ? ಈಗ ಆಫ್ಟರ್ 15/3 ಆರ್ ಈಗೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ? But he says already there was a delivery warrant ಏನು?
I have produced the document.
Attachment ಏನು?
Delivery warrant.
Delivery warrant.
ಹೌದು. Issue delivery warrant against JDR ಅಂತ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ನಾವು ಮೂವ್ ಮಾಡ್ಕೊಂಡಿದ್ದು. I have produced along with my statement of objection.
Final hearing ಮಾಡೋಣ ಬಿಡಿ. Instead of recalling that order.
Not with us to why the defense of adverse possession was not considered. What we have to see the written statement. At one breath.
Sorry, heard on IA 1 of 24 for recalling the order dated 15/3/24 along with statement of objections. And counsel appearing for the appellant would submit that there was a threat of delivery of possession and hence they moved the matter before this court in the early morning and matter was taken up in the afternoon. And also submit that he has already informed the KVTR counsel. And now the application is filed by the subsequent advocate who filed the wakalat later on. And earlier he has not obtained the NOC from the earlier KVTR counsel. And subsequent to this order dated 15/3/24, he has obtained the NOC. And having taken note of the said fact into consideration when this court already
14/3 months.
Framed the substantive question of law 15/3/24. It is appropriate to, instead of considering IA number 1 of 24, matter could be heard. And hence list this matter for hearing of the main appeal on date ಕೊಡಿ ಮೇಡಮ್, 2 ವಾರದಲ್ಲಿ. ಯಾವ ವರ್ಷದ ಸೂಟು? 2008. ಎರಡು ವಾರದಲ್ಲಿ ಕೊಡಿ ಮೇಡಮ್. 12/7. ಮೇನ್ ಅಪೀಲ್ heir ಮಾಡಿ. And accordingly, IA 1/24 is disposed of ಅಂತ ಹಾಕಿ.
67.
Harish HV.
I am for appellant.
12
12 days
days
delay.
Ah.
Suit to, I am for the plaintiff. Suit was one for redemption of mortgage. That is allowed, my lord. 2003 was the mortgage deed. The appellate court, my lord, considered that mortgage deed.
ಈಗ ರಿವರ್ಸ್ ಆಗಿದೆಯಾ?
Reversed.
Divergent pending ಇದೆ. I issue notice on IA 1/24 and also on main.
And,
List this matter on 29/7.
and in the meantime, records may be kindly be called for. Construction of the document is.
Meanwhile, registry is directed to get the records.
Please, ma'am.
You can divergent pending ಇದೆ.
Divergent pending.
68, parted in admission.
ಬಸವರಾಜ್
Basuvaraj
Kabaddi.
Kabaddi.
Last time, I think this matter was heard in part.
Please, Madam. The question was on whether the appellate court was right in holding that the will was not valid because it was executed under suspicious circumstances. In relation to that, my lord,
Suit
for partition filed by the daughter of the first wife, which was decreed. I went on appeal. Appeal dismissed. This is my second appeal. The defendant's second appeal.
Concurrent finding.
Concurrent finding.
What is the error committed by both the trial court as well as the first appellate court?
My lord, the most important point here, which I had not raised in the last hearing, is that this is a second suit for partition filed by the daughter. When the first suit was, she had filed only against her father, which was decreed. FDP was pending. FDP is still pending. And second suit was entertained. During the pendency of FDP, the father dies. So ideally, she should have filed an application in the suit itself for altering the preliminary decree. Now,
FDP itself.
in the FDP itself. Now, what has happened? She has got 1/4 share in that earlier decree. And now, out of the 3/4 given to the father, she has got half of that. So that is 3/8. So she is getting 1/4 plus 3/8, whereas the other only surviving second daughter is getting only 3/8. On this count alone, the suit itself.
What is the name of the father?
Name of the father is Siddappa, my lord.
Siddappa.
Siddappa. The family tree is at page number 5 of my appeal.
Have you raised the objection before the trial court? Second suit is not maintainable?
We have not, my lord.
Then?
My lord, this is a question of law. This is not, the trial court has recorded the filing of the older suit and pendency of the FDP. So even if I have not raised that.
Where is that observation?
Please,
Certified copy of the judgment and decree.
my lord, internal page number 4 of the RA, first appeal, my lord.
Earlier suit is OS number 380 of 93.
Please, my lord.
380 of 93.
380 of 93. How? FDP 3 of 2000. Internal page number 4, my lord.
Whether the plaintiff proves that the father of the plaintiff was given 3/4 share in the suit scheduled property as per the decree passed in, that is suit was filed by the father.
No,
earlier.
Illa. Suit was filed by the daughter.
Earlier. And father was allotted 3/4 share.
Howdu. ಆ ಸೂಟಲ್ಲಿ nobody else was party.
In the earlier suit.
In the earlier suit. ಅದಕ್ಕೆ father ಗೆ
Father was a party, defendant.
ಅದೇ only father. ಅಂದ್ರೆ I was not a party.
Plaintiff Siddappa had executed will in favor of his grandson Shivananda Swami pertaining to item 1 to 5, 7 and 9 to 10 of social property and dated so and so so and so.
My lord, execution of the will is after the first suit is decreed. Will came to be executed after the first suit is decreed.
Yes.
So that is I am not on will now.
That is his share, 3/4 share.
3/4 share. With respect to 3/4 share, will execute ಮಾಡಿದ್ದಾರೆ and validity of that will is questioned in this suit. However, the fact that earlier suit was filed and FDP is pending is not at all considered, though the facts are forthcoming.
Issue number 3 to 4, so 5 are answered as negative. Before
That
the
is with
calc-
respect to the will, my lord.
Will is negative.
That is with respect to will.
Hmm.
ಈ ಸೂಟೆ ಎಂಟರ್ಟೈನ್ ಮಾಡಬಾರ್ದಿತ್ತು.
But this suit is in respect of the property of the father. Second suit.
Property, ಹೌದು,
Second
property,
suit.
ಹೌದು. But that's a subsequent event before the FDP is concluded. So if the FDP is not concluded, finally,
Madam, after the death of the father only, the second suit is filed.
please, my lord,
That is in respect of the property which was allotted earlier in
Please,
favor
my
of the
lord.
father.
please.
How now you can contend that this suit ought not to have been entertained?
No, she should have gone in the older, in the FDP and told that the father has died and allot the share accordingly.
How?
My lord,
Unless there is a preliminary decree in respect of the property of the father who left the property, died intestate.
my lord, the law is settled with respect to multiple preliminary decrees being passed in a partition suit before the final decree is passed.
Here there is a dispute with regard to the even entertaining execution of the will by the father.
Please,
in
all
of
of
the
this should be
legatee.
raised in the
no,
first suit,
madam.
my lord. My lord, in 2005, when
Cannot
the,
contend that second suit is not maintainable.
my lord, when,
Hmm.
if I may draw an analogy, my lord,
Hmm.
when the amendment to the Hindu Succession Act came about in 2005, there was a direction that,
Copy of the earlier judgment.
adilla, my lord. It is
Earlier you have, earlier
first
the
suit dilla.
very plaintiff Jayamma has filed the suit
Huh.
against the father.
Huh.
Where is that copy of the judgment?
Adilla, trial court.
Take another. What happened that FDP now?
Pending ಇದೆ.
Earlier FDP also
Pending
still
ಇದೆ.
pending?
ಹಾ. Certified copy ಇಲ್ಲ, but.
Who are all the parties in the earlier suit?
Only father,
Only father.
only father.
Ah.
I tried to implement
Now the suit is filed against whom?
against the surviving
Who are
daughter.
all the surviving heirs, legal heirs of the father?
Illa, the second suit was, my lord, the second suit was also filed
Against whom?
against me, the surviving legal heirs.
How you are related to the family?
I am the son, daughter and son of, grandson of the second wife, my lord. Grandson,
Grandson of second wife.
please, my lord. Earlier suit to copy.
Then again, question of the validity of the marriage of second wife also. All these issues has to be considered.
My lord, it is admitted by the
You
plaintiff.
are not disputed the earlier decree.
I have not.
Then
I filed an appeal against the first decree.
Can you-
I failed.
issue notice against respondent. In the meanwhile, you get that copy of the earlier judgment.
Please,
Issue notice against respondent and call for records. This matter on the 30th of July.
oblige. My lords, in the interim,
What are release of notice of this?
my lord, stay, there is some difficulty happening on the ground. So stay of the appeal
Madam,
order.
there is a concurrent pending, no stay. Let the records come. ಆಯ್ತು ರಿಲೀಸ್ ಫ್ರಮ್ ಪಾರ್ಟರ್ಡ್ ಅಡ್ಮಿಷನ್ ಇದ್ದಾಗ ಪಾರ್ಟರ್ಡ್ ಅಂತ ಮಾಡಿರ್ತೀವಿ ಮೇಡಮ್ ಆಯ್ತು
Admission matter 69, Shailaja.
dispensation of notice to deputy commissioner.
Petition, my lord. This probate petition is filed for the last will of Mrs. Srimati Indramma, late Indramma. The probate petition is filed for the execute the last will of the probation for the last will of the Srimati Indramma. For the scheduled property A and B.
What are the scheduled properties? Is it a registered will?
No, my lord, it's an unregistered will.
Unregistered will?
Yes, yes. During the time of COVID,
In respect of the properties?
yes, my lord.
Immovable or?
Immovable property.
Immobile properties.
Yes, yes.
Why you are seeking for dispensation of notice against the deputy commissioner?
For the valuation of the property.
Now you have filed an application for dispensation of notice to deputy commissioner.
Yes, my lord.
Why you sought for dispensation? I am asking you. What are the properties? Immobile properties?
Yes, yes, my lord. Yeah, schedule A and B, immobile properties.
Where is your application for dispensation?
Your file.
Paper publication is there.
Yes, my lord.
2 of 52. Varanasi. She died at Varanasi.
Yes, yes, my lord. Yeah, Varanasi.
Properties are situated where?
Madhur district, my lord.
In Madhur.
Yes, my lord.
So, heard the appellant counsel on IA number 2 of 24. And in support of the application, an affidavit is sought to that undertaking to pay the maximum court fee as contemplated under the Karnataka Court Fees and Suits Valuation Act 1958. And for the reasons stated in the accompanying application, IA is allowed in dispensing the notice to the deputy commissioner. I heard on IA number 1 of 24, wherein prayer is made to take out the publication in the local newspaper, Kannada Prabha and Indian Express. And for the reasons stated in the accompanying application and affidavit. And property is also, ಎಲ್ಲಿರೋದು ಇದು ಪ್ರಾಪರ್ಟಿ ಮದ್ದೂರು.
Madhur, my lord.
ನೀವು ಯಾವ ಎಡಿಷನ್ ಕೇಳಿದಿರಿ?
Hindu and
ಯಾವ ಎಡಿಷನ್?
Kannada
ಕನ್ನಡ ಪ್ರಭಾ ಇದೆ, ಇಂಡಿಯನ್ ಎಕ್ಸ್ಪ್ರೆಸ್.
Indian Express. Yes, my lord.
ಯಾವ ಎಡಿಷನ್ ಅಂತ ಕೇಳಿದೆ.
Madhur.
ಪ್ರಾಪರ್ಟಿ ಮದ್ದೂರು ಇದೆಯಲ್ಲ?
Madhur ಅಲ್ಲಿ ಪಬ್ಲಿಷ್ ಮಾಡ್ತೀವಿ.
Prayer not specific. Madhur town. Madhur town ಅಂದ್ರೆ ಮೈಸೂರು ಎಡಿಷನ್ ಇವೆಲ್ಲ ಸ್ಟೇಟ್ ಲೆವೆಲ್ ಎಡಿಷನ್ ಯಾವ್ದು?
ಮೈಸೂರು ಬರ್ದ್ಮೇಲೆ. ಮಂಡ್ಯ.
And permitted to take out
Mandya district, my lord.
citation. ಯಾರು ಇಲ್ವಾ ಇವ್ರು ರಿಲೇಟಿವ್ಸ್ ಯಾರು ಬೇರೆ?
ರಿಲೇಟಿವ್ಸ್ ಇಲ್ಲ my lord. ಅವರ ಬ್ರದರ್ ಇದ್ರು, ಅವರು ಎಕ್ಸ್ಪೈರ್ ಆಗೋದು ಕೋವಿಡ್ ಇಂದ.
ಪಿಟಿಷನರ್ಗೆ.
ಎಸ್ my lord. Petitioner is
ರವೀಶ್.
ರವೀಶ್.
ಅವ್ರು ಇರೋದು ಎಲ್ಲಿ?
ಅವ್ರು ಇರೋದು ಬೆಂಗಳೂರು my lord.
ಸಂದ್ರ ಬೆಂಗಳೂರು.
Yes.
ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲಿದೆ. ರಿಲೇಟಿವ್ಸ್ ಯಾರು ಇಲ್ವಾ ಅಂತ ಕೇಳಿದೆ, ಎಲ್ಲಿದ್ದಾರೆ?
No, brother and mother both are expired and father also expired. But that certificate LRs ಇಲ್ಲ my lord.
LRs ಇಲ್ಲ. ಆಯ್ತು, ಮಂಡ್ಯ ಎಡಿಷನ್. Date. To take out the same on 15/7 on or before 15/7 and date is fixed for appearance 19/8.
70 adjourned 71. HN Basavaraju. SV
That the first respondent Savitramma is no more. Now, my lord, other LRs are already on record. I am filing a memo to treat the other respondent number 2 to 5 are the LRs of deceased respondent number 1.
The appellant counsel submits that R1 is no more and respondent number 2 to 5 are the LRs of deceased respondent number 1 and hence dispute illala and then the respondent also not disputes the said memo and hence memo is accepted. Appellant counsel is directed to amend the cast title in terms of the memo. ಒಂದೇನೋ ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಇದೆ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್
We will carry out. The trial court records are summoned. It's a divergent filing. Suit came to be dismissed and first appellate court reversed it. Against that, my lord, the divergent finding appeal is filed. Trial court records are called for, it is already received. Any date, my lord, you will lordship fix, we will argue the matter. First time it is, yes. It is there, I said it is received. Any date may kindly be fixed on that day, we will look into the original records and we will argue the matter.
Sure. In the meanwhile, the appellant counsel is also directed to amend the cast title in respect of R6 and R7 also. And records bandidella? Records already received and list this matter for admission along with records on 12/7.
Interim order is there.
Interim order idea? Interim order granted earlier is extended till next date of hearing.
Instead of 10/7, could it be on 14th onwards?
12/7.
Very.
Harish HV? Interim order ilva? Last time interim order extend agilla ante nodri. Yeah. Extend agilla last time interim order
hearing extend agilla.
Last time onde sarina ayat interim order extended till next date of hearing. Harish HV?
72.
Appear for the appellant, my lord. Plaintiff filed the second appeal, my lord. Plaintiff filed suit for injunction, my suit is decreed.
Suit is decreed and
First appellate court is
reversed the appeal.
finding, reverse finding, my lord. As per sale lead exhibit P5, my lord. I may purchase the suit scheduled property.
Is abated already abate agide?
R2 abated, my lord. My trial court reason, my lord, in page number, type copy, my lord. Page number 39, my lord. Cross examination, DW3 is purchased, my vendor is clearly admitted. I am in possession and enjoyment and borewell, my lord. And borewell receipt also produced. And DW2, dependent number 1 also admitted. I am in possession, my lord. Clearly, but first appellate court is, my lord, boundaries disputed the, that point, my lord, only set aside the first appellate court judgment, my lord. Typed copy in page number 39, my lord.
Yes.
Only to sale lead boundaries, but by mistake, my lord. I am in possession, my lord. Electrical bills and produce in the RTC produce, my lord. Tata extract also produce, my lord. Apply depend number also.
You purchase the property from the different number DW3.
See, my lord. Depend number 3 command possession is admitted, but boundaries also disputed my vendor, my lord. Command exam class DW2. I am in till then my possession. Borewells, my lord. Electrical bills is produced and RTC extract also produced, my lord. boundary disputed in the dependent number one, my lord. Dependent number one also purchased other land, same survey number, my lord.
When the boundary mentioning is a mistake, you are called upon to rectify it. Why you are not rectified it?
But now is a
Hmm?
defend, my
That
vendor.
is the evidence and appreciation by the first appellate court.
My lord. But dependent number three,
So
DW3,
DW3 being the vendor of both plaintiff and
vendor is
husband of
reverse.
defendant number one has deposed the boundaries mentioned in the sale deed.
is wrong
of
and
Plaintiff are wrong.
they also-
And he asked the plaintiff for its rectification. If the plaintiff is a law-abiding citizen, definitely would have rectified the boundaries instead of institution of the suit. The intention behind filing this suit clearly indicates she want to grab the property of defendant number one instituted towards western side. This is the
Okay.
observation.
only boundary is disputed, my
Hmm.
lord. My vendor is also come and reverse file, reverse oriented.
Yes, told. This matter is listed for admission. I heard anything to say, madam? Nothing. Heard the appellant counsel and also the counsel for the respondent. Having perused the material on record, the trial court granted the relief of the permanent injunction in favor of the plaintiff, and the same is reversed by the first appellate court, having considered the admission on the part of DW3 being the vendor of both plaintiff and husband of defendant number one has deposed the boundaries mentioned in the sale deed of plaintiff are wrong. And he asked the plaintiff for its rectification. And the same has not been done. And hence reversed it. There is a divergent finding with regard to the description of the properties concerned. And hence matter requires reconsideration. Admit. The following substantive question of law is framed. Whether the first appellate court erred in reversing the judgment of the trial court in not considering the exhibit P2 to 6. And also the material on record and whether the same amounts to its perversity. That's all.
Paper book may dispense.
Paper book, filing of paper book is dispensed. Only suit is for the relief of permanent injunction. List this matter for final hearing in the first week of August. Records ಬಂದಿದೆಯಾ? ಅಲ್ಲ? ಸರಿ. Okay.
73
For the appellant. Someone made some submission in the early morning, yeah? Huh? Okay. Substation,
My IA may be considered, my lord. That is
Madam,
fine.
IA?
To stay the operation of judgment and decree. It is a bare
IA
injunction.
filed in 2018.
ಮಾಡಿದ್ದು.
What is the
ಆಮೇಲೆ-
urgency now?
ಅಲ್ಲ, I have not moved the matter.
Counsel for the respondent Kvatar takes time on the ground that senior counsel is not in station. And counsel for the appellant is also present. This matter at 12:07.
Date, my lord?
12/7.
Court all move ಮಾಡಿದಾರ ನೀವ?
ಮಾಡಿ.
ಯಾರ ಮೂವ್ ಮಾಡಿದಾರಲ್ಲ ಮೆಮೊ? ನೀವೇ ಮೆಮೊ ಮಾಡಿ ನೀವೇ ಟೈಮ್ ಕೇಳಿ ಮತ್ತೆ? ಆಯ್ತು.
74.
Non-furnishing of copy of judgment invoice
My lords, I
number
appear for the
435.
appellant, my lords. Request for an adjournment, my lords. Senior is not in station. In fact, this matter,
Not in station, why you have not produced the copy of the judgment invoice?
my lords, the
435?
matter was heard by the previous bench in length, my lords. While hearing, it was directed that we have to produce that copy, my lords. We have informed the appellant.
That order was passed on 1/12/23. Almost.
Please, my
6
lords,
months
that
has
is
been elapsed.
99 judgment copy, my lords. We are not able to get it. We have informed them, my lords. That is with respect to different property, my lords. That is why we are producing that judgment, my lords.
Main contention, adene, why you are not producing the judgment?
That is what, my lords, we have informed them, my lords, together along with the judgment, and we will argue the matter, my lords. 10 days time may be granted.
The
my lords.
appellant counsel again seeks time to produce the copy of the judgment passed in OS number 435 of 1999. And counsel for the respondent also contend that the res judicata applies. And hence the copy of the earlier judgment is also necessary to decide the issue involved between the parties. And hence another 2 weeks time granted to produce the same. List this matter on 12/7.
Grateful.
75, Sachin BS.
Please, for the appellant.
Hmm.
Plus, this is a divergent finding.
Hmm.
Suit for declaration and relief of possession.
Here partly decreed.
Trial court dismissed the suit.
Hmm.
First appellate court decreed the suit in
Earlier-
respect of
earlier
title is concerned.
In the appellate court, it decreed partly
Insofar as title is concerned, appellate court.
as owner,
Yes, please,
possession, and also the permanent injunction is dismissed.
please. Idರಲ್ಲಿ first appellate court appointed the court commissioner. A court commissioner records ಬೇಕಾಗ್ತದೆ. Records ಬಂದಿಲ್ಲ.
2018 matter, 2006.
Appeal,
ಲಿಸ್ಟ್ ಆದ್ರೂ ಈಗ ಆ ರೆಕಾರ್ಡ್ ಬೇಕು, ಈ ರೆಕಾರ್ಡ್ ಬೇಕು, ಏನ್ರಿ ಇದು?
ಕೋರ್ಟ್ ಕಡೆಯಿಂದ ತರಿಸಿದ್ರೆ ಅದು ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗ್ತದೆ.
The appellant counsel seeks time on the ground that
ಟೈಮ್ ಅಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ತರಿಸ್ಬೇಕಾಗ್ತದೆ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್.
ಏಕೆ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ?
ನಮ್ಮ ಹತ್ರ
ರೆಕಾರ್ಡ್ ಇಲ್ಲೇನ್ರಿ? ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಅದ್ರ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಹಾಕ್ಬೇಕು. ಇಫ್ ನೆಸರಿ ಓನ್ಲಿ ವಿಲ್ ಕಾಲ್ ಇಟ್. ನೀವ್ ಹೇಳ್ಬೇಕು. ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಾ? ಅದು ಇದೆಯಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಲ್ಲ, ಒಟ್ನಲ್ಲಿ ಟೈಮ್ ಬೇಕಷ್ಟೇ. ಒಟ್ನಲ್ಲಿ ಟೈಮ್ ಬೇಕಲ್ಲೇನ್ರಿ? ನೀವ್ ಕೇಳಿದ್ದು ಇದೆ ನೋಡಿ ಅಲ್ಲಿ. ಓದಿಲ್ಲ,
ಓದಿದ್ದೀನಿ.
ಅದೇ ಕತೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಆ ರೆಕಾರ್ಡ್ ಬೇಕು, ಈ ರೆಕಾರ್ಡ್ ಬೇಕು ಅಂತ. ನೋಡು, appellant counsel seeks time. List this matter on 12/7.
76.
ಅಡ್ಮಿಷನ್ ಅಲ್ಲೂ ರೆಡಿ ಇರಲ್ಲ, ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲೂ ರೆಡಿ ಇರಲ್ಲ, ಮತ್ತೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್?
76.
76.
Suit for partition and separate possession and mean profits, my lord. On A and B schedule properties. The respondent number 1 to 5 are the plaintiffs. my lord.
ಇದೆ, ಸ್ವಲ್ಪ ಮಾಡಿಫೈ ಮಾಡಿದ್ದಾರೆ. ಪಾರ್ಟ್ಲಿ
Yes,
ಡಿಗ್ರಿ
my lord.
ಅಲ್ವಾ?
Regarding B
Sharing
schedule properties.
1/3 in B schedule property. And the same has been set aside, partly decreed, plaintiff number 1 to 5, 128 share. In respect of D 16 to 21 dismissed. Call for records.
One more appeal is filed by the appellants, my lord.
ಅವ್ರು ಹಾಕಿದಾರ?
ಇಲ್ಲ, ನಾವೇ ಇನ್ನೊಂದು ಅಪೀಲ್ ಹಾಕೋಣ. 2 ಆರ್ಯಗಳು ಹಾಕಿದ್ವಿ.
ಇನ್ನೊಂದು ಹಾಕಿದ್ದೀರಾ?
ಹೌದು, ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆ.
ನಂಬರ್ ಹೇಳಿ.
RSA 1445 of 2018.
45 of 18.
Yes, my lord.
ಎರಡು ಒಟ್ಟಿಗೆ ಫೈಲ್ ಮಾಡಿದಾರಲ್ಲ, ಮತ್ತೆ ಒಟ್ಟಿಗೆ ಹಾಕ್ಸ್ಕೋಬೇಕಿತ್ತಲ್ಲ?
ಇಲ್ಲ, ಡೇಟ್.
So appellant counsel submits that already one more RSA is pending and notice has been ordered in RSA 1445 of 2018. And hence issue notice in this appeal also against the respondents and call for records, list both the matters on 29/7.
77. Kirtidar Kolar.
Kirtidar Kolar, compliance of office objection raised on NOC Wakalat filed by the Sridhar and Hegde.
Please.
ಏನ್ರಿ ಇದು?
NOC Wakalat Melad, the signature of appellant number 2 to 5 does not tally with the earlier Wakalat anta ide. I will clarify it. Earlier Wakalat alli ಅವರು ಕನ್ನಡದಲ್ಲಿ ಮಾಡಿದ್ರು, ಈಗ NOC Wakalat alli ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ objection. One more objection is
the learned senior advocate undertakes to file appointment, submits that he is going to file wakalat in the registry today. His registry is directed to put up the wakalat and ಮಾಡಿದೆ, ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಈಗ ಡೌಟ್ ಇದೆ ಅಂತ. ಈಗ ಮೊದ್ಲಿನ ವಕಾಲತ್ಗೂ ಈಗಿಗೂ ಡಿಫರೆನ್ಸ್ ಇದೆ ಅಂತ. ಹೇಳಿ. ಕಂಪೇರ್ ಮಾಡ್ತೀರಾ? ಕ್ಲಾರಿಫೈ ಮಾಡ್ತೀರಾ?
ಕ್ಲಾರಿಫೈ ಮಾಡ್ತೀನಿ. ಯಾಕಂದ್ರೆ ಅದರಲ್ಲಿ ಮತ್ತೊಂದು ವಕಾಲತ್ತು ತಗೊಂಡಿದೀವಿ, ಈ ವಕಾಲತ್ತಲ್ಲಿ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲೇ ಮಾಡಿದಾರೆ. ಒಂದು ಮೂರು ವಕಾಲತ್ ಟೈಮ್
JM ಉಮೇಶ್ ಮೂರ್ತಿ ತೋಳ್. Appellant counsel seeks 1 week time to clarify with regard to the office objection in respect of the wakalat. And hence list this matter on 12/7.
Please.
Kanath Kumar Shetty case.
Last time I had.
ಏನೋ ಮೆಮೋ ನಾನ್ ಫೈಲಿಂಗ್ ಅಪ್ ಇದೆ.
ಅದು ಮೆಮೋ ಬಂದಿಲ್ಲ ಸಿಗ್ನೇಚರ್ ಆಗಿ, ಬಂದ ನಂತರ.
ಏನ್ ಮೆಮೋ ಅದು?
ವಿಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ.
ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ.
ಹೌದು, ವಿಡ್ರಾ ಮಾಡ್ತೇನೆ ಅಂತ
So,
ನಾನು
appellant
ಮೆಮೊ
counsel-
ಕಳಿಸಿಕೊಟ್ಟಿದ್ದೇನೆ.
Appellant counsel seeks
One more week.
one week to file the memo and hence list this matter on 5/7.
ಆಗ್ಬೋದು. 5/7 ಬೇಡ.
ಯಾವ
7/7, 8/7.
8/7.
8/7.
79.
79
From
Prabhu
Pradar.
Dar. Ajay Prabhu.
Plaintiffs appeal.
Ready ಇದೀರಲ್ಲ? ಮಧ್ಯಾಹ್ನ 2:30.
My lord,
2:30.
2:30, a lot matters, ಮುಗಿಸ್ಕೊಂಡ್ ಬರ್ತೀನಿ ಸ್ವಾಮಿ.
ಮುಗಿಸ್ಕೊಂಡೇ ಬನ್ನಿ. ಪರವಾಗಿಲ್ಲ.
Serial number 80.
Serial number
18.
80.
80. 80.
ಹಾ ಹೇಳಿ.
ಅದೇ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಷನ್.
ಹಾ?
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಷನ್.
ಅದೇ ಇರುತ್ತೆ ನೆಕ್ಸ್ಟ್ ಇದು ಅಡ್ಮಿಷನ್ಗೆ.
ಅದೇ ಅದು I have to produce 2-3 documents.
ಹಾ.
The trial court, it is a suit for specific performance. And the trial court dismissed my suit on the ground that during pendency of the case, my PA holder executed an settlement deed and I executed an agreement of sale in favor of the defendant number 2. Relying upon these 2 documents, as well, my suit came to be dismissed. These 2 documents, as per the witnesses' evidence given by the parties, it is not proved at all. And they admits that I have not signed any such agreement.
Whether those documents are placed before the trial court or not.
That document is placed, but it is not, their own witnesses admits that it is not, I am not signed the documents.
But that is the document of part of the records.
Yes, that only thing is,
Why you are seeking time now?
only thing is, that document is placed on record. It would be easy for to convince your lordships,
Records
only for that reason.
ಇಲ್ಲಲ್ಲ? ಹಾ.
ಅದೇ 2 ಕೋರ್ಟ್ನವ್ರು ಅದನ್ನ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. If that is considered, I have executed ಅಂತ ಹೇಳಿ ಅವ್ರು ಏನ್ ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂಡಿದ್ದಾರೆ, it will prove that that I am the document executed.
ಎಷ್ಟು ದಿವಸ ಬೇಕು?
ಏನ್ ಬೇಡ, 1 ವಾರ ಸಾಕು.
ಏನ್ ಬೇಡ? ಒಂದು ವಾರ ಸಾಕು.
ಒಂದು
2018 ಡಾಕ್ಯುಮೆಂಟ್ ಇಟ್ಕೊಳ್ಳಿ. ಏನ್
ಪಾಪ ಅವ್ರು ಇಬ್ರು ಲೇಡೀಸ್, ಒಬ್ರು ಸತ್ತೋದ್ರು, ಇನ್ನೊಬ್ರು ಮೊನ್ನೆ ಒಬ್ರು ಬಂದಿದ್ದಾರೆ. ಆಗ
counsel seeks 1 week time.
Yes.
Counsel for the respondent ಯಾರು? ನೀವ್ ಯಾರಿಗೆ? ನೀವಲ್ವಾ? ಯಾರು ಇಲ್ವಾ ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್?
Respondent number 7, my lord.
ಅದರ್ ಸೈಡ್ ನೀವು ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲಲ್ಲ, ಟೈಮ್ ತಗೊಂಡು.
ಇಲ್ಲ, ನಾನು ಅವ್ರು ಬರ್ತಾರೆ ಇಲ್ಲೇ ಹೇಳ್ಬಿಟ್ಟೇನೆ.
ಕೌನ್ಸಿಲ್ ಯು ಆರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಹೂಮ್?
Respondent number 7, my lord. 7. ಜಯಮ್ಮ ಅಂತ.
ಆಟೋ ಇಲ್ಲ ಯಾರು ಇಲ್ವಾ ಮೇಡಮ್?
Sir, 80 ಅಲ್ಲ.
80. Serial number 80 ಅಲ್ಲಿ. 80.
80 ನಿಂದ ಕೇಸ್ ಅಲ್ವಾ?
ಶ್ರೀಕಂಠ
ಹೌದು.
ಹೌದಾ, ಅದರಲ್ಲೇ
ವಿಶ್ವನಾಥ್ ರೆಡ್ಡಿ ಏನೋ ಮತ್ತೇನೋ TMS ನಾರಾಯಣ್ ಫಾರ್ ಆಟೋ. MS ಅದು ಆಯ್ತು.
MS ನಾರಾಯಣ್.
ನೀವು ಯಾರಿಗೆ R2ಗ?
R7
R7 ಯಾರು ಇಲ್ರಿ ಇಲ್ಲಿ?
ಹೌದು ಮೇಡಮ್.
ಬೇರೆ ಕೇಸ್. ಸೀರಿಯಲ್ ನಂಬರ್
80
ಯಾರು ಇಲ್ವಲ್ಲ?
ನನಗೆ ಅಪೀಲ್ ಕಾಪಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ
R1 and R2 ಬಿಟ್ರೆ ಯಾರು ಇಲ್ಲ.
I represent ಜಯಮ್ಮ ಮೇಡಮ್. ಅದರಲ್ಲಿ ಜಯಮ್ಮ.
ಕೌನ್ಸಿಲ್ ಫಾರ್ R2 is present. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 1 week ಏನಾಗಲ್ಲ ಕೊಡಿ. 5/7. 5/7 ಹೇಳಿ ನಿಮ್ದೇನು?
ಮಚ್
6 ಎಲ್ಲ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಈಗ ಯಾವ್ದು ತಗೊಳ್ಳಲ್ಲ. ಅಡ್ಮಿಷನ್, ಫೈನಲ್ ಇಯರಿಂಗ್ ಏನಾದ್ರು ಮೆನ್ಷನಿಂಗ್ ಇದ್ರೆ ಮಾಡ್ಬೋದು.
ಸ್ವಾಮಿ 5 ಬೇಡ, ಒಂದು ಬೇರೆ ಕೇಸ್ ಎಲ್ಲ ಅವತ್ತೇ ಲಿಸ್ಟ್ ಆಗಿದೆ. 6ನೇ ತಾರೀಕು.
6 ವರ್ಕಿಂಗ್, 6 ಸಾಟರ್ಡೆ ಇಲ್ಲ.
ಮಂಡೇ
8/7.
8 ಮಚ್
ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಕೇಳೋದಿಲ್ಲ. ಯಾವ್ದಾದ್ರು ಫೈನಲ್ ಇಯರಿಂಗ್ ಏನಾದ್ರು ಮೆನ್ಷನ್ ಮಾಡಿದಾರೆ?
Serial number 81, my lord.
81 ಹೇಳಿ. ಯಾರು ಬೆಳಿಗ್ಗೆ ಏನೋ ಮೆನ್ಷನ್ ಮಾಡಿರ್ಲ ಯಾರು?
Yes, my lord. I am appealing for the appellant.
DK ಚಂದ್ರಶೇಖರ್ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರಾ?
Yes, my lord. I informed him.
Intimate ಮಾಡಿ. Appellant counsel seeks. Your counsel, you are appearing for respondent. Now they are seeking. So, appellant counsel seeks time and counsel for the respondent also present and says no objection. Dismiss matter on 12/7.
86 ಮಾಡೋಣ.
86 ಹೇಳಿ ಏನಾಗಬೇಕು?
I need
11th ಹಾಕೊಡ್ರಿ. 11th.
12/7. ಬಡವಾ 11th.
afternoon.
11th 11th working ಅಲ್ಲ? 86 ಹೇಳ್ರಿ. MS ನಾಗ ಸ್ಫೂರ್ತಿ ಹೆಗಡೆ.
I have little, my lord, suit for partition.
ಸ್ಫೂರ್ತಿ ಹೆಗಡೆ ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ?
ಹೇಳ್ತೀನಿ ಈಗ.
ಹೇಳಿದಿರಾ?
My lord, I will inform.
ಹೇಳ್ಬಿಟ್ಟು ಮನ್ಸನ್ ಮಾಡಿ 2:30. ಇಬ್ರು ಇದ್ರೆ ಮಾತ್ರ ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಇಲ್ಲವ್ರಿಲ್ಲ.
ADLR ಬಂದಿದೆ. ಆಮೇಲೆ ಕೊಟ್ಟಾಗ ಫೈಲ್ ಕೊಡ್ತೀನಲ್ಲ ಹೇಳಿ. ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ. ಹಾ 2 ಪಾಸ್ ಓವರ್ ಇದೆ ಸರ್ ಅದಾದ್ಮೇಲಿಂದ. ಆಯ್ತು. ಇಲ್ಲ ಸರ್ ನೀವಿರ್ಬೇಕು. ಹೌದು 2:30ಗೆ.
Court officer? Madam, court officer, madam? Hello?
ಹೇಳಿ ಸರ್ 11ಗೆ
ಏನಿಲ್ಲ 11th ತಾನೇ ಅದು 10th ಅಲ್ಲಿ 11th ಹಾಕೊಡಿ ಅಂತ ಹೇಳಿದೆ.
ಹಾಕಿದ್ದಾರೆ
81 ಸೀರಿಯಲ್ ನಂಬರ್ 81.
ಹೌದು ಸರ್ 11ಗೆ ನೀವು
PKC ಸರ್ ಮಾಡಿದ್ದಾರೆ
thank
date
you.
ಕೊಟ್ಟಿದ್ದಾರೆ ನೀವು ಊಟ ಮಾಡಿ ಊಟ ಮಾಡಿ ಅಂದೆ.
Thank you. Yes, sir, thank you.
ಕೊಟ್ಟಿದ್ದಾರೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನಾಗಿದೆ ಅಂತ ಮೋಸ್ಟ್ಲಿ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ. ಕೌನ್ಸಿಲ್ಸ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಕಾಂಪ್ರಮೈಸ್ ಆಗುತ್ತೆ. ಏನಾಗಿದೆ?
1/7 date ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮೇಡಮ್ ನಮಸ್ಕಾರ ಸೀರಿಯಲ್ ನಂಬರ್ 99 ರೀಚ್ ಆಗುತ್ತಾ?
ಎರಡೇ.
ನಾಲ್ಕೈದು ಮಿಕ್ಕಿದೆಲ್ಲ ಮಾಡಿದ್ದೆ 30 ಇತ್ತು. 4 ಉಳಿದಿತ್ತು. 2 ನೋಟ್ ಬರ್ಬೇಕು ಎಕ್ಸರ್ಸ್ ಆಯ್ತು. ಇನ್ನೆರಡರಲ್ಲಿ 1 ಸ್ಟಿಚ್ ಮಾಡ್ಬೇಕು. ಇನ್ನೊಂದು ಕೈ ಹಾಕಿತ್ತು ಅದು ಹಾಕಿ 1960 ಹಾಕಿದ್ವಿ.
ಯಾವಾಗ ಹಾಕಿದ್ದೀರಾ?
1960 ಹಾಕಿ.
ನಿಮ್ಗೆ ಫೈಲ್ ಇದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್, ಇಲ್ಲ ಅಂದ್ರೆ
1960 ಇಯರ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಈಗ ಮಾಡಕ್ ಕೊಡ್ತೀರೋ ಅಥವಾ ನಾ ಕೆಳಗಡೆ ಹೋಗಿ ಮಾಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಿಲ್ಲ. ನಂಬರ್ 88 ಕೊಡ್ತೀರಾ?
ಎರಡಿದೆ. ಯಾರೋ ಅದು ಫೈಲ್ ಕೊಡ್ತಾರೆ.
ಸುಮಾರು ನಾನು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದೆ ನಿಮ್ಗೆ ಏನ್ ಕೊಟ್ಟು ನಮ್ದು ಎಲ್ಲ ಕೇಳಿದ್ದೀನಿ.
55 ಕಂಪ್ಲೇಂಟ್ಸ್ ಇವತ್ತಿಗೆ ಮಾಡಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಫೈಲ್ ಇಲ್ಲ, ನಾಳೆ ತಗೊಳ್ಳಿ. ನಾಳೆ ಬರುತ್ತೆ, ಇವತ್ತಲ್ಲ, ಚೇಂಬರ್ ಅಲ್ಲಿ ಇದೆ ಅದು. ಕೊಡಿ. ಅವೆರಡು ಮಾಡಿದ್ದೀರಾ? ಅದೇ ಟೈಪ್ ಕಾಪಿ ಆಫ್ ಡಿಗ್ರಿ ಆಮೇಲೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 3 ಇನ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ stated dead but arrayed as a party before this court. ಅದನ್ನ ನೀವು ಮಾಡ್ಬೇಕು. ಇಲ್ಲಿ ಯಾಕೆ ಮಾಡಿದ್ರಿ ಮತ್ತೆ ಅವ್ರನ್ನ? ಕೇಳ್ಬಿಡಿ. ಏನಂತ ಆರ್ಯನಲ್ಲಿ ಇರ್ಲಿ ಸರ್, ಅಂತದನ್ನ ಇಲ್ಲಿ ಮಾಡಿರ್ಬಾರ್ದಾಗಿತ್ತು ಅವಾಗ. ಏನಾದ್ರು ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಅಲ್ಲ. ಅಬೇಟ್ ಆದ್ಮೇಲೆ ಅದೇ ಇಲ್ಲಿಗೆ ತಗೊಂಬಂದ್ರೆ ಅವಾಗ ನಮ್ಗೇನು ಗೊತ್ತಾಗಲ್ವಲ್ಲ. ಇಲ್ಲಿಗೆ ಡೆಡ್ ಪರ್ಸನ್ ಮೇಲೆ ಆಗೋಗಲ್ವಾ? ಆಯ್ತು, ಮಾಡ್ಬಿಡಿ ಆಮೇಲೆ.
ಬಟ್ ಅದ್ರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದ್ವಿ 4 ಇತ್ತು, 2 ಓವರ್ ರೂಲ್ ಮಾಡಿದ್ವಿ ತಾವೇ.
ಹೌದು,
ಇನ್ನೊಂದು ಸ್ಟಿಚ್ ಮಾಡ್ಬೇಕಿತ್ತು.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿ ಆಮೇಲೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರಿ.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ ನಾನು. ಅಪ್ಲಿಕೇಶನ್ ಕೂಡ ಹಾಕಿದ್ದೀನಿ, 19/6 ಹಾಕಿದ್ದೀನಿ. ಆಫೀಸ್ ಮೇ ಬಿ ಡೈರೆಕ್ಟೆಡ್ ಟು ವೆರಿಫೈ.
ಏನ್ ವೆರಿಫೈ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ, ನಾನು ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದ್ದೀನಿ, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಪೋಸ್ಟ್ ಮಾಡ್ತಾರೆ.
ಏನೋ
ಏನಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಿ ನೀವು?
ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಿತ್ತು, ಅದನ್ನ ಹಾಕಿದೀವಿ.
ಯಾವಾಗ ಹಾಕಿದಿರಿ?
19/6 26 ಹಾಕಿದ್ವಿ.
25/6
25/6 ಒಳಗೆ ಮಾಡ್ಬೇಕಿತ್ತು.
ಫೈಲ್ ತರ್ಸ್ ನೋಡಿ ಮೇಡಮ್, ಯಾವಾಗ ಏನ್ ಮಾಡ್ಬೇಕಿತ್ತು?
25/6 ಒಳಗೆ ನಾನು ಮಾಡ್ಬೇಕಿತ್ತು. 28 ನಾನು ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಅಪ್ಲಿಕೇಶನ್.
ನೋಡಿ ಮೇಡಮ್,
ಮಾಡ್ಬೇಕಿತ್ತು, ಅದನ್ನು ಮಾಡಿದ್ದೀನಿ.
ಫೈಲ್ ತರ್ಸ್.
ಓವರ್ ರೂಲ್ ಮಾಡಿದ್ದೀನಿ.
ಆಯ್ತು, ಫೈಲ್ ತರ್ಸ್ ನೋಡೋಣ. ನಾನು ಓವರ್ ರೂಲ್ ಮಾಡಿ ರಿಮೈನಿಂಗ್ ಟೈಮ್ ಮಾಡಿದ್ದೀನಿ, ಆದ್ರೂ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ದೀನಿ. ಮಿಕ್ಕಿದ್ದು ಒಟ್ಟು 30 ಇತ್ತು, 26 ಮುಂಚೆನೆ ಮಾಡಿದ್ದೆ.
ಆಯ್ತು ನೋಡಿ.
ಪ್ಲೀಸ್
ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ seal number 6, ಹೇಮಂತ್ ರಾಜ್.
Cost is paid. One certified copy of the decree also should furnish. There are 2 office objections. For a moment, kindly see the
council submits that he has paid the cost. ಆಮೇಲೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಏನ್ ಕೊಡ್ಬೇಕಿತ್ತು? ಕೊಟ್ಟಿದ್ದೀರಿ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ಸ್ಟಿಚ್ ಮಾಡಿದ್ದೀನಿ. ಟೈಪ್ಡ್ ಕಾಪಿ
ಅದನ್ನು ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ. 60 ಅಲ್ಲಲ್ಲ, ಅದ್ರಲ್ಲಿ ಸ್ಟಿಚ್ ಮಾಡಿದ್ದೀನಿ, ಕಂಟಿನ್ಯೂ ಮಾಡಿದ್ದೀನಿ, ಸ್ಟಿಚ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ ಆಲ್ರೆಡಿ.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಜಸ್ಟ್
ಇವತ್ತು.
ಇವಾಗ ಡಿಗ್ರಿ ಟೈಪ್ಡ್ ಕಾಪಿ.
ಟೈಪ್ಡ್ ಕಾಪಿನಾ?
ಹೌದು, ಡಿಗ್ರಿ ಟೈಪ್ಡ್ ಕಾಪಿ.
ಡಿಗ್ರಿ ಟೈಪ್ಡ್ ಕಾಪಿ ಅದೇ ಇರ್ಬೇಕು. ಒರಿಜಿನಲ್ಸ್ ಏನ್ ಡಿಗ್ರಿನೇ ಇರ್ಬೇಕು ನೋಡಿ.
ಆಮೇಲೆ ಒಂದು ಸಬ್ಮಿಷನ್ ಸರ್,
the typed copy of
ಅಲ್ಲ ಒಂದು ಸಬ್ಮಿಷನ್
OS decree is also produced. ಆಮೇಲೆ
ಒಂದು ಸಬ್ಮಿಷನ್ ಅದರಲ್ಲಿ. ಫಾರ್ ಅ ಮೂಮೆಂಟ್ ಕೈಂಡ್ಲಿ ಡಿಗ್ರಿ ಪೇಜ್ ನಂಬರ್ 65 ಕಾಪಿ ಲೆಜಿಬಲ್ ಇದೆ, ನಾನು ನೋಡ್ಕೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ, ಕ್ಲಿಯರ್ ಆಗಿದೆ. ಇನ್ಸ್ಪೈಟ್ ಆಫ್ ದಟ್ ಆಫೀಸ್ ಹ್ಯಾಸ್ ರೈಸ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
ಅಲ್ಲ, ಲೆಜಿಬಲ್ ಕಾಪಿ ಕೊಡಿ, ಟೈಪ್ಡ್ ಕಾಪಿನ ಅವರು ತಕರಾರು.
ಪೇಜ್ ನಂಬರ್ 65 ದಯವಿಟ್ಟು ಒಂದ್ಸಲ ನೋಡಿ. ಪೇಜ್ ನಂಬರ್ 65 ಡಿಗ್ರಿ ಕಾಣುತ್ತೆ, ಓದಕ್ಕೂ ಬರುತ್ತೆ ಸ್ವಾಮಿ. ಅದ್ರ ಮೇಲೆ 3 ಸಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬಂದಿತ್ತು.
ಅಂದ್ರೆ ಜೆರಾಕ್ಸ್ ಸರಿ ಇಲ್ಲ ಅಂತ
ಅಲ್ಲ, ಚೆನ್ನಾಗಿ ಕಾಣುತ್ತೆ ಸ್ವಾಮಿ, ಅದು ಓದಕ್ಕೂ. 65 ನೋಡಿ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿನೇ ಅದು.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿನೇ, ಬಟ್ ಟೈಪ್ಡ್ ಕಾಪಿ ಕೊಡಿ ಅಂತ ಅದೊಂದು
ನೀಟಾಗಿ ಕಾಣುತ್ತೆ. 60 ಅದು ಒರಿಜಿನಲ್ ಕಾಪಿನೇ ನೀಟಾಗಿ ಕಾಣ್ತಾ ಇದೆ. ನಾನ್ ನೋಡ್ಲಿಲ್ಲ, ಇವಾಗ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೋಡ್ತೀನಿ, ನೀಟಾಗಿ ಇತ್ತು ಅದು.
ನಿಮ್ ಕಣ್ಣಿಗೆ ಚೆನ್ನಾಗಿ ಕಾಣುತ್ತ್ರಿ, ನಾವೆಲ್ಲ ಮುದುಕರು, ನಮಗ್
ನಿಮಗೆ ಇಲ್ಲ ಸ್ವಾಮಿ, ನಿಮಗೆ
ನಮ್ ಕಣ್ಣಿಗೆ ಕಾಣ್ಬೇಕು, ನಮ್ ಕಣ್ಣಿಗೆ ಕಾಣ್ಬೇಕಲ್ಲ.
ಆಯ್ತು,
ಓಕೆ. anyhow you have complied it. ನೆಕ್ಸ್ಟ್ ಏನ್ ಹೇಳಿ?
ಅದರಲ್ಲಿ ಒಂದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಬೇಟ್ ಆಗಿದೆ ಅಲ್ಲಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಬೇಟ್ ಆಗಿದೆ ಅದು.
ಸತ್ತವನ್ಗೂ ನೀವು ಪಾರ್ಟಿ ಮಾಡಿದಿರಿ ಅಂತ.
ಬಟ್ ಅದು ಜಡ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಗ್ರಿಯಲ್ಲಿ ಸೇಮ್ ಆಸ್ ಇಟ್ ಈಸ್ ತೋರಿಸಿದ್ರು. ಅದು
ಅಬೇಟೆಡ್ ಅಂತ ಇದೆಯಲ್ಲ,
ಅಬೇಟ್ ಅಂತೂ ಮಾಡಿಲ್ಲ.
ಈಗ ನೀವು ಪಾರ್ಟಿ ಮಾಡಿದಿರಲ್ಲ, ಯಾರನ್ನ ಏನಂತ ಮಾಡಿದಾರ ಅವರು? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ವೆರಿಫೈ ಮಾಡಿದಿರ ನೀವು? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಶ್ರೀಮತಿ ಭೈರಮ್ಮ ಅಂತ ಏನೋ ಪಾರ್ಟಿ ಮಾಡಿದಿರಲ್ಲ,
ಅಬೇಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಬೇಟ್ ಆಗಿದೆ ಅಂತ.
ಎಲ್ಲಿದೆ ಅಬೇಟೆಡ್ ಅಂತ ಮೇಡಮ್? ಆರ್ಯ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಶ್ರೀಮತಿ ಭೈರಮ್ಮ ತಾನೆ? ಭೈರಮ್ಮ. ಭೈರಮ್ಮ ತಾನೆ ಅಪಲೆಂಟ್? ಯಾರು ಅಪ್ಡೇಟ್ ಹೇಳಿ? ಗಂಗಾ ಅನ್ವಯ. ಹಾ, ಏನಾಗಿದೆ? ಬರ್ದವ್ರ ಗಂಗಾನ್ಮಯ್ಯ ಇಸ್ ನೋ ಮೋರ್ ಅಂತಲ್ಲ, ನಿಮ್ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಇದೆ ನೋಡಿ.
I will delete it.
R3 ಡೆಡ್ ಅಂತ ಇದೆ.
I will delete as abated.
ಅಲ್ವಾ? Hold. Remaining one office objection regarding R3 is dead. Council 6 1 week time.
ಅಲ್ಲ ಅಲ್ಲಿ ಇಲ್ಲೇ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಮತ್ತೆ ಅದಕ್ಕೆ
ಹಾ,
ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ ಇಲ್ಲೇ ಡಿಲೀಟ್ ಅಂತ ಮಾಡ್ಬಿಡ್ತೀನಿ.
ಸಬ್ಮಿಷನ್ ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು ಡೆಟ್
ಬರ್ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ, ಇದನ್ನೇ
ಡಿಲೀಟ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಮಾಡಿ 1 week ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಬರ್ತದೆ.
ಇಲ್ಲೇ ಮಾಡ್ಬಿಡ್ತೀನಿ sir. ಮತ್ತೆ ಫೈಲ್ ಸಿಗೋದಿಲ್ಲ ಅಲ್ಲಿ ಹೋದ್ಮೇಲೆ ಅಲ್ಲಿ.
Told, and the council submits that the R3 who is no more, he may be permitted to delete him and hence permitted to delete. ಆಯ್ತು, ಮುಗಿಸಿ. Post the matter for admission on 12/7.
36.
ಬರ್ಲೇ ಅಲ್ವಾ? ಏನಾಯ್ತು? ಪಾಸ್ ಅವರ್ ಆಯ್ತು.
ಮಂಜುನಾಥ್
ಬೆಳಗ್ಗೆ ಏನಕ್ಕೆ ಇಟ್ಕೊಂಡ್ರಿ ಇದು? ಕಾಸ್ಟ್ ಕಟ್ತೀನಿ ಅಂದ್ರೆ.
ಕಾಸ್ಟ್ ಕಟ್ತೀವಿ ಅಂತ ಹೇಳಿ.
ಹಾ, ಏನಾಯ್ತು?
ಕಟ್ಟಿದ್ದೀನಿ.
Council submits that he has paid the cost. Non-compliance ಗೆ
ಕಂಪ್ಲೇಂಟ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಡ್ಬೇಕು, ನಾನು ಅಷ್ಟೇ ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀನಿ. OS ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಅಲ್ಲಿ ಸಿಗ್ತಾ ಇಲ್ಲ. ಫೈಲ್ ಏನೋ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ.
ಏನ್ ಸಿಗ್ತಾ ಇಲ್ಲ?
ಫೈಲ್
ಯಾವ್ದ್ರದ್ದು?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಾನು ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ದೀನಿ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ. ಅವ್ರು ಪಾರ್ಟಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಫೈಲೇ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ವಿ.
ಒಟ್ಟಿಗೆ ಕಾಲ್ ಔಟ್ ಆಗಿದೆ. ಇಲ್ಲ ಅಲ್ಲ, ನಮ್ಮಲ್ಲೂ ಕಾಲ್ಫರ್ ಮಾಡಿಲ್ಲ, ಮತ್ತೆ
ಇಲ್ಲ
ಸಿಗ್ಲಿಲ್ಲ.
ಮಾಡಿಲ್ಲ, ಇನ್ನೂ ಅಡ್ಮಿಷನ್ಗೆ ಬಂದಿಲ್ಲ. ಅದೇ ಅಬ್ಜೆಕ್ಷನ್ಲಿ
ಏನೇನ್ ಕೊಡ್ಬೇಕು?
ಒಂದೇ ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ
3 ಕೊಡ್ಬೇಕು. 3 ಕೊಟ್ಟಿಲ್ಲ. ಹಾ,
ಅಲ್ಲ ಒಂದು OS ಒಂದೇ.
ಜಡ್ಜ್ಮೆಂಟ್, ಡಿಕ್ರಿ, ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ 3 ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
ಹೌದು ಕೊಟ್ಟು.
ಅಪೀಲ್ ಹಾಕಿರೋದು 20ರಲ್ಲಿ. ಈಗ 4 ವರ್ಷದಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದೀರಿ?
ಅಲ್ಲ ಅವ್ರಿಗೆ ಹೇಳ್ತಾನೆ ಇದ್ದೀನಿ,
ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರೆ ಏನ್ ಮಾಡೋದು?
ಇನ್ನೊಂದ್ 2 ವಾರ ಟೈಮ್.
And again 2 weeks time and hence on further cost of rupees 500, another 2 weeks time granted. List this matter on 12/7.
ಕಾಸ್ಟ್ ಟು whom?
Further cost ಹಾಕಿದೀವಿ ಈಗ ಮತ್ತೆ.
ಸೇಮ್
ಟೇಬಲ್ ಅಟ್ ರಿಜಿಸ್ಟರ್ ಎಷ್ಟೇ?
ಲೈಬ್ರರಿ ಫಂಡ್.
ಅಲ್ಲ,
ಓ, ಲೈಬ್ರರಿ ಫಂಡ್ ಸರ್ಕಾರ
Registry-ಗೆ.
ನೋಡಿ.
ರಿಜಿಸ್ಟ್ರಿ,
ಹಾ.
ಹೈಕೋರ್ಟ್ ರಿಜಿಸ್ಟ್ರಿ.
ಹೈಕೋರ್ಟ್
ಲೈಬ್ರರಿಗೆ ಎಷ್ಟು ಜನ ಹೋಗಿ ಕುತ್ಕೋತಾರೆ ಹೇಳಿ? ಹಾ,
ಅಲ್ಲಿ ಫುಲ್ ಇರುತ್ತೆ, ಜಾಗನೇ ಇರಲ್ಲ ಬೆಳಿಗ್ಗೆ ಕೂತ್ಕೊಳ್ಳೋಕೆ.
ಹೌದಾ?
ಪರವಾಗಿಲ್ಲ ಇರುತ್ತೆ, ಅದು
ಪರವಾಗಿಲ್ಲ ಹಾಗಾರೆ. ಹಾ,
ಫುಲ್ ಇರುತ್ತೆ.
ಹೌದಾ? ಗುಡ್ ಸೈನ್.
ಫುಲ್ ಇರುತ್ತೆ, ಜಾಗನೇ ಇರಲ್ಲ ಕೂತ್ಕೊಳ್ಳೋಕೆ ಬೆಳಿಗ್ಗೆ ಮಧ್ಯಾಹ್ನದವರೆಗೆ. ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಜಾಗ ಇರೋದು.
ಹೌದಾ? ಗುಡ್ ಸೈನ್ ಅಂದೆ.
ಬುಕ್ಸ್ ಎಲ್ಲ ಇದೆ ಈಗ.
ಬುಕ್ಸ್ ಇದೆ, ನಾವು ಹೋಗಿ ಕೂತ್ಕೊಂಡಿದೀವಿ.
ಮೊದ್ಲೆಲ್ಲ ಇದಿಲ್ಲ, ಈಗೆಲ್ಲ ತುಂಬಾ ಇದೆ ಎಲ್ಲ.
ಅದೇ ಗುಡ್ ಸೈನ್ ಅಂದೆ. ಹಾ. ಎಷ್ಟಾದ್ ಮೇಡಮ್?
79.
79.
ಪ್ರಮೋದ್ ಆರ್, ಅಜಯ್ ಪ್ರಭು ಎಂ.
ಇವ್ರು ರೆಡಿ ಅಂದ್ರಲ್ಲ, ಇದೆ ಅಲ್ಲ? ಇದೇ ಮುಗಿಸ್ಕೊ ಬರ್ತೀನಿ ಅಂದ್ರೆ ನಾ ಮಧ್ಯಾಹ್ನ. ಆಯ್ತು, ಪಾಸ್ ಅವರ್ ಮತ್ತೊಂದು ರೋಡ್ ಪಾಸ್ ಅವರ್.
80 ಅರ್ಜನ್, 81 ಅರ್ಜನ್, 82 ಹುಂಡಿಕಾ ಈಶ್ವರ.
ಸಿದ್ದೇಶ್ವರ್.
For partition.
Partition dismissed to confirmed.
On the ground that it was barred by time.
Barred by time?
No, limitation, on the ground of limitation. Applying section Article 65(2) of the Limitation Act. The trial court, the appellate court also dismissed the thing. The findings were not get in para number 90 at page number 29.
Appellate court,
In this case, it is admitted that the mother of the plaintiff number 1 and 2, Ratnamma, died in the year 1985. And the suit is filed in 2010. Is after lapse of 12 years. As per Article 65(b) of Limitation Act, the suit by a Hindu or Muslim is entitled to the possession of immovable property. On the death of Hindu or Muslim female, the possession of the defendant shall be deemed to become adverse only when the female dies. As admittedly, the mother of the plaintiff one and two, Ekama died in the year 1985. The possession of the defendant became adverse from the date of the death in 1985. Therefore, the suit should have been filed within 12 years. But the suit is filed in 2010. Under the circumstances, the plaintiff are not entitled for the leave in the suit as the suit is barred by limitation.
That is the only ground?
Oh, that's the only ground. I mean, that is the only ground, even trial court also.
Suit filed by whom?
By the
Children of
children and husband. Children, kindly see, my lord, I have produced the genealogy, kindly see at page number 64.
Children and husband against whom?
Against other kosher, there is the brothers of mother.
Brothers of mother.
Brother and sister.
Brother and sister.
Kindly see the genealogy at page number 64, my lord. It is an admitted fact that the suit schedule properties 1, 2, 3 are co-personary properties, are joint family property. It is not in dispute. And item number 4 was purchased by Mrs. Venkata Shamappa. Your lordship got it at page number 64, my lord, genealogy.
Venkat Samamma.
Venkata Shamappa. After
Shamamma antide. Oh, adu father. Sorry.
Genealogical tree and very nice. And then he had 5 children. That is
suit for partition.
Oh, the suit for partition.
Again, the partition can admission.
Even 1981 Supreme Court.
Maybe suit for partition limitation and attract ಆಗ್ತದ. Maybe.
Limited right. That I said no absolute right. They had
Limitation Act ಕೊಡಿ madam.
12 years. You should have uninterrupted possession in 12 years. Even after the.
Is it applicable for the partition also? Maybe an uninterrupted possession. Because they have continued, she passed away and other brothers have continued in the family. 65B.
Not an absolute right. The legal acts, the husband could have.
For possession of immovable property or any interest therein based on title. 12 years ago. 65B, where the suit is by a Hindu or a Muslim entitled to the possession of immovable property on the death of a Hindu or Muslim female. The possession of the defendant shall be deemed to become adverse only when the female dies. Is it a suit for only possession of immovable property? Partition adne ಕೇಳಿದೆ ಎಲ್ಲಿದೆ ಅಂತ limitation. Heard the appellant counsel and also the counsel appearing for the respondent. I will frame substantive question of law, then we'll decide how limitation applicable in a case of partition. ಕೊಡಿ ಅಪೇಕ್ಷ ಕೋರ್ಟ್ ಏನಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ ಕೊಡಿ ನೋಡ.
1981 Supreme Court page number 77 is directly on the point.
ಆಯ್ತು, ಶಾರ್ಟ್ ಕ್ವಶನ್ ಮಾಡಿ ಫ್ರೇಮ್ ಮಾಡೋಣ, ಆಮೇಲೆ ನೋಡಿ ಏನಾಯ್ತು ಮೇಡಮ್. Respondent counsel and this appeal is filed against the concurrent finding of the trial court dismissing the suit. The suit is filed for the relief of partition and possession by the children of one Ratnamala and her husband against the defendants. And trial court framed the issue with regard to the euro limitation melena.
Trial court same.
ಇಲ್ಲ ಅವ್ರ ಇಶ್ಯೂ ನಂಬರ್ 1, 2, 3 ನೆಗೆಟಿವ್ ಅಂದ್ರೆ plaintiff, defendant 1 and 2 are members of undivided family. Even ancestral property ಅಂತ plead ಮಾಡಿದೀರಾ?
1 to 3. 1 to 3 suit schedule properties are ancestral properties, whereas the item number 4 was purchased by Venkata Shamappa.
And contended that plaintiffs and defendants 1 to 4 are the members of the undivided Hindu joint family. And also contended that scheduled properties are the ancestral and joint family properties of plaintiff and defendant 1 to 4. And trial court answered the same as negative. Being agreed by the same was also challenged before the appellate court, and appellate court also will considering the material on record comes to the conclusion in paragraph number 19 that as admittedly the mother of the plaintiff number 1 and 2, Ratnamma, died in the year 1985, and suit is filed for the possession of the defendants became adverse from the date of her death in 1985 in view of Article 65B of Limitation Act. And hence comes to the conclusion that relief claimed is barred by limitation. The counsel would contend that the very reasoning given by the first appellate court is erroneous. On the other hand, counsel appearing for the respondent would contend that under section 65B, when the suit is filed for the relief of possession, attracts and not committed any error. Having considered, though there is a concurrent finding, the question of law involved in the matter is with regard to the limitation aspect is concerned as in view of the observation made by the first appellate court, and hence matter requires reconsideration. Admit whether the first appellate court, whether the first appellate court committed an error in coming to the conclusion that suit is barred by limitation invoking section 65B of Limitation Act. Whether the trial court also committed an error in answering issue number 1 to 3 as negative against the material available on record, and whether the finding of both the courts amounts to perversity. Call for records, list the matter for final hearing on 1st of August. Filing of paper book is dispensed.
83, Girish Valadari.
Valadare Raghavendra Prasad, 97 days in filing the appeal. Entry delay, from the objections, 97 days. Huh? ಡಿಲೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಡಿಲೇಗೂ ಏನು ಇದೆಯಲ್ಲ ಅದು ನೋಡಿ. Heard the appellant counsel on IA number 1 of 22, and there is a delay of 97 days in filing the appeal, and also considered the statement of objections filed by the counsel for respondent. And reasoning assigned here, the reasoning, what is the reasoning? Condemnation of delay.
From illness and suffering from illness and due to financial crisis.
Suffering from
Illness and due to
illness.
financial.
And reason assigned in the application to condone the delay that due to financial difficulties and in the meanwhile he was suffering from illness, he could not able to contact advocate immediately, and hence there is a delay. The counsel for the respondent also filed the objections to the IA, contending that appellant ought to have been prudent and diligent and sought for the remedy immediately. The reason stated is not satisfactory, and also contend that original suit was filed in the year 2013. And delay has not been properly explained. having considered the grounds urged in the Probate as well as statement of objections and taking into note of delay of 97 days. And reason is stated that due to financial difficulty as well as in the meanwhile he has suffered illness. And though objected that no satisfactory reasons are assigned and considering 97 days delay, it's appropriate to condone the delay. I think next time again. Partly declared, hand over the position within 3 months. Partly allowed, mean profit.
Current mean profit, if an appeal for seeking mean profit before the first appellate court, that came to be allowed. My appeal came to be dismissed because I confirmed the order of trial court. Suit for adjournment and eviction suit. Reasonable time is granted, I am doing the business in the shop.
Im prakara reasonable and rest.
Clearing shop.
2014. ಏನೋ ಒಂದು ಶಾಪ್ ಏನು ಟೈಲರಿಂಗ್ ಶಾಪ್ ಎಷ್ಟು ವರ್ಷದಿಂದ ರನ್ ಮಾಡ್ತಾನ ಅಲ್ಲಿ how many years he is running tailoring shop ಏನ್ರಿ ರೀಸನಬಲ್ ಟೈಮ್ ಕೇಳ್ತಾರೆ ಏನು
2013
ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ ಟೈಲರಿಂಗ್
Tailoring ಮಾಡ್ತಾರೆ.
ಹಾ
Tailoring ಮಾಡ್ತಾರೆ.
any answer is elicited that he is not doing anything?
It informs me that, but he wanted for a whole year. 2 months can be done.
Rents ಕೊಟ್ಟಿಲ್ಲ
Rents pay ಮಾಡ್ತಾರೆ. 1,000 rents. Regularly paying the rents, my lord. 4,000 due at that has been considered by the trial court and that also paid, my lord. Para 19, page number 66, my lord.
4,000 ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ.
Even though he claimed further rent, but to the effect
amount
that
is 4,000 that has been already paid. At the time of filing suit, but later he had paid the said amount.
Above finding, it is clear that due to payment of 4,000 by defendant, one answered the issue number 1 and 2 in the negative. First, you verify with your client whether he has paid the rent or not. Trial court na rent fix ಮಾಡಿದ್ದಾರೆ ಎಷ್ಟು ಅಂತ ಮಾಡಿಲ್ಲಲ್ಲ
1,000 ಕೊಡ್ತಾ ಇದೆ that has
partly decreed and hand over the vacant possession ಅಂತ ಆರ್ಡರ್ ಇದೆ. ಈ ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ 21 ಇಂದ ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ವಾ ಗೊತ್ತಾಯ್ತು. That is with regard to the mean profit is concerned. That is allowed. ಇಲ್ಲೆಷ್ಟು ಫಿಕ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಅಪೀಲ್ ಅಲ್ಲಿ ಮೀನ್ ಪ್ರಾಫಿಟ್ಸ್ ನ
Inquiry separate.
that is also dismissed.
That is allowed. Their appeal is allowed, my lord.
Allowed are stating that the ಏನಂತ
Separate proceedings.
Page number 50, my lord. Page number.
what is the admitted rate of rent?
1,000.
1,000. ಅದನ್ನಾರು ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು ಹೋಗ್ಲಿ
Sir, my information ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
ತಗೊಳ್ಳಿ. Appellant counsel is directed to verify whether admitted rent of ₹1,000 is paid or not within 1 week. And also counsel for the respondent is also directed to verify with his client how much time he is going to give.
46.
46.
Out of 43. So reduction of the evidence of read shows that it is classified as to plaintiff. And not paid the rent of the plaintiff. On the other hand, he stated that he would go in the
3 months rate ಒಂದು ಮಾತ್ರ ಹೇಳ್ತಾನೆ. ಆ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಮಾತ್ರ 3 ತಿಂಗಳು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. You also verify and list this matter on 5/7.
Entry ಮಾಡಿದ್ರೆ ಎಷ್ಟು?
Entry ಮಾಡ್ರಿ ಇದೆಯಾ? Entry ಮಾಡ್ರೆ granted earlier is extended till next date of hearing. Rent ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ 1 ದಿವಸನೂ ಕೊಡಲ್ಲ ಡೇಟ್ ಟೈಮು. You cannot squat on the property without making the payment of rent.
84 adjourned, 85. Hariprasad MB.
ಹರಿಪ್ರಸಾದ್ MB ಶ್ರೀನಿವಾಸ. ಬೆಳಿಗ್ಗೆ ಯಾರು ಇದ್ರಲ್ಲಿ ಕೇಳಿದ್ರಲ್ಲ? ಹಾ. Someone sought time in the early morning. ಯಾರು ನೀವಾ ಅವರ? Appellant. ನಿಮ್ಗೇನೋ ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ರಾ? ಮಾಡಿದ್ರು. So appellant counsel seeks time and counsel for the respondent is also present. List this matter finally on 12/7.
86.
MS ನಾಗರಾಜ್. ಇದ್ರಲ್ಲಿ ಏನೋ ಮಧ್ಯಾಹ್ನ ಯಾರೋ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಲ್ಲ?
ಮಾರ್ನಿಂಗ್
ಪೂರ್ತಿ ಆ ಕಡೆ. ಹಾ ಹೇಳಿ. ಹಾ.
My lord, it's a divergent findings, my lord. Super partition. The trial court dismissed the suit at entirety.
Appellate court reversed and
Reversed
granted
the
half
findings.
share.
Half share
court
granted to the son. My lord, here, my lord, the son to whom, my lord, the share has been allotted. My lord, he happens to be the son of second wife. During the substance of the first wife, marriage, my lord, he got married second wife also. He is born through the second wife. And my lord, so far.
The property is ancestral or separate?
Ancestral property.
Separate
My
property.
lord, he has acquired through the partition. Partition. And my lord, the appellate court while reversing, my lord, so far limitation is concerned, that has not been taken into consideration. My lord,
What is the limitation? Suit and suit for what?
Suit for what? Partition.
Partition.
My lord, the property has
Partition
alienated.
ಗೆ limitation ಬರ್ತದ್ರಿ.
The suit is alienated. The entire property has been alienated. It's not amenable for.
ಯಾವಾಗ alienate ಆಗಿರೋದು?
My lord, the property has been sold.
New purchaser?
2000.
New
Yes, I am the
subsequent
purchaser.
purchaser?
Yes.
ಯಾವಾಗ property was purchased?
In 2004.
4. Suit was filed in 2015.
15. My lord, that is the minor when the alienation was made. My lord, he has to challenge the alienation, my lord, made by the Karta of the family within 3 years from the date of attaining majority. That's what observed by the trial court.
Any attained the majority?
My lord, he was attained the majority in the year of, my lord, at the time of filing the suit, he was aged about, my lord, 22 years. The 4 years delay.
28 years. Around 24 years.
Vijayam
is contended in the first wife's daughter. She died in the.
Oh, first wife's daughter, okay.
First wife daughter.
But she died there in the after that.
After filing of the suit.
Immediately she died. Immediately he married another one lady by name Indrama, who is an Appellant teacher. Thereafter 2 children were born. Their 3 children are contended to be the children of Rajanna. They are all legitimate children itself. That is the ground they have to ask. But their question was retained with Vijayamma, because Vijayamma was married but still living in the father's house, because his husband is he is not living with the Vijayamma. The other son, that is Anganwadi teacher's son, which is minor, he is at Bangalore. And the second daughter Nandini is at also Bangalore. Vijayamma was married and she is at Palanalli itself, at the property itself. So nearby social property itself. Now also she is in the possession of the social property. There is a complaint which is going on. After the complaint, there is no change of the Kata till 2018 and 2015. Then they interrupted with the question. Then we have filed a suit for partition. And before that, this document, only the Rajanna, that is the father, was executed a deed of sale. Upon that, there was a money exchange of 1,30,000. But the value of the property exceeds more than 1,30,000 as on that day itself. Subjectment. It is only with the mortgage.
Why the trial court has dismissed the suit? Because answered the issue number 1 as affirmative. Only on the ground that not entitled for 3/4 share antana.
So for daughter's concern, my lord, that sale is made prior to 2004. 2004, my lord. 9/9/2005, before enactment of the section 6, my lord, amendment, the sale was alienated. Therefore, they are not entitled to the fight. That is what observed. That is also observed. That has been upheld by the appellate court also. So for son is concerned, my lord, the trial court has also dismissed the suit on the ground of that, my lord, is when he was a minor, when his property is alienated, he has not challenged the sale after attaining the majority within 3 years, as per section 82, supposed to the minority guardianship act. My lord, on the ground of limitation, suit was dismissed. So for son is concerned, daughter is concerned, my lord, the law is very clear that has been upheld by the trial court. And my lord, and subsequently in the appeal, my lord, all 3 they have filed the appeal. in the appeal, my lord, appellate court has upheld the findings of the trial court in so far daughters is concerned. Son is concerned, my lord, see, the limitation is over. The limitation is not taken into consideration. Even they are observed, my lord, that in the appellate court is also observed that, my lord, only the thing they have ascertained that observed that, my lord, he has got an undivided interest in the property. It cannot be, he cannot alienate the property without any family necessity. That we have proved and established that the property has been mortgaged, and in order to discharge that these old debt, my lord, he is alienated the property, and also for the minor marriage, to perform the marriage of that Vijayamma, he sold the property.
Good. Heard the appellant counsel and admit substantive question of law frame ಮಾಡೋಣ. Heard the appellant counsel and also the counsel appearing for the respondent.
Here is concerned, my lord, the Supreme Court decision.
Connected appeal ಯಾರು ಫೈಲ್ ಮಾಡಿರೋದು? ನೀವಾ?
Daughters they have filed.
ಏನಂತ?
Contending that the property was alienated much before the amendment of 2005 on the strength of 6A of the amendment to the.
Not correct ಅಂತನಾ?
Not correct, in view of the confounding.
Told. Heard the appellant counsel and also the counsel appear for the respondent in both the appeals. The suit was filed in OS number 105 of 2015 claiming partition in respect of the suits and properties. And trial court declined to grant the relief in favor of the plaintiff, though comes to the conclusion that the properties are the ancestral and giant family properties of plaintiff and defendant number 1. And plaintiffs not entitled for 3/4 share. And also in respect of the sale deed dated 21/2004 executed by the defendant number 1 in favor of defendant number 2, also answered as negative and not accepted the contention of the plaintiff, and the same is not binding. And however, the trial court comes to the conclusion that the defendant number 2 is the bona fide purchaser of the suit and property and dismiss the suit. Being agreed by the judgment and decree of dismissal of the suit, appeal was filed in RA number 26 of 2020. First appellate court confirmed the judgment with regard to the claim of plaintiff number 1 and 2 and granted the relief in favor of plaintiff number 3, that plaintiff number 3 is entitled for half share in the suit and properties by partition, meets and don'ts. And also held that likewise defendant number 2 is also entitled for remaining half share in the suit and properties by way of equitable partition. Being agreed by the granting of share in favor of the plaintiff number 3, RA number 42 of 23 is filed. And also in respect of declining the right in favor of plaintiff number 1 and 2, RSA number 1541 of 22 is filed. Main contention of the appellant counsel that granting of share in favor of the plaintiff number 3 is not correct. And the appellate court committed an error. On the other hand, counsel appearing for the respondent also, respondent and appellant in other appeal contend that the dismissal of the suit in respect of plaintiff number 1 and 2 is also erroneous, having taken note of the divergent finding and also issue involved between the parties is whether plaintiff number 3 is entitled for share and whether both the courts committed an error in declining to grant the relief in favor of plaintiff number 1 and 2 requires reconsideration. Admit the following substantive question of law arises for the consideration of this court are whether the first appellate court committed an error in granting the relief of partition in favor of the plaintiff number 3, granting half share that is entitled for a share in the suit share properties. Whether both the courts have committed an error in declining to grant the relief in favor of plaintiff number 1 and 2 in coming to the conclusion that sale deed was made prior to the amendment, that is 21/2004. That is the only reason, na? Sale was made in 21/2004.
Yes, that is the only reason the decline is made. They are minor and one is minor.
Whether the finding of both the courts are perverse, ignoring the material available on record and the same amounts to perversity.
So for minor is item number 3, my lord, he born second wife. Revalasithappa case is applicable.
ಅದೇ ನೋಡೋಣ. You argue at the time of ಇದು first. File. Filing of paper book is dispensed since the suit is filed only for the relief of partition. And only question is required to be considered is question of law and question of fact. List the matter for final hearing on first of August.
Till then, my lord, they are trying to interfere, my lord, based on that opposition. 2004 ಅಲ್ಲಿ
ಆಯ್ತು ಡಿಸೈಡ್ ಮಾಡಿ ಒನ್ ಏಟ್ ಡಿಸೈಡ್ ಮಾಡೋಣ.
87.
ಆಗಸ್ಟ್ ಏನ ಕೊಟ್ಟರು ಅದಕ್ಕೆ ಫಸ್ಟ್ ವೀಕ್ ಬೇಡವಾ? ಫಸ್ಟ್ ಆಫ್ ಆಗಸ್ಟ್ ಬೇಡವಾ? ಹಾ 87 ಮುದ್ರಾಜ್ ಶ್ರೀರಾಮ್ ತಿಮ್ಮಪ್ಪ ನಾಯಕ್ dismissed, reversed, declared as owner.
For declaration and injunction, divergent findings. Divergent findings. My lord, the trial court, considering the partition deed of 1958, that the plaintiff did not have, a plaintiff's uncle did not have the right to execute the gift deed. On that ground, the suit of the plaintiff came to be dismissed in the trial. Later, considering the same, the appellate court has upheld and there is a divergent finding with that aspect.
Dismiss reverse ಆಗಿದೆ ರೀ.
Reverse ಆಗಿದೆ, divergent finding. Suit was dismissed.
Reverse ಮಾಡಿ declared as owner ಅಂತ ಮಾಡಿ.
Yes.
In respect of A schedule property.
Yes.
And also directed to hand over the possession in respect of B schedule property within 3 months. That
Yes.
is the judgment of the first appellate court. Really.
The thing is, I am in possession right from the partition date. My fathers were the shareholders in that property. I am in possession of that property. Just drawing a handwritten sketch, the plaintiff files a suit in the trial court. On that basis, after all evidences were taken and that the uncle Narsimaya did not have the right to execute the gift deed. On that ground, the trial court dismissed that the respondent number 1 doesn't have any right over the property. But the appellate court, considering the same only, has declared that she is the owner of the A schedule property and B schedule has to be delivered to her. From 1958, the appellant ancestors are in possession of the property. After the partition, the partition deed is dated 29/4/1958. From that day, they are in possession of the property, but she draws a sketch of her own and claims the property of this appellant. Without any authority or any document, only unregistered partition deed they declare.
The 2 guntas of property encroachment is in respect of B schedule property.
B schedule anta declared ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ, but I am in possession of that property which has fallen to my ancestors. They only have drawn that B schedule. There is no such B schedule. They have drawn for the case purpose. It is totally with regard to survey number 11/1. There were 2 parts happened between the ancestors of the appellants. I'd like to draw your kind attention to the page number 66, where the finding has been given clearly by the trial court. Page number 66. Yes. Prior page, one line, last line I would like to read out. Property bearing survey number 11/1, measuring 1 acre 13 guntas, equally divided between the father of the plaintiff and the father of the defendant, number 1 and 2. Exhibit D7 is the certified copy of the partition deed dated 29/4/1958, executed amongst Narsimaya, Timmaya and Karyana, who are the sons of Timmaya. On perusal of exhibit D7, the land bearing survey number 11/1,
equally divided by plaintiff's father and the father of defendant number 1 and 2. The document at exhibit D7 substantiates the defense of the defendant number 1 and 2 that there was no property in land bearing survey number 11/1 fallen to the share of Narsimhaya, who is the senior uncle of the plaintiff. It is also oral testimony of PW1 that the senior uncle of the plaintiff executed this gift deed in respect of property which were fallen to the share of her father. The person who did not have the right over the property has executed a gift deed, and on that basis, the plaintiff, the respondent number 1 claims that that property belongs to her.
Yes, counsel.
Even though the partition which was alleged in 1988 activities, it's a handwritten document. ಅದರಲ್ಲಿ ಯಾರಿಗೆ ಎಷ್ಟು ಎಸ್ಟೇಟ್ ಅಂತ ಸುಮಾರು ಅರ್ಧದಷ್ಟು ಇವರಿಗೆ ಸುಮಾರು ಅರ್ಧದಷ್ಟು ಇವರಿಗೆ ಆ ತರ ಮಾಡ್ಕೊಂಡು ಸಿನ್ಸ್ 1958 ಪ್ರಾಪರ್ಟಿ ಸ್ಟೂಡ್ ಇನ್ ದ ನೇಮ್ ಆಫ್ ಮಿಸ್ಟರ್ ನರಸಿಂಹಯ್ಯ. 1868 when sale deed comes to be executed by the father of appellant. The property stood in the name of Narasimhaya. They filed a suit in 2009, was number 117 in 2009. They withdrew it because Narasimhaya had the kata, but their father only had sold the stock. Same way, Mr. Narasimhaya gifted the property, 30 guntas to my share. Here 1994, 40 survey number 11/1C1 and 1C2 1C1 1C2 ನನ್ನ ಬರುತ್ತೆ, 1C1 ಇವ್ರಿಗೆ ಬರುತ್ತೆ, ಮಾಜರ್ ಡ್ರಾಪ್ ಆಗುತ್ತೆ, ಮಾಜರ್ ಅಲ್ಲಿ ಇವ್ರು ಬಂದು ಸೈನ್ ಮಾಡ್ತಾರೆ 1994. Then they come and they try to encroach on my land. ಏನು ಮನೆ ಈಸ್ಟರ್ನ್ ಪೋರ್ಷನ್ ಡೋರ್ ಅದನ್ನ ನಾರ್ದರ್ನ್ ಪೋರ್ಷನ್ ಓಪನ್ ಮಾಡ್ತಾರೆ, ಅದರಿಂದ 2 ಗುಂಟೆ ಓಪನ್. They say if deed is null and void, ಅವರಿಗೆ execute ಮಾಡ್ತಾರೆ. But that if he was acted upon 1994 ನಲ್ಲಿ ಯಾವಾಗ ಬಂದು ಎಲ್ಲ ಬಂದು ಮೆಜರ್ ಮಾಡಿ ಮಾಡಿದಾಗ ಇವ್ರು ಬಂದು ಸೈನ್ ಮಾಡ್ತಾರೆ. ನಾವು ಬಟ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ has been produced. 1994 ನಲ್ಲಿ ಗೊತ್ತಿತ್ತು ಎಲ್ಲಾನು ಪೊಸಿಷನ್ ಕರೆಕ್ಟ್ ಆಗಿ.
Good. Heard the appellant counsel and also the counsel appearing for the respondent. Suit is filed seeking the relief of declaration, recovery of possession and mandatory injunction by the plaintiff, claiming that she is the owner in possession of A scheduled property as per the gift deed executed by Narsimhaya, and also contend that defendants have encroached 2 guntas of land in the suit scheduled property. And defendants appeared and filed written statement that boundaries of the suit scheduled property mentioned in the plaint is not proper. And also, second defendant contend that gift deed dated 1932 to 1992 in favor of the plaintiff is not binding on them. The trial court, having considered the material on record, answered all the issues except additional issues, and answered the additional issues as affirmative, in coming to the conclusion that second defendant proved that gift deed dated 19/3/1992 in favor of the plaintiff is not binding on them, and dismissed the suit. Being agreed by the dismissal of the suit, an appeal is filed. And in the appeal, on reappreciation of both oral and document evidence available on record, the first appellate court comes to the conclusion that the judgment and decree passed by the trial court is perverse and capricious and committed an error in answering additional issues and answering other issues. And granted the relief declaring that plaintiff is the absolute owner of A scheduled property and defendant number 1 and 2 are directed to hand over the vacant possession of B scheduled property of item number 1. And similarly, third defendant is directed to hand over the vacant possession of B scheduled property of item number 2 within 3 months from the date of the order. Being agreed by the said judgment and decree of the first appellate court, the present second appeal is filed. The main contention of the counsel appearing for the appellant that first appellate court was not justified in upholding the registered gift deed dated 17/3/1992, executed by one Sri Narasimhaya, even though he was not having any right to execute the same, and declaring of the plaintiff as owner of the A scheduled property is also based on the gift deed is erroneous. And question of handing over the B scheduled property also doesn't arise. The very approach of the first appellate court erroneous. The counsel appearing with respondent would vehemently contend that the trial court has not properly appreciated the material available on record. On the other hand, first appellate court reversed the finding of the trial court and rightly granted the relief declaring as owner of the property and rightly ordered to deliver the possession. Having considered the very contention of the plaintiff claiming the right in respect of the social property based on the gift deed in respect of A scheduled property. And also there is an allegation of enforcement to the extent of 2 guntas. On the other hand, second defendant contend that gift deed dated 19/3/92 in favor of the plaintiff is not binding. And there is a divergent finding with regard to the very execution of the gift deed. And validity of the gift deed is also disputed. And when there is a divergent finding with regard to the very execution and proving of document of gift deed, matter requires reconsideration. Admit. The following substantive question of law arises for the consideration of this court. Whether the first appellate court committed an error in upholding the registered gift deed dated 17/3/1992, executed by one Sri Narasimhaya, and whether he had right to execute the same in favor of the plaintiff. Whether the first appellate court committed an error in declaring the plaintiff as owner of the social property in accepting the gift deed and directing to deliver the vacant possession. Whether the first appellate court committed an error in ignoring the material evidence available on record and this said reasoning that plaintiff has made out the case and proved the gift deed is against the material on record, whether it amounts to perversity.
Status quo may be granted. madam,
Yes,
because they are
status
trying
quo.
to disturb.
ಈಗೇನು ಪೊಸಿಷನ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿ ಅಂತಿದ್ದಿಲ್ಲ ಅದ
ಹೌದು ಹೌದು ಸ್ವಾಮಿ ಅದಕ್ಕೆ ಸ್ಟೇಟಸ್ ಕೋ ಈಸ್ ಇನ್ ಪೊಸೆಷನ್.
ಹಾಕಿಲ್ಲ ಅಂತಲ್ಲ ಅವ್ರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿಲ್ವಂತಲ್ಲ. ಆಯ್ತು. Filing of paper book is dispensed. List the matter for final hearing on 2nd of August. First ಬೇಕಾ? 1st of August, right?
88, SV Bhatt, SV Prakash.
Amendment is being carried out.
amendment is being carried out. At the minutes.
ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಿದೀರಾ?
ಆಗ್ತಾ ಇದೆ.
ಹಾ,
ಮಾಡ್ತಾ ಇದೆ.
ಮಾಡ್ತಾ ಇದೆ.
ನಾಲ್ಕೈದು ಶೀಟ್ ಆಗುತ್ತೆ, ಸಪರೇಟ್ ಶೀಟ್ ಅಲ್ಲಿ.
ಅಮೆಂಡ್ಮೆಂಟ್ 4-5 ಪೇಜ್ ಆಗುತ್ತಾ?
ಹೌದು. ಒಂದು 15 ಪೇಜ್ ಇದೆ, 15 ಅಲ್ಲ 7-8 ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ.
ರೆಡಿ ಇದ್ದೀರಾ ನೀವು ಅಡ್ಮಿಷನ್ಗೆ? ನೋಡಿ, the appellant counsel is directed to amend the cast title and file amended appeal memo within 1 week. This matter for admission on 12/7. ಬೇಡ, next week ಅಂದ್ರೆ ಡೇಟ್ ಕೊಡಿ, ಸ್ಟಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ. 5/7. ಎಂಟ್ರಿ ಮಾಡಿದೀಯಾ?
Undertaking ಕೊಟ್ಟಿದೆ.
ಹಾ, the undertaking is continued till next date of hearing.
89.
This is a declaration suit. Site purchase ಮಾಡಿದ್ರು KGF ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಲ್ಲಿ, ಆಕ್ಷನ್ ಅಲ್ಲಿ ತಗೊಂಡ್ರು. ಆಕ್ಷನ್ ಅಲ್ಲಿ ತಗೊಂಡ ತಕ್ಷಣ ಮಾರ್ಟಿಗೇಜ್ ಮಾಡ್ಕೊಟ್ರು. ಮಾರ್ಟಿಗೇಜ್ ಮಾಡ್ಕೊಟ್ಮೇಲೆ ತಕ್ಷಣ ಹೋಗಿ ಬೇರೆಯವ್ರ ಹತ್ರ ಮಾರ್ಟಿಗೇಜ್ ಮಾಡ್ಕೊಡ್ಲಿಲ್ಲ, ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡ. ಇವಾಗ ಇಲ್ಲಸ್ಟೇಟೆಡ್ ಇವಾಗ ಮಾಡ್ಕೊಂಡು ಅದ್ರ ಪ್ರಕಾರ ಅವನು ನಂದೇ ಸೈಟು ಅಂತ ಈಗ ಇವರು ಡಿಕ್ಲರೇಷನ್ ಹಾಕಿದ್ರು. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ 15 ವರ್ಷ ಆದ್ಮೇಲೆ ಮಾರಾಟ ಮಾಡಿದ್ದಾನೆ. ಮಾರಾಟ ಮಾಡ್ತಾ ಇವ್ರು ಪರ್ಚೇಸರ್, ಸಬ್ಸಿಕ್ವೆಂಟ್ ಪರ್ಚೇಸರ್ ಏನಾಕಿದ್ದಾರೆ, ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ. ಡಿಕ್ಲರೇಷನ್ 2 ಕೋರ್ಟ್ ಅಲ್ಲೂ ಅವ್ರ ಕಡೆ ಅಡ್ವಾನ್ಸ್ ಇದೆ. ಅವ್ರು ಹೇಳಿದ್ದಾನೆ ಕ್ಲಿಯರ್ ಆಗಿ ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ನಾನು ಇವ್ರ ಮಾಟಿಗೆ ದುಡ್ಡು ಸಾಲ ಮಾಡಿಕೊಟ್ಟು ಅವರಿಂದ ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ. The lower courts, both the courts have not occurred the submission of those. ಸೆಕೆಂಡ್ ಥಿಂಗ್ ಏನಾಗಿದೆ, ಅವ್ರು ಫೇಕ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಫೇಕ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಲಿಲ್ಲ. ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವೆಶ್ಚನ್ ರೈಸ್ ಮಾಡಿದ್ದೀನಪ್ಪ. ಮಾಡಿದ್ವಿ. ಪೇಜ್ ನಂಬರ್ 43 ನಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ, ದಾವಾ ಸ್ವತ್ತನ್ನು ಕಾಗದದ ಮೂಲಕ ವಾದಿ ಬರೆದು ಕೊಟ್ಟಿರ್ತಾನೆ ಎಂದರೆ ಸಾಕ್ಷಿ ನಾನು ಅವರಿಂದ ಸಾಲ ಪಡೆದು ಸಾಲದ ಭದ್ರತೆಯಾಗಿ ಸಹಿ ಮಾಡುವಂತೆ ವಾದಿಯು ಕೇಳಿದ್ದು ನಾನು ಸಹಿ ಮಾಡಿರುತ್ತೇನೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. That is recorded in the even lower court and apex court. Both courts have been taken as a wrong conclusion. So fake document ಮೇಲೆ ಅವರು ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ.
ಫೇಕ್ ಡಾಕ್ಯುಮೆಂಟ್?
ಫೇಕ್ ಡಾಕ್ಯುಮೆಂಟ್.
ಯಾವ ಫೇಕ್ ಡಾಕ್ಯುಮೆಂಟ್?
ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಬಟ್ ಅವರು ಖಾತಾ ಕಂದ ಏನೂ ಇಲ್ಲ. ಓನ್ಲಿ ಅವನ ಹತ್ರ ಇವನ್ ಪೊಸಿಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಲಿಲ್ಲ, ಇಲ್ದೇನೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ in 2001 ಅಲ್ಲೇ.
How whether defendant number 1 to 4 can execute the sale deed in favor of you counsel?
ಇಲ್ಲ, 1 to 4 ಇವ್ರಿಗೆ ಮಾಡ್ಕೊಟ್ರು.
ನಾರಾಯಣಪ್ಪ defendant number 5 and 6 ಗೆ
5 and 6
they are the appellants here.
5 and 6 ಇವಾಗ appellants. 5 and 6 ಅವರು ಇವ್ರಿಗೆ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ.
5 and 6
ಇವ್ರಿಗೆ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ಯಾರಿಗೆ?
ನಮ್ಮ appellantsಗೆ ನವೀನ್ ಕುಮಾರ್ ಅಂಡ್ ಮೈದೇಲಿ. ನವೀನ್ ಕುಮಾರ್ ಮತ್ತೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಇನ್ನೊಬ್ಬರು ಮಾರಾಟ.
ಅವರೇ ಡಿಫೆಂಡ್ ನಂಬರ್ 5 and 6. ಅವರೇ ಡಿಫೆಂಡ್ ನಂಬರ್ 5 and 6
ಅಲ್ಲ, ಸುಮ್ಮನೆ ಅವ್ರು
ಹಿಂದೆ ಅಪೀಲ್ ಮೆಮೊ.
ಶಶಿಕುಮಾರ್ ನಾರಾಯಣಪ್ಪ ವೆಂಕಟಪ್ಪ ಅನ್ನೋರು.
ನವೀನ್ ಕುಮಾರ್ is the fifth defendant before the trial court. ಹೌದಾ? 6th defendant is ಮೈದೇಲಿ. They are the purchasers from defendant number 1 to 4. ಹೌದಲ್ವಾ? How they defendant number 1 to 4?
1 to 4 ವೆಂಕಟಪ್ಪನ ಡಾಟರ್ಸ್ ವೆಂಕಟಪ್ಪ ಅವರು. 1 to 4 ಇದು 1 ಇರೋದು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಈಗ ಪರ್ಚೇಸರ್. ಈಗ ಪರ್ಚೇಸರ್ 2 to 5 ಬಂದು ಈ ಅಳುಬರು ಮಾರಾಟ ಮಾಡಿದ್ರು. ವೆಂಕಟಪ್ಪ ಸತ್ತೋದ ಮೇಲೆ ಮಕ್ಕಳು ಬಂದ್ರು.
Whether defendant number 1 to 4 are having absolute right to sell the property in favor of defendant number 5 and 6 counsel?
ಹೌದು.
What is the finding of the trial court?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದೇ ಇದೇ ಹೇಳಿದ್ದಾರೆ ಅವರು. ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ. ಫೇಕ್ ಡಾಕ್ಯುಮೆಂಟ್ ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ, ಸೇಲ್ ಡೀಡ್ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ. ಸೇಲ್ ಡೀಡ್ ಹೆಂಗಾಯ್ತು ಅನ್ನೋ ಕ್ವಶನ್ ಅವ್ರಿಗೆ ಥಾಟೇ ಬರಲಿಲ್ಲ. ಸೇಲ್ ಡೀಡ್ ಇಸ್ ಅ ಫೇಕ್ ಡೀಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಮಾಡಿದ್ರು. ಆಮೇಲೆ ಪವರ್ಸ್ ಇಲ್ಲ, 10 years ಮಾಡಬಾರ್ದು ಅಂತಿದೆ ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿಯಿಂದ. ಆ ಕಂಡೀಷನ್ಸ್ ವೈಲೇಟ್ ಮಾಡಿದೆ. ದಟ್ ಆಲ್ಸೋ ಇಸ್ ನಾಟ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಲೋಯರ್ ಕೋರ್ಟ್ not consider for that point also.
How your vendors have got the right to sell the property counsel?
Vendors, is in Alati.
1 to 4.
Subsequent purchaser on that.
Number 1 to 4.
124 is a subsequent, second time purchase. Second time. 2001 ಅಲ್ಲಿ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
From whom?
From that ವೆಂಕಟಪ್ಪ. ಪರ್ಚೇಸ್ ಅಂದ್ರೆ ನಾಟ್ ಪರ್ಚೇಸ್ ಈಸ್ ಅ ಮಾರ್ಟಿಗೇಜ್. ಮಾರ್ಟಿಗೇಜ್ ಬರ್ಸ್ಕೊಳ್ಳೋ ಬದಲು ಅವ್ರು ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಸ್ಕೊಂತೀವಿ. ಇದನ್ನ ಗೊತ್ತಿಲ್ಲ. ಇವ್ರು ಯಾವಾಗ ಡಿಕ್ಲರೇಷನ್
ಸ್ಟೋರಿ ಆಫ್ ಮಾರ್ಟ್ಗೇಜ್ has not been considered.
ಹೌದು ಸ್ವಾಮಿ, ಅವ್ರು ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ. ಓನ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಂತಿದ್ದಾರೆ. ಆ ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡಿರೋದು ಆ ಟೈಮಲ್ಲಿ ಮಾಡಿದ್ರೆ ತಪ್ಪು. ಆ ಟೈಮಲ್ಲಿ ಮಾರಕ್ ಬರೋದಿಲ್ಲ.
Not binding on the plaintiff.
Yes, ma'am.
What is the error in the order?
No. ಅವಾಗ ಅವ್ರ ಮಾರಾಟಕ್ಕೆ ಪವರ್ಸೇ ಇಲ್ಲ. ಅದು ಮಾರಾಟಕ್ಕೆ ಆತನಿಗೂ ಪವರ್ ಇಲ್ಲ. ಅದಕ್ಕಿನ್ನೂ ಪೊಸಿಷನ್ ಕೊಡ್ಲಿಲ್ಲ ಆಗ. ಅರ್ಬನ್ ಡೆವಲಪ್ ಅಥಾರಿಟಿ ಅವರು ಪೊಸಿಷನ್ ಕೊಡ್ಲಿಲ್ಲ, ಇದು ಕೊಡ್ಲಿಲ್ಲ. ಹಾಗಾಗಿ ಬಂದಿರೋದ್ರಿಂದ.
Call for records.
For records and also issue TI Somesh, judgment stay.
ಏನ್ TI ಏನಾಗೋದಿಲ್ಲ.
Judgment stay ಆಗ್ಬೇಕು.
No.
ಇಲ್ಲ ಮತ್ತೆ ಹೋಗಿ ರಿಜಿಸ್ಟರ್ ಆಗಿ ಕ್ಯಾನ್ಸಲೇಷನ್ ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
ನಿಮ್ ಸೇಲ್ ಕ್ಯಾನ್ಸಲ್ ಆಗೋಗಿದೆ, ಅದು ಕನ್ಫರ್ಮ್ ಆಗಿದೆ.
ಇಲ್ಲ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಗಿದೆ ರೀ, ಸೇಲ್ ಡೇಟ್ಸ್ ಆರ್ ಕ್ಯಾನ್ಸಲ್ಡ್.
ಅದು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಲ್ಲ, ಇನ್ನೂವರೆಗೂ ಪೊಸಿಷನ್ ಹೋಗಿಲ್ಲ. ಅಲ್ಲಿವರೆಗೂ ಜಡ್ಜ್ಮೆಂಟ್ ಇಷ್ಟೇ.
ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಲಿ ನೋಡಿ, ವಿಲ್ ಸಿ.
ಅಲ್ಲಿವರೆಗೂ ಸ್ವಲ್ಪ ಕೊಡಿ ಸು. ಅಲ್ಲಿವರೆಗೂ ಇರ್ಲಿಲ್ಲ ಮತ್ತೆ ಆಗ್ಬಿಟ್ರೆ
ನಥಿಂಗ್ ವಿಲ್ ಹ್ಯಾಪನ್. ನಾನು ಐ ಹ್ಯಾವ್ ನಾಟ್ passed an order for issuance of notice also. I am not convinced.
The notice also issued ಮಾಡಲ್ಲ.
Records ಬರ್ಲಿ ನೋಡೋಣ. I will look into the records, then I will consider it.
Fix the date, my lord.
Date ಕೊಡಿ ಮೇಡಮ್. 27th. ಮೇಡಮ್ 3 weeks ಆಗಲಿ.
22/7.
22/7.
Mobilize, my lord.
90.
I am for the appeal. Yeah, this is my suit for a declaration. Suit for declaration filed by my lord Appellant. Before the civil court in OS number 480 of 2014. My lord has sought my lord a declaration. Declaring that my lord the plaintiff is lawful annexation of the property on the basis that estate registered will dated 27/1981. This is the my lord prayer. The Bhujangrao Nimbalkar has got two sons, my lord, by name Chandu Rao and my lord Abbasa. And my lord, the Abbasa has got a son by name Ramarao. Appellant is son of Ramarao. And that Chandu Rao has got a son by name Lakshman Rao. The defendants are the children of Lakshman Rao, that is grandsons of Chandu Rao. This property, my lord, the suit scheduled property has been purchased by appellant's uncle Chandu Rao through registered civil deed dated, my lord, 15/6/1967. And he was the manager. Abbas Saab, my lord, the grandfather of the appellant, died in the year of 1970. And my lord, the subsequent to that, my lord, the partition effected among the children of Abbas Saab and my lord, the Chandu Saab's children, Chandu Rao's sons. And my lord, this Chandu Rao has executed registered will in favor of my lord, the appellant on 2/7/1981. And these facts has been admitted by the defendants before the court. And my lord, the two witnesses has been examined and cross-examination has been done. Who is the, my lord, witness to the will. And defendants have admitted the execution of will. I'll draw your lordship's attention to only cross-examination portion, because will has been my lord, marked as exhibit P1. And during the year of 1985 to 88, my lord, that RTC was reflected in the name of the Narayan Rao appellant. And thereafterwards, my lord, Lakshman Rao, subsequent to death of Lakshman Rao, the mutation entered in the name of my lord, his wife and defendants. Then I have approached Tahsildar to get transfer. Tahsildar issued endorsement that you have to resolve in the civil court. Thereafterwards, that I have filed suit. And following issues has been framed, my lord, before the trial court. Whether the plaintiff proves that.
Will.
Please, my lord. Whether the plaintiff
will came into existence in a suspicious circumstances anta finding trial court.
Allah. Since I am not in position, surrounding circumstances which they have not needed the written statement ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ,
ಅವರಿಗೆ ಚಂದ್ರರಾವ್ ಹುಷಾರಿಲ್ಲ, that contention has not been taken. Court has presumed that, my lord, since the plaintiff has not proved that he is in his health condition was not the health condition
Not
was good
spoken,
as of
not
the date
spoken
of.
about.
Kindly see admission, my lord, at the cross-examination of DWI. That court, my lord, has given contrary finding to the admission.
Why he has disinherited the family members while executing the will in favor of the
Since, my lord,
beneficiary?
that children have not looked after him. And, my lord, he was staying in, my lord, he was looking, Narayan Rao looking after his, my lord, the grandfather. And, my lord, only 2 acres has been executed will in favor of the plaintiff in 6 acres. 4 acres has been given to their son only. Kindly see admission, my lord. And drive not attention to. Take away, my lord, DW1.
DW1 ಕೊಟ್ಟಿದ್ದೀರಾ ಡಿಪೋಸಿಷನ್?
ಹಾಕಿದ್ದೀನಿ page starts from, my lord,
ಕ್ರಾಸ್
page
ಎಕ್ಸಾಮಿನೇಷನ್.
19. Sorry, DW1, my lord. Kindly see page number 21. ಪಾರ್ಟಿ ಸವಾಲು SR ವಕೀಲರು. ನಿಂಬಾಳ್ಕರ್ ವಿಜಯನಗರನಾಗಿ ಮುತ್ತಜ್ಜರಾಗಬೇಕು ಅವರಿಗೆ ಅಭ್ಯಾಸ.
ನೀವು ಯಾವ್ದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಯಾರ್ದು ಓದ್ತಾ ಇದ್ರಿ?
DW1.
DW1.
Sir.
DW1, go to page number 59.
Page number. Nanu, I am a BCom graduate. I can read so and so and so. It is true to suggest that Appa Sahab has died in the year of 1972, and Narayan Rao, grandfather. It is true to suggest that Ramarao is the son of Appa Sahab. The plaintiff is the son of Ramarao. It is true to suggest that plaintiff and the defendant are cousin brother. It is true to suggest that Lakshmi Rao and Ramarao were well known in Bommanahalli village and adjacent villages. It is true to suggest that my grandfather was doing panchayat. It is true to suggest that plaintiff is the grandson of Appa Sahab. It is true to suggest that Ramarao died at a younger age. It is then, my lord, I draw lordships to page number 61. ದಾವಾ ಸ್ವತ್ತು ನನ್ನ ಅಜ್ಜ ದಿನಾಂಕ 15/6/67 ಖರೀದಿಸಿದ್ದ ಆಸ್ತಿ ಎಂದರೆ ಸರಿ. ನನ್ನ ಅಜ್ಜ ಅಂದ್ರೆ ಚಂದೂರಾವ್. ಅಜ್ಜನ ಆಸ್ತಿಯನ್ನು ಖರೀದಿಸಲು ಕಾಲದಲ್ಲಿ ಸಂಧಿ ಸುತ್ತಿನ ಮಾಲೀಕನಾಗಿ ಸದರಿ ಸುತ್ತಿನ ಸ್ವಾಧೀನದಲ್ಲಿ ಇರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ದಾವಾ ವಾದಿ ಈ ದಾವೆಯಲ್ಲಿ ಯಾವ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುತ್ತಾರೆ ಎಂದು ನಾನು ತಿಳಿದುಕೊಂಡಿಲ್ಲ. ದಾವಾ ಸ್ವತ್ತು ಈಗ ಬೀಳು ಬಿದ್ದಿರುತ್ತದೆ ಎಂದು ಸಾಕ್ಷಿ ನಾನು ವ್ಯವಸಾಯ ಮಾಡುತ್ತೇನೆ ಎನ್ನುತ್ತಾರೆ. Then, my lord, kindly see. Next, my lord, ಸಾಕ್ಷಿಗೆ ನೀತಿ ಒಂದು ದಾಖಲೆಯನ್ನು ತೋರಿಸಿ ಇದು ನೋಂದಾವಣೆ ಆಗಿರುವ ಮರಣ ಶಾಸನ ಅಥವಾ ನೋಂದಾವಣೆ ಆಗದೆ ಮರಣ ಶಾಸನ ಸಾಕ್ಷಿ ಸೂಚನೆಗೆ ಸಾಕ್ಷಿ ಮರಣ ಶಾಸನ ಆಗಿರುವ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನಾನು BCom ವ್ಯಾಸಂಗ ಮಾಡಿರುತ್ತೇನೆ. ನನಗೆ ಕನ್ನಡ ಓದಲು ಬರೆಯಲು ಬರುತ್ತದೆ. ದಿನಾಂಕ 2/7/81 ಚಂದೂರಾವ್ ವಾದಿಗೆ ವಿಲ್ ಮಾಡಿರ್ತಾರೆ ಸಾಕ್ಷಿ ಮಾಡಿರಬಹುದು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಚಂದೂರಾವ್ ವಿಲ್ ನಲ್ಲಿ ನಾನು ಓದಿ ತಿಳಿದುಕೊಂಡು ಸಹಿ ಮಾಡುತ್ತೇನೆ ಎಂದು ಹೆಬ್ಬಟ್ಟನ್ನು ಹಾಕಿರುತ್ತಾರೆ ಎಂದರೆ ಸಾಕ್ಷಿ ನನ್ನ ಅಜ್ಜನಿಗೆ ಓದಲು ಬರೆಯಲು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನೀತಿ 1 ದಾಖಲೆಯಲ್ಲಿರುವ ಹೆಬ್ಬಟ್ಟಿನ ಗುರುತು ನನ್ನ ಅಜ್ಜನ ಹೆಬ್ಬಟ್ಟಿನ ಗುರುತೇ ಅಥವಾ ಇಲ್ಲವೆಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮ ಊರಿಗೆ ಹನುಮಂತರಾವ್ ಸಿಂಧ್ಯ ನನ್ನ ಸಂಬಂಧಿಸಿದಲ್ಲಿ ಸಾಕ್ಷಿ ಅವರು ನನ್ನ ಮಾವ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಈ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಇದ್ದಾರಲ್ಲ ಅವ್ರ ಮಾವನೇ ಸಾಕ್ಷಿಯಲ್ಲಿ. ಅಂಡ್ ಹಿ ಹ್ಯಾಸ್ ಸ್ಟೇಟೆಡ್ ದಟ್ ಹಿ ವಾಸ್ ಪ್ರೆಸೆಂಟ್. ವೆಂಕಟರಾವ್ ನನ್ನ ಸಂಬಂಧಿಕರು ಅಂದ್ರೆ ಸರಿ. ಕೊಳಲೂರು ಜಯಪ್ಪ ನನ್ನ ಅಜ್ಜನಿಗೆ ಸಂಬಂಧಿಕರು ಹತ್ತಿರದವರು ಅಂದರೆ ಸಾಕ್ಷಿ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಪರ್ವತಪ್ಪ ನಮ್ಮ ಊರಿನವರು ಮತ್ತು ನನ್ನ ಅಜ್ಜನಿಗೆ ಆತ್ಮೀಯರು ಎಂದರೆ ಸಾಕ್ಷಿ ನಮ್ಮ ಊರಿನವರು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಈ ಮೇಲಿನಿಂದ ಹನುಮಂತರಾವ್ ಸಿಂಧೆ, ವೆಂಕಟರಾವ್, ಕೋಳೂರು ಜಯಪ್ಪ ಮತ್ತು ಪಾರ್ವತನ್ನು ನಮ್ಮ ಅಜ್ಜ ವಾದಿಯ ಪರವಾಗಿ ಮಾಡಿದ ನೀತಿಯೊಂದರ ವಿಲ್ಲಿಗೆ ಸಾಕ್ಷಿದಾರರಾಗಿ ಸಹಿ ಮಾಡುತ್ತಾರೆ ಸಾಕ್ಷಿಯು ಮಾಡಿರಬಹುದು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. In so far as, my lord, execution of will and, my lord, the witness who are, my lord, adduced evidence before court as exhibit P2 and P3 has been admitted. ಸರಿ, ನನ್ನ ಅಜ್ಜ ಮರಣ ನಂತರ ದಾವೆ ಸುತ್ತಿನ ವಾದಿಯು ಉಳುಮೆ ಮಾಡುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚಂದ್ರರಾವ್ ಅವರು ಮರಣ ಹೊಂದಿದ ನಂತರ ಈ ದಾವೆಯನ್ನು ದಾಖಲಿಸಿದ ದಿನಾಂಕದ ಸ್ವಾಧೀನ ಅನುಭೂತಿಯಲ್ಲಿ ಇರುತ್ತಾರೆ ಆದರೂ ಸ್ವಾಧೀನ ಅನ್ನುವುದು ತಿಳಿಯುವುದಿಲ್ಲ ಸರಿಯಲ್ಲ. 1985ರಿಂದ 86ರಿಂದ 1999ರವರೆಗೆ ನೀತಿ ಟೂರಂತೆ ದಾವಾ ಸೊತ್ತು ವಾದಿಯ ಹೆಸರಿನಲ್ಲಿ ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿಯು ನೀತಿ ದಾಖಲೆಯನ್ನು ತೋರಿ ಸಾಗುವಳಿ ಕಾಲದಲ್ಲಿ ವಾದಿಯ ಹೆಸರು ಸಾಕ್ಷಿ ಆ ಕಾಲಕ್ಕೆ ಒಟ್ಟು ಜಮೀನಿನ ವಿಸ್ತೀರ್ಣ 6 ಎಕರೆ 22 ಇದ್ದು ವಾದಿಯ ಹೆಸರು ಇರುತ್ತದೆ ಹಾಗೂ ಖಾತೆ ನನ್ನ ತಾಯಿ ಹೆಸರಿಗೂ ಇರುತ್ತದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ಬಿಕಾಸ್ 2 ಎಕರೆ ಮಾತ್ರ ಮಾಡಿರುವುದು. ನಾರಾಯಣರಾವ್ ಹೆಸರು ಜಂಟಿಯಾಗಿತ್ತು. ನನ್ನ ಅಜ್ಜ ಚಂದೂರಾವ್ ಮರಣ ಹೊಂದಿದ ನಂತರ ನನ್ನ ತಾಯಿ ಹೆಸರಿಗೆ ದಾವಾ ಸೊತ್ತು ಪವತಿ ಖಾತೆ ಹಾಗೂ ಪೂರ್ವದಲ್ಲಿ ನನ್ನ ಅಜ್ಜನ ಹೆಸರಿನಲ್ಲಿತ್ತು. ದೆನ್ my lord, rest of things kindly see page number 64. 63. ನನ್ನ ಅಜ್ಜ 63ರಲ್ಲಿ ನನ್ನ ಅಜ್ಜ ಚಂದೂರಾವ್ ವಾದಿಗೆ ವಿಲ್ ಮಾಡಿರುವ ವಿಚಾರ ನನಗೆ ಮತ್ತು ನನ್ನ ಸಹೋದರಿ ಗೊತ್ತಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಈ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿರುವ ಕಾರಣ ನಾನು ವಾದಿಗೆ 8,000 ಹಣವನ್ನು ಪಡೆದುಕೊಂಡು ವಾದಿಯ ಹೆಸರಿಗೆ ಖಾತೆ ಮಾಡಿಸಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಂತರ ನಮಗೂ ಮತ್ತು ವಾದಿಗೆ ಸರಿಬಾರದೇ ಇರುವ ಕಾರಣ ತೊಂದರೆ ಕೊಡುವ ಉದ್ದೇಶದಿಂದ ಇತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. Then my lord, kindly come to page 64. ನನ್ನ ಅಜ್ಜನು ಮಾಡಿರುವ ವಿಲ್ಲಿನ ಪ್ಯಾರಾ 3. ನನ್ನ ಅಜ್ಜನು ಮಾಡಿರುವ ವಿಲ್ಲಿನ ಸಾಕ್ಷಿದಾರರಾದ ಜಯಪ್ಪ ಮತ್ತು ವೆಂಕಟರಾವ್ ಹಾಗೂ ದಾವೆಯಲ್ಲಿ PW2 ಮತ್ತು 3 ರವರು ಸಾಕ್ಷಿ ನುಡಿದಿರುವ ಬಗ್ಗೆ KG ಜಯಪ್ಪ ಮತ್ತು ಹನುಮಂತ ತೀರಿಕೊಂಡಿದ್ದಾರೆ ಸರಿ. ಸಾಕ್ಷಿಗೆ ಪ್ರತಿವಾದ ಪತ್ರವನ್ನು ತೋರಿಸಿ ಇದು ನೀವು ಹಾಕಿರುವ ತಕರಾರು ಎಂದು ಸೂಚನೆಗೆ ತಹಸೀಲ್ದಾರ್ ಅವರ ಮುಂದೆ ಹಾಕಿರುವ ತಕರಾರು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. Since my lord that they have filed objection, I am constrained to file suit. My respectful submission is, the court has said in the written statement that the Chandu Ravge mentally ಸರಿ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿರ್ಲಿಲ್ಲ. And written statement of para 2 ನಲ್ಲಿ they have admitted the Chandu Rao self-acquired property. He has got independent rights. Partition took place after purchase of the property. This property is not subject matter of the partition. Everything has been admitted. But the trial court and lower appellate court hold that since you are not in position, since you have not got transferred kata, therefore, my lord, here I am failed to prove the will. Therefore, my lord, this is, my lord, the clearly, my lord, that in the partition also this property has not brought. And when I approached the Tahsildar for transfer of kata, they have objected, which is admitted. Whether after admission, whether court can give divert the judgment on the presumption and assumption, that is the question. Because my lord, admitted facts need not be proved. And the ingredients of proving the will, that whoever available at the time of execution of will before the sub-register, I have, my lord, the notice has been issued to them, and my lord, they were present, and they have, my lord, stood as witness PW2 and 3, and all documents has been marked, and my lord, position has been proved. Under those circumstances, Lord, trial court and lower appellate court has ನಾನು ಇಂಜೆಕ್ಷನ್ ಕೇಳಿದ್ದೀನಿ, restraining them to create third party interest during the pendency.
The finding of both the courts that the very will.
Yes, my lord. Supreme Court says your lordship, I did not, because my lord
is doubtful anta.
ಅಲ್ಲ, ಡೌಟ್ಫುಲ್ ಆಗಿ ರಿಜಿಸ್ಟರ್ಡ್ ಬಿಲ್,
Registered
ವಿಟ್ನೆಸ್ ಬಂದಿದ್ದಾರೆ
ಅವರು ಅಂದ್ರೆ ಸಾಲದು.
ಅಲ್ಲ,
their evidence must be credible.
ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಓದ್ಬಿಡ ಸರ್. PW1
ಓದಿದ್ರಲ್ಲ ಈಗಾಗಲೇ.
ಅಲ್ಲ, ಅವ್ರದ್ದು PW2 and they have said we are present. ಅವನು ಗುಡ್ ಸ್ಟೇಟಸ್ ಆಫ್ ಮೈಂಡ್ ಅಂತಾನೆ ಹೇಳಿದ್ರು. And cross examination also they have stated PW1 and 2 and 3. Apart from the admission,
PW 1 and 2 evidence ಅಲ್ಲಿ nowhere you have stated that the person who executed the will having sound state of mind ಅಂತ ಹೇಳೇ ಇಲ್ಲ ಇಲ್ಲವೇ. Paragraph number 17 of the trial court judgment.
ಅಲ್ಲ, ಅದೇ ನಾನು ಇಲ್ಲೇ ಓದ್ಬಿಡ್ತೀನಿ. Page 38.
ಏನೋ ಬಗ್ಗೆ ಸಂಶಯದ ನ್ಯಾಯಾಲಯದ ಸಂಶಯಕ್ಕೆ
Page number 25. I know the plaintiff and the defendant number 1 to 5, page 25. The plaintiff is the son of Ramarao and the defendant number 1 to 5 are the children of Lakshman Rao.
Issue notice and call for records.
Interim order will not do. So
Interim order.
not to create third party interest, that's it.
Nothing will happen.
Please, in the otherwise.
Concurrent finding.
Interim order, restrain them to create.
Concurrent finding. No case for interim order. List this matter on 28/7. ರಜಾಲ ಮೇಡಮ್ 26/7.
ಅದರಲ್ಲಿ ನಾಳೆ ಸೇಲ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಾರ್ದು ಅಷ್ಟೇ.
ಏನಾಗಲ್ಲ. Subject to the result of the second appeal.
91.
Much.
RL Uday Kumar, S Nagesh.
It is plaintiff's appeal, my lord. Divergent finding. Plaintiff filed a declaration, so. Declare that
Trial court comes to the conclusion that GPA and the
It's null and void.
null and void.
appellate court
Same
held
has
that
been reversed by the appellate court.
the absolute property of the D1. That is what they are. That is, through will he has got, but there is no such document. Will is not proved in accordance with law. Even after, my lord, there was the partitions filed by the first plaintiff.
Records ಬಂದಿರಲ್ಲ ಮೇಡಮ್. Call for records.
Please stay there.
List this matter on 26/7.
90. RB Sangamesh.
Sentence appeal. It is an agreement, joint development agreement not entered between the defendant number 1 to 4 and the plaintiff. Lords, during the year 2008, 5/6/2008. Lords, the plaintiff claims that they have paid an amount of ₹1,45,000 and ₹2,17,000 on two occasions. But however, notes the defendants admit only one payment, ₹1,45,000. Notes along with the agreement of development, joint development. But a GPA was also executed, an unregistered GPA, but the joint development agreement was registered. But so under this GPA, lots, this was authorizing the developer to enter into and then develop the land. But what happens is 2008, lots, after taking this joint development agreement, but the plaintiff gives an application. It was a non-converted land. He gives an application to the MUDA for change of for conversion to residential. Thereafter, he will not pursue. He keeps quiet, lots. Nothing proceeds thereafter. Not even, lots, a stone is altered in the entire land. It is as it is status. Even today, lots, we are growing the crops there. Lots, when things stood thus, lots, the defendants, lots, on and off go request them to develop, lots. Nothing proceeds thereafter except filing an application for conversion. Then, lots, having fed up with the attitude of the plaintiffs, lots, they enter into one more joint development agreement in year 2013 on 1/2/2013 with the defendant number 5 and 6. Now, lots, after the second development agreement is entered into, lots, thereafter, after 2 years, lots, the plaintiff files a suit. Lots, he frames a suit in such a manner and he does not seek for specific performance of his agreement of 2008. Without seeking for specific performance of that agreement of 2008 in which the plaintiff seeks for development, he only seeks for a relief to declare that the 2013 agreement is not binding on him and says that he is in possession of the property under the agreement and GPA, joint development agreement and the GPA of 2018 and seeks for an injunction. But the trial court notes obviously 2013 agreement, he is not a party. It is between defendant number 1 to 4 who are the owners and defendant number 5 and 6 who are the subsequent joint development holders. The trial court decrees the suit declares so far as that agreement is concerned, 2013 agreement says not binding on the plaintiff, but also grants an injunction laws, holding that under the GPA, the plaintiff is put in possession, therefore injunction is granted. Lots, in the appeal filed by the defendant, the appellate court modifies the decree. Lots, 2013 agreement not binding declaration, lots, that is upheld as it is, but appellate court says injunction cannot be granted because the plaintiff claims to be a developer, and even if he claims that he is in possession as an agent of the defendant because defendants are accepted as the owners. Therefore, injunction cannot be granted, and lots, he modifies the decree, trial court decree,
And my lords, he says that the defendants are entitled the plaintiffs are entitled to proceed with the development work as per the earlier agreement of 2008 Exhibit P1. This is the modified decree. Lords, the defendants in this appeal, lords, state that, lords, without seeking for declaration of specific performance of 2008 agreement, lords, 2008 agreement admittedly is entered. Lords. However, there is a dispute with regard to the advance and security deposit. We admit only the first payment of 1,40,000. The second payment of 2,17,000 is created. The defendants deny the signature. Nevertheless, lords, keeping that apart for a moment, lords, the joint development agreement of 2008, it is executed. Thereafter, nothing proceeds. Till 2015, they keep quiet. They suddenly file a suit after about 7 years without seeking for specific performance of 2008 agreement and only seeking for declaration that the 2013 agreement is not binding. Lords, my primary submission is that the suit for declaration without seeking for 2008 agreement for specific performance, Lords, the suit framed in the present form seeking for only the relief with respect to 13 agreement, Lords, is not maintainable.
Issue notice, call for records.
Interim order in ಕೇಳಿದಿನ interim order ಕೇಳಿದಿನ stay of that judgment ಅಂತ
Records ಬರ್ಲಿ ನೋಡ್.
93, Ramesh K. Harish S.
This is defendant's appeal. Now, for the plaintiff, respondent had filed a suit. For specific performance, alleging that the the appellant herein had executed an agreement of sale with respect to an ancestral property, agreeing to sell the social property in their favor. And the contents of that agreement or that, they have sale consideration was fixed at rupees 8,50,000 and a sum of rupees 8,40,000 was given and another sum of rupees 10,000 rupees was furnished according to them. Lord, the plaintiff has denied the execution of the agreement of sale for this reason, Lord. Lord, earlier, as a security for some loan obtained from the respondent plaintiff's husband, the respondent plaintiff husband, along with the present plaintiff number 1, had executed an agreement of sale, Lord, in favor of the respondent's husband. May I pass on this compilation? Lord, that agreement, the Lordship may kindly peruse page number 95 of the compilation.
95.
Earlier agreement was one agreement as a security to the respondent's husband was executed by the husband of the first plaintiff, who is no more now. But that was executed on 16/6/2011. This is cancelled, my lord.
On 9/5/2013.
On 9/5/2013. But here, your lordship may kindly see, eitherly recitals, my lord, at page 97. Cancellation. Para 3 ಮರು ಆದರೆ ಇನ್ನುಳಿದ ಕ್ರಯದ ಮೊಬೈಲ್ ಹಾಗೂ 25,000 ರೂಪಾಯಿಗಳನ್ನು ಸ್ವತ್ತಿನ ಸೂಕ್ತ ದಾಖಲೆಗಳನ್ನು ಒದಗಿಸಿಕೊಂಡು ಕ್ರಯಪತ್ರವನ್ನು ನೋಂದಣಿ ಮಾಡಿಸಿಕೊಳ್ಳಲು ನನ್ನಿಂದ ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಆದ ಕಾರಣ ಈ ಹಿಂದೆ ಮುಂಗಡವಾಗಿ ನೀಡಿದ 8 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಈ ಕರಾರು ಪತ್ರಕ್ಕೆ ಸಾಕ್ಷಿ ಹಾಕಿರುವವರ ಸಮಕ್ಷ ನಗದಾಗಿ ಪಡೆಯುತ್ತೇನೆ. ಮುಂಗಡ ಹಣ ನನಗೆ ಸಂಪೂರ್ಣ ಸಂಗ್ರಹವಾಗಿರುತ್ತದೆ. ಯಾವುದೇ ಬಾಕಿ ಬರಬೇಕು ನನ್ನ ಹೆಸರಿಗೆ ಬರೆದುಕೊಟ್ಟ ಕ್ರಯಪತ್ರದ ಕರಾರು ಪತ್ರವು ಈ ರದ್ದಿಯಾದ ಪತ್ರದಂತೆ ರದ್ದುಗೊಳಿಸಿ ಬರೆಸಿಕೊಟ್ಟಿರುತ್ತೇನೆ. Not this. Now, the present agreement of sale, which is sought to be executed, my lord, is also on the very same day, in favor of the respondent plaintiff. ಅದು ಇದರಲ್ಲಿ ನಮಗೆ ದುಡ್ಡು ಹಂಚಕ್ ಆಗ್ಲಿಲ್ಲ, ವಾಪಸ್ ತಗೊಂಡಿದ್ದೀವಿ ಅಂತ. But while registering this document, my lord, they have fraudulently obtained the other document also. Continuation number. Now your lordship may kindly peruse exhibit P1. This is, my lord, at page 61. Immediate next document. Registration,
61.
please. ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಕ್ರಮವೇನೆಂದರೆ ನಮ್ಮ ದರದ ಮಿತಿ ಅಂದರೆ ಗೃಹ ಕೃತ್ಯದ ಖರ್ಚಿಗಾಗಿ ಹಾಗೂ ಸಾಲ ತೀರುವಳಿ ಮಾಡುವ ಉದ್ದೇಶದಿಂದಲೂ ಸಹ ಶೆಡ್ಯೂಲ್ನಲ್ಲಿ ಸಹ ಉದಾಹರಿಸಿರುವ ನಮ್ಮ ಪಿತ್ರಾರ್ಜಿತ ಸ್ವತ್ತನ್ನು ನಿಮಗೆ ಇಂಡಿಯಾ ಗೌರ್ಮೆಂಟ್ ಚಲಾವಣೆ ರು 8,50,000 ರೂಪಾಯಿಗಳಿಗೆ ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಕೊಡಲು ಒಪ್ಪಿರುತ್ತೇವೆ. ಕ್ರಯದ ಪೂರ್ವ ಮುಗುಲಗು 8,50,000 ರೂಪಾಯಿಗಳ ಪೈಕಿ ಕ್ರಯದ ಮುಂಗಡವಾಗಿ 8,40,000 ರೂಪಾಯಿಗಳನ್ನು ಈ ಕರಾರು ಪತ್ರಕ್ಕೆ ಸಾಕ್ಷಿ ಹಾಕಿರುವ ಸಮಕ್ಷಮ ನಗದಾಗಿ ಪಡೆದಿರುತ್ತೇವೆ. ಇನ್ನುಳಿದ ಕ್ರಯದ ಮೊಬಲಗು 10,000 ರೂಪಾಯಿಗಳನ್ನು ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ಕ್ರಯಪತ್ರದ ನೋಂದಣಿ ಮಣಿಯಲ್ಲಿ ಉಪನೋಂದಣಿಗಾದಿಗಳ ಸಮಕ್ಷಮ ನಗದಾಗಿ ಪಡೆಯುತ್ತೇವೆ. ಇದನ್ನು ಅದೇ ದಿವಸ ಹೆಂಡತಿ ಹೆಸರಿಗೆ ಪ್ಲೈಂಟಿಫ್ ಹೆಸರಿಗೆ ಮಾಡ್ತಾರೆ. ಕ್ಯಾನ್ಸಲ್ ಇಮಿಡಿಯೇಟ್ ಎರಡೂ ಸೈಮಲ್ಟೇನಿಯಸ್ ಆಗಿ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ. ಒನ್ ಆಫ್ಟರ್ ದಿ ಅದರ್. ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 138, ಇನ್ನೊಂದು ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ 139.
ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ.
ಅಲ್ಲ ಇದ್ರಲ್ಲ ದೇ ಸೇಮ್ ಲೋಡ್ ಒನ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೂವ್ಡ್ ದಿ ಪೇಮೆಂಟ್. ಆನ್ ದಿ ಅದರ್ ಹ್ಯಾಂಡ್ ದೇ themselves have deposed. They have stated in the one deed ballot saying that they don't have money. But apart from that, my lord, even in their client, my lord, they themselves have stated. Client is at page 2, my lord, of the compilation. ಇದರಲ್ಲಿ ancestral property minors is the second and third appellants are the minors. ಅವ್ರದ್ದು interest ಆಗಿದೆ. Even there is not even a recital for the sake of minors interest we are selling this property. Page 2 of the plaint, my lord, with the compilation. ಅದರಲ್ಲಿ para 2 ನಲ್ಲಿ it is submitted that the defendants are the absolute owners in and enjoyment of the social property, and it is the ancestral property of the husband of the first defendant. But the husband of the first defendant is no more, my lord. Against the wife and children they have obtained a decree. ಆ ಎರಡು ಡಾಕ್ಯುಮೆಂಟ್ ನ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅವರಾಗ್ಲಿ ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅವರಾಗ್ಲಿ ಕನ್ಫರ್ಮ್ ಮಾಡಲೇ ಇಲ್ಲ.
What is your specific defense?
But we have not executed this, this
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅದು ಗೊತ್ತಿಲ್ಲದೇನೆ ಫ್ರಾಡ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು ಹೇಳಿ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಕೈಂಡ್ಲಿ our defense is at page 8, my lord. The written statement.
Fraud in ಬಗ್ಗೆ ಏನು? What is the material? Mere taking of contention that it is a fraud is not enough. There must be some material that they played the fraud.
The circumstances and exhibit D1 ಮತ್ತೆ P1 came into existence. ಅದು ಒಂದು circumstance ಮತ್ತೆ contents of that my lord, if at all ಅವ್ರು 8,40,000 ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಕೊಟ್ಟಿದ್ರೆ they could have got it registered on the very same day. 10,000ಕ್ಕೋಸ್ಕರ ನಿಲ್ಲಿಸ್ತಾ ಇರ್ಲಿಲ್ಲ. Sale consideration 8 lakhs. Property value is more than 40 lakhs. Market value is. We have the alleged registered sale deed is concocted document. In fact, no consideration is passed.
Where is your evidence, counsel?
Please.
Where is your evidence?
Please.
ಹಾಕ್ಲಿಲ್ಲ ನೀವು ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್?
ಇಲ್ಲ ಹಾಕಿಲ್ಲ. ಇದೆ. Page 50, my lord.
Page
50, 50 in the compilation.
50.
Please. So as is below and Sharathan and Prabhuti, after the death of Vijay Kumar, I and my children have succeeded to the second property and being in possession in the state. I submit that the defendants are attached in the property. There are no manner of state, cultural or interest, after possession of the people. In spite of the defendant, in spite of the defendant, and this is in confront of the property. Not ಇನ್ನೊಂದು ಬೇರೆ ಸ್ಟೂಡೆಂಟ್ ಸಾರಿ
Earlier agreement na cancel ಮಾಡಿ ಹೊಸ agreement ಬರ್ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ನಿಮ್ಮ admissions ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
ಇಲ್ಲ ಅದನ್ನ ಡಿನೈ ಮಾಡಿ
ನೀವೇ ಹೋಗಿದ್ರಿ 9/5/2013 ಹುಲಿಯೂರು ದುರ್ಗ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಚೇರಿಗೆ ಹೋಗಿದ್ದೆ. ಆ ದಿನ ವಾದಿಯಾದ ವರಲಕ್ಷ್ಮಿ ರಾಮರಲ್ಲಿ ಬಂದಿರಲಿಲ್ಲ. ವಾದಿಯ ಗಂಡನಾದ ನಾಗರಾಜರವರು ಬಂದಿದ್ದರು ಎಂದರೆ ಸರಿ. Why he came to if you are not executed the sale agreement?
On the very same day, under the guise of cancellation of the earlier agreement of sale made in favor of her husband, my lord. They have, without the knowledge of this,
you can say
appellate, my lord, they have taken this circumstances.
out of total sale consideration, you have received an amount of rupees 8,40,000. Only balance is only 10,000. That's all.
Earlier agreement allu adane ಹೇಳ್ತಾರೆ.
ಆಯ್ತು ಇರ್ಬೋದು.
Earlier agreement allu adane ಹೇಳ್ತಾರೆ.
ಅದ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಹೊಸ
it is for none other than the husband of the plaintiff respondent, my lord.
And the sale agreement is also registered sale agreement.
Please, my lord, if at all, if that agreement were genuine, they could have got the sale deed executed in their favor, my lord, instead of executing another agreement.
Maybe they are not having any interest to have the property.
ಅದರಲ್ಲಿ ನಮ್ಮ ಹತ್ರ ದುಡ್ಡಿಲ್ಲ ಅನ್ನೋದನ್ನು ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. Payment is also not true.
Concurrent pending counsel, no ground. No grounds.
ಮೋಸ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಮೋಸ ಆಗಿದ್ದಕ್ಕೆ ಏನಾದ್ರು ಎಲಿಸಿಟ್ ಮಾಡಿಸ್ಬೇಕಲ್ಲ. ನಥಿಂಗ್ ಇಸ್ ಎಲಿಸಿಟೆಡ್. ಎಲ್ಲಿದೆ ಎಂತದೂ ಇಲ್ಲ. ಮೋಸದ ಬಗ್ಗೆ ಏನಿಲ್ಲ.
ಅಲ್ಲ ಕನ್ಕಾಕ್ಟೆಡ್ ಆಫ್ ಡಿಫೆನ್ಸ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. A document itself, circumstances under which it has come into existence, my lord, that itself establishes, my lord, there is a fraud. Fraud, my lord. ಅವ್ರದೇ ರಿಸೈಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಹಣ ಇಲ್ಲ
ಅದ್ರಲ್ಲಿ ಏನು ಹೇಳ್ಸಿಲ್ಲ.
ಆ ರಿಸೈಟಲ್ your lordship may kindly see the recital of that exhibit D1, my lord. Cancellation of the agreement. ಅದನ್ನ ಹಣ ಇಲ್ಲದೆ ಇರೋದಕ್ಕೆ ನಾವು ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ತಿದೀವಿ ಅಂತ ಇಲ್ಲೇ ಹೇಳ್ತಾರೆ. ಅಲ್ಲಿ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಪೂರ್ತಿ ಹಣ ಕೊಟ್ಟಿರೋ ತರ ಮಾಡ್ತಾರೆ.
Call for records, issue notice.
94. MD 72.
This matter on 26/7.
90th appeal. 90th appeal.
Dismiss ಆಗಿದೆ, ಕನ್ಫರ್ಮ್ ಆಗಿದೆ.
Paragraph 14.
Put for declaration and permanent injunction.
65 para 14. Page 65 para 14.
65. Para 14.
Setting aside the compromise decree, suit has been. Fraud has been alleged. Fraud has been alleged. So far as the compromise is concerned. Separate suit not maintainable anta vacha ಮಾಡಿ. Separate suit is not maintainable.
ಯಾವ್ದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ?
Set aside the compromise decree. That is the only reason on which suit has been dismissed. I should have approached the very same court, filing an application.
ಹೌದು, ಅಲ್ಲೇ ಹೋಗ್ಬೇಕಲ್ಲ. ಫ್ರಾಡ್ ಬಗ್ಗೆ ಯಾರು ಅಲ್ಲೇ ಹೋಗ್ಬೇಕು. Third party can file a separate suit, that's all.
Third party, and I am a party to the compromise decree.
ಮತ್ತೆ
I have to go to the very same.
ಅಲ್ಲಿಗೆ ಹೋಗಿದ್ದೀರಾ? ಅಲ್ಲಿಗೆ ಹೋಗಿಲ್ಲಲ್ಲ ನೀವು? ಮತ್ತೆ
Separate suit ಹಾಕಿದ್ದಾರೆ.
Recently, I also passed an order last week. If he is a third party, he is not a party to the compromise, then he can file a suit. Or otherwise, if a party alleges any fraud, Then they have to challenge the same in the very same court, that's all.
ground ಮೇಲೆ ವಜಾ
ಹಾ?
ground ಮೇಲೆ ವಜಾ ಮಾಡ್ತಾರೆ.
ಅದೇ ಗ್ರೌಂಡೇ ಮಾಡ್ಬೇಕು, ಮತ್ತೆ ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಬೇರೆ ಏನಾರು ಮಾಡಕ್ಕಾಗುತ್ತಾ? ಇಲ್ಲ. No grounds, third. Had the appellant counsel matters listed for admission. This appeal is filed against the concurrent judgment. The case of the plaintiff before the trial court, while seeking the relief of declaration to declare that he himself and defendant number 2 to 4 are the joint owners of the social property, and to declare that the compromise decree passed in OS number 10 of 2000 dated 21/4/2009 is partly null and void with respect of the share allotted to the first defendant and for consequential relief of permanent injunction, restraining the defendant number 1 or any other acting under him in any mode from interfering with plaintiff's peaceful and possession of the social property. The main contention of the plaintiff also in the said suit that he along with deceased M.S. Manjunatha are the giant owners of the social property. And also claims interference by the defendants with his peaceful possession and enjoyment of the social property. And also it is his contention that compromise decree passed by the court in OS number 10 of 2000 is void in respect of share allotted to the defendant number 1. When defendant appeared and filed the written statement that plaintiff is not entitled to the relief sought for until setting aside of decree in OS number 10 of 2000. And also contend that suit is barred by limitation. The trial court, having considered the material on record, answered the issue number 1 to 3 as negative and accepted the contention of the defendant that unless the compromise decree passed in OS number 10 of 2000, plaintiff is not entitled for any relief. Compromise ಯಾವಾಗ ಆಗಿರೋದು actually?
Compromise was dated 21/4/2009.
9 suit file ಮಾಡಿದ್ದು
8 ವರ್ಷ ಆದ್ಮೇಲೆ.
8 ವರ್ಷ ಆದ್ಮೇಲೆ. And also comes to the conclusion that suit is barred by limitation. After prolonged period of compromise, suit is filed. Being agreed by the judgment and decree of dismissal of the suit, appeal is filed in RA number 5020 of 2023. The appellate court also on reconsidering both oral and documentary evidence available on record comes to the conclusion that trial court has not committed any error, even extracted the answer elicited from the mouth of witness, particularly in paragraph number 15 of the judgment. And also comes to the conclusion that actively participated in the proceedings in OS number 10 of 2000. The same was presented before the court and pleaded. And when already there was a compromise in accordance with law wide order dated 21/4/2009 and not proved the fraud or misrepresentative facts, then answer the point as negative. Being agreed by the concurrent finding, the present appeal is filed. The main contention of the counsel appearing for the appellant that both the courts failed to consider the decree obtained in OS number 10 of 2000 is the outcome of fraud. And the very fraud vitiates everything including the decree of the court. And both the courts failed to consider that since the compromise itself is void, the suit to set aside the said compromise is competent and maintainable. When the allegation of fraud is made, both the courts ought to have considered the same. The council also vehemently contend that this court has to frame the substantive question of law, whether the courts below were justified in dismissing the suit of the plaintiff as barred under Order 23 Rule 3A of CPC, and whether courts were justified in dismissing the suit of the plaintiff, ignoring the plea of fraud set up by the plaintiff, seeking set up a decree dated 21/4/2009. And both the courts have committed an error. Having considered the factual matrix of the case, is very clear that earlier suit was filed and decree was passed. And also, it is very specific that when the fraud has been alleged by the plaintiff in obtaining the earlier compromise, ought to have approached the very same court and not approached the very same court. Since the suit is also barred under Order 23 Rule 3A of CPC, the apex court also held that if any allegation of fraud in respect of any compromise decree, and if he is a party to the proceedings also, party to the compromise also, there cannot be any separate suit, as there is a bar under Order 23 Rule 3A of CPC. And trial court also taken note of the setback into consideration, particularly in paragraph number 13. And even relied upon the judgment of the Supreme Court, and comes to the conclusion that there cannot be any independent suit while dismissing the appeal. The first appellate court also having taken note of the material on record, and also comes to the conclusion that when he was a party to the compromise, and if it is any fraud, the same has to be proved before the very same court and not before filing any independent suit. And law is also settled with regard to the setback into consideration of Order 23 Rule 3A of 23 Rule 3A. And when such being the case, I do not find any error committed by trial court and also the first appellate court in dismissing the suit, and hence it doesn't require any interference of this court to admit and frame any substantive question of law. In view of the discussions made above, I pass the following order. Suit is dismissed.
I seek permission to approach the very same court by me. I seek the permission of the court to.
ಏನ್ರಿ 2009 ಕಾಂಪ್ರಮೈಸ್ ಈಗೇನು ಹೋಗಲ್ಲ ಇದ್ ಮಾಡ್ತಿದ್ ಬನ್ನಿ. ಆಯ್ತು ಮುಗಿದೋದ್ ಕತೆಗ್ ಮತ್ತೇನ್ ಜೀವ ಕೊಡಕ್ ಟ್ರೈ ಮಾಡ್ತೀರಿ? ಆಯ್ತು.
Reporting settlement 95.
ಸಂಪತ್ತೇ KP's 1.
Matter in last occasion I submitted, my lord, there is no settlement, and I will go on with the matter on. Please, lords, this appeal is by the defendant number 5. Suit is for partition. I am the purchaser. The genealogical tree lordship find at my lord page number 76. Typed copy at page number 77.
77.
It's exhibit piece 17 submitted by them, my lord, before the court below. My lord, the Melagiri Gowda, my lord, is the original grandfather who married to Srimati Irama, and the property purchased by my lord, the Melagiri Gowda. My lord, he had 3 children, my lord, Shivana, Gaurama, Gurusiddhamma, and these are the daughters, my lord. The claim is only with respect to Shivana. Shivana has expired, my lord. Because of this, his death, the property of the Melagiri Gowda directly devolved on H. Devi Ramma. Now, my lord, the parties, my lord, are claiming, my lord, through the Devi Ramma. My lord, the HS Uma is the plaintiff number 1. And my lord, the 2 daughters, my lord, HS Uma and HS Mamta, the last person, my lord, are the plaintiff 1 and 2, my lord. And my lord, 3rd daughter, Srimati HS Manjula, is expired. Her son has not been shown, my lord, he is Abhishek. He is plaintiff number 3. My lord, these 3, my lord, persons filed a suit against, my lord, the HS Manjunath, who is expired, my lord. So the 2 wives they have mentioned, H. Lalita, they shown she is expired. And my lord, Nagaratna is a 2nd wife, they claim. She has not been made as a party, she is a widow. Now, my lord, for this person, there are 3 children, my lord, they shown as Abhinaya, who is a D1, Shruti D2. Navin, my lord, is also shown, his name is also pleaded in the plaint, but he has not been made a party. And they stated, my lord, he is missing. Missing anta ಹೇಳ್ತಾರೆ. Lord, next is HS Nilakanta, my lord, he is one of this son. He has been made as a defendant number 3. And my lord, HS Mamta is a plaintiff number 2. My lord, the original exhibit, page number 76, my lord. Exhibit P70 is the genealogical tree they produced. My lord, the two names which I took is that, my lord, the Srimati Nagaratnam, bottom ಅಲ್ಲಿ ಸುಳಿವಿಲ್ಲ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಅಂಡ್ my lord, ಅಲ್ಲಿ ಬಾಟಮ್ ಕೆಳಗಡೆ
ಮಕ್ಕಳಿಲ್ಲ.
ಮಕ್ಕಳಿಲ್ಲ ಅಂತ ಸುಳಿವಿಲ್ಲ ಅಂತ ಮೇ ಬಿ ಇಷ್ಟು ಮಕ್ಕಳಿಲ್ಲ ಅಂತ. She has, there is no information about her, whether she is alive or not. She has not been made a party.
You are the purchaser.
I am the purchaser.
From whom you have purchased the property?
Lord, I have purchased from the two brothers, that is, my lord, the HS Nilakanta and his family, HS Manjunath and HS Nilakanta, two brothers, my lord. From them, I have purchased a property. In fact, they executed a GPA, registered GPA in favor of defendant number 4. Based on that, my lord, defendant number 5 sold to me, my lord. My lord, see, Naveen, my lord, they sold, my lord, Kane agidare anta. My lord, there is no relief, my lord, sought in respect of this Nagaratnamma and this Naveen, my lord, even though, my lord, they have a right of the property. My lord, not making all the co-partners, my lord, as a necessary party is also one contention. Another contention is that, my lord, this is a case where, my lord, there is a lack of pleadings from my hand with respect to the contention. The subject properties, my lord, the 5 acres, my lord, 15 guntas. My lord, out of this, my lord, and 36 guntas each, my lord, has been granted by the land tribunal in favor of 3 persons, my lord. My lord, that is in the year 7/5/1987. My lord, those 3 persons and these 2 brothers, my lord, jointly executed this composite property in my favor. My lord, the exhibit P1 is the GPA. In that, my lord, there is a specific recital that this land has been granted in favor of the 3 persons. My lord, that has not been challenged by the family members. My lord, they executed a GPA and from them I purchased. No, my lord, even assuming, my lord, the partition is, they are entered for the partition. For the three persons who has got a, my lord, certain portion, that is 2 acres, 15 guntas, which is granted in the land tribunal. For that, my lord, these plaintiffs have no rights because it has been granted, it has been granted in favor of the land tribunal. And the very same document which they produced, my lord, said that is a recital to that effect. My lord, even assume, my lord, there is a partition for this extent, my lord, they have no claim, is my humble submission. And secondly, my lord, only my property of purchased by me has been sought for a partition. They also not pleaded that they have no other properties. And this is the only property. Even the pleadings on them is also lacking on that part.
Is it your case that they are having other properties also?
My lord,
Other than the property which you have purchased?
no, my lord, they are no,
Pleading anta kelide.
no, there is a case of lack of pleadings, my lord, that in the cross-examination suggestion was made to some of the property. They pleaded ignorance, my lord. Lord, the case, my lord, both the learned trial courts dismissed on the ground that, my lord, though I set up a defense in the cross-examination, I confronted the land tribunal order, shown them this is the order to a certain extent, that is 36 guntas, each has been granted in favor of 3 persons. And so that, my lord, the claim is only about the remaining extent, not against the 36 guntas, my lord, 2 acres, 15 guntas. That has been, the document has been marked, my lord, it has been confronted. And my lord,
Confronted, what is their reply to the confrontation of those documents?
Lord, they confronted, my lord, ಯಾವುದೇ ಜಮೀನು ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತ they stated.
They denied.
They denied there ಯಾವುದೇ ಜಮೀನು ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತ. But the family members, my lord, who was the brothers are executed, my lord, only the remaining extent, my lord, they agreed jointly it has been executed. Now, my lord, the point for lack of pleadings, my lord, regarding that, the board court held, my lord, though you set up a defense in the evidence of trial, but there is no pleadings, I cannot look into them. Though, my lord, it's a sound rule.
First, there must be a pleading and then you can set up any defense.
Please, my lord, but my lord, please, my lord, but the one citation of the Constitution bench of the Honorable Supreme Court regarding this, my lord, they took an exception to hold that, my lord, if the parties who step into the case and who step into the witness, he knows that such an incident, he knows about the defense, which is implied, my lord, because he has produced a sale deed. In the sale deed, my lord, there is a mention about the land grant of land tribunal. It's deemed that, my lord, he is aware of the defense which I set up. My lord, that is what the exception taken by.
Not enough.
Please, my lord, so that, my lord, I confirm.
At least when you took this contention also.
Please, my lord.
You would have placed the material before the trial court also that family is having other properties.
It's not on far.
As well as these properties are exclusively belongs to them.
Regarding family property, partial partition, my lord, I will not much argue because, my lord, no material is produced. My arguments will stick on to that, my lord, the properties granted in favor of the land tribunal. That is 36 kuntas each, my lord, that's 2 acres, 15 kuntas. Regarding that, my lord, I will say much
That is
press on.
exhibit D1 to D3.
Please, my lord. D1 is the land tribunal order. And, my lord, regarding the defense, my lord, that a certain portion of the land is granted, is aware to them because, my lord, they produce the sale deed and GPay, which is exhibit P1. The recital contains there too. And, my lord, regarding the lack of pleading, my lord, the one cited constitution bench decision may be permitted, my lord. May just take lordship to the exhibit P1, my lord, for better understanding. It's in my
Different number?
different number 5, my lord, the purchaser. Please. 4 is the GPay holder. The family members, brothers are executed.
Both of them are not entered into the witness box.
Please, my lord, that is also one they are not done. But based on the available records and the evidence, my lord, I may be
They
permitted.
have
my lord.
not had any evidence before the trial court.
Please, my lord, because of this confrontation, my lord, they believed that, my lord, it could be defeated.
Yes, counsel, what do you say?
The first time he is taking a defense. Maybe the details filed by you can go on aggregate. In the written statement, you can go on file whether you another revenue record of the there was the absolute owner of the project. The same data from the other family. Look at them, I saw this to get the general cover of the family over the all the revenue records were located and entered in the He's never visual recording not there of candidate land. First time he has taken wrongs in the appeal. Changing all
As I earlier submitted.
Here also there is a clear admission on the part of you.
Please, my lord.
Property derived to the Mailari,
Please, my lord, that is not in dispute, my lord.
Thereafter.
That is not in dispute, my lord.
Now, how can you contend that?
That purchase
some of
property
the-
has, please, my lord, that purchase property has been granted in the land tribunal.
Nothing on record, told.
Well, just two more submission, please, my
Great.
only submission. Lord, though it may be, my lord, I admitted, but my lord, the land tribunal has been granted, my lord, that is not in dispute, my lord, exhibit D1. I'm not erring the necessary parties, my lord, those two persons who also has a right, that is Srimati Nagaratna and Naveen. My lord, there is no space, a relief against them, my lord.
Did only equity in respect of the property from whom you have purchased the property, your interest can be protected, that's all.
Please. That's all, my lord, but this suit is not mental. But
ಹಾಕಿದ್ದೀರಾ ನೀವು? ಹಾಕಿದ್ರಿ, ಪೆಂಡಿಂಗ್ ಇದೆ.
My lord, they have not made all the parties, my lord, as
Both
that's,
seek remedy, that's all.
no, my lord, so 2 members has not been made a party, my lord, that's also, is their own document,
Pay ground now.
no, my lord, regarding the lack.
I will give liberty to them to claim there in FDP, even if they have not been made as parties.
My lord, regarding lack of pleadings, my lord, I just relay one decision, my lord. I do understand, my lord, some lack of pleadings.
ಫೌಂಡೇಶನ್ ಇಲ್ದಲೆ ಬಿಲ್ಡಿಂಗ್ ಹೆಂಗ್ರಿ ಕಟ್ತೀರಾ?
ಸ್ವಲ್ಪ ಆತರ ಆಗಿದೆ, ಬಟ್ my lord, the documents
ಸ್ವಲ್ಪ ಆತರ ಆಗಿಲ್ಲ.
ಅಂದ್ರೆ
ಆತರ ಆಗಿದೆ. ನಿಮ್ಮ ಸ್ಪೆಸಿಫಿಕ್ ಪ್ಲೀಡಿಂಗ್ ಅದು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ವಾಟ್ ಹಿ ಹ್ಯಾಸ್ ರೆಡ್.
my lord, they said absolute owner of the properties of the entirety ಅನ್ನೋ ಬದ್ಲಿ ಆತರ ಇದೆ.
No consult. This matter is listed for admission, reporting settlement, and both of them said made the submission that there is no any element of settlement. And hence this court taken up this matter for admission. The counsel appearing for the Akin Munche, the factual matrix of the case of the plaintiff before the trial court, that plaintiffs, the associated properties are the ancestral joint family properties of the plaintiff and defendants. And also their contention that they are the members of Hindu undivided joint family. And also the specific case that one Shivanna was the propositor of the family, joint family of the plaintiff and defendant 1 to 3, who died intestate leaving behind his wife, Srimati Devi Ramma, who also died intestate leaving behind their children. They also left behind the social properties of the ancestral joint family properties of plaintiff and defendant 1 to 3. The revenue records were stood in the name of above said Devi Ramma, the mother of the plaintiff till 2005. And on verification, the plaintiffs learned that the defendant number 1 to 3 have said to be executed, registered power of attorney dated 13/7/2005 in favor of the 4th defendant, who in turn executed a registered sale deed dated 17/8/2005 in favor of the 5th defendant. Though the defendants number 1 to 3 having no exclusive right to alienate the social property, in which plaintiffs each entitled for their 1/4 legitimate share, and therefore above said alleged general power of attorney and the sale deed are not binding on them, and hence filed the suit for the relief of partition and separate claim. The defendants appeared. They are very 4 and 5 matra appear agilla.
1 to 3
1 to 3 appear agilla.
1 to 3 expert
did not appear, and defendant number 4 and 5 appeared and filed the written statement, wherein also they admitted that property was purchased by property was originally belonged to Govinda Raja Shetty, who was the absolute owner of the agriculture property, and Govinda Raja Shetty along with his sons sold the agriculture property, survey number 33/2, along with other properties in favor of Mailagiri Gowda, alias Mailagiri Gowda, son of Hanumante Gowda, who had sale deed dated 27/7/1954. And mutation also came to be affected in MR number 2 of 54. And also the said Mailari Gowda died leaving behind his legal heirs, that is Srimati Devamma, who is the wife of late M.H. Shivanna, the son of Mailari Gowda. And mutation also was transferred in favor of Devi Ramma, MR number 31 of 93-94. After the demise of Devi Ramma, the said property has devolved on her 2 sons. And MR also changed in their favor, IHC number 5 of 2005, and MR number 32 of 2004-5, dated 5/7/2005. And thereafter, both the sons are the absolute owners of the property, and one of the son executed bar general power of attorney in favor of defendant number 4, and general power of attorney holder That is defendant number 4 has executed sale deed dated 17/8/2005 and delivered the possession in favor of defendant number 5. And pursuant to the sale, all the revenue records are changed in their name, and hence the defendant number 5 is the bona fide purchaser of the social property for valuable consideration. The trial court, having considered the material and record, and there is no dispute with regard to the relationship between the parties, and having considered the material and record, also comes to the conclusion that social property is an ancestral property, and plaintiffs are also the members of the joint family property, and not accepted the contention of the defendant that he is the bona fide purchaser, since he himself has pleaded that two sons are the absolute owners of the property and not made any effort before purchasing the property to verify with regard to the title whether any other shareholders are there. Hence, the trial court granted 1/5 share in favor of the plaintiff. Being agreed by the said judgment, an appeal is filed, and appellate court also, having considered the grounds urged in the appeal memo, formulated the points whether the trial court committed an error in decreeing the suit, and having reassessed the material available on record, dismiss the appeal, being agreed by the said judgment, said concurrent judgment. Present case is filed, present second appeal is filed before this court. The main contention of the counsel appearing for the appellant, that both the courts failed to appreciate that plaintiff had not established that the entire social property belonged to the family. It was available for partition. And also counsel would immediately contend that the land tribunal passed an order to the extent of 36 guntas each in favor of the 3 persons, and document exhibit D1 is also confronted. So there may not be a specific pleading in respect of the land tribunal order, but defendant number 4 and 5 were able to establish their case by confronting document exhibit D1 during the course of cross-examination, and this has not been considered by the trial court as well as the first appellate court. And hence this court has to frame the substantive question of law, particularly in respect of document exhibit D1 was marked. And the preliminary decree passed without ascertaining the availability of the social property for the partition for the plaintiffs, and hence this court has to frame substantive question of law. For account of the counsel appearing for the respondent brought to notice of this court of the very pleadings made by the appellant, and he accepted the property belongs to the family of propositors Mailari Goda, and he died intestate, and also property devolves upon his son Shivanna, and he died also intestate, and property devolves upon the plaintiffs as well as other
Defendant 1, 2, 3.
other sons. And the very pleading is also very specific. Only they claim that two sons are the absolute owners and not denied the relationship between the parties. And now the appellant cannot contend and raise new ground that property is not amenable for partition, relying upon the document exhibit D1 and no pleading except confronting the document of exhibit D1 before the trial court. And both of the trial court as well as the appellate court considered the material and record in the absence of any pleading. The new ground cannot be urged, and only in the first appellate court the said ground has taken, and hence no substantive question arises for the admitting and framing of substantive question of law. Having heard the appellant counsel and also the counsel appearing for the respondent, court has to take note of the pleadings of the plaintiff as well as the defendant. And admittedly, defendant number 1 to 3 have not appeared and contested the matter. Only defendant number 4 and 5 appeared and contested the matter, and also having taken note of the pleading in respect of the property belongs to the original propositors Mailari Gowda is not disputed. And the fact that they have purchased the property only by two sons of the said Shivannala, said Shivanna is also not in dispute. And the plaintiffs are also the daughters of said Shivannalva.
Out.
Shivanna is also not in dispute. And having taken note of the said material on record, when there is a clear pleading and admission before the court that originally property belongs to the Mailari Gowda and excluding of the daughters if any property is sold by other two sons. And also this same is purchased in the year 2005 subsequent to the amendment to the Succession Act. And when such material available on record, the first appellant cannot be permitted to raise new plea before this court without any pleading. And the law is also settled that the same cannot be done. And when such being the case, I do not find any error committed by the trial court as well as the first appellate court in granting the relief and confirming the same. However, this court can take note of the interest of the purchaser who is the appellant before this court, and FDP is pending before the trial court. He can seek for the remedy before the FDP court for equitable partition. And other contention also raised by the appellant that all the family members have not been made as parties, even in the absence of all members of the family not made as parties. Even those family members have not been made party also can be claim their claim before the FDP proceedings in respect of their respective share, if they are willing to get the share in the family property. With this observation, the petition appeal is disposed of.
Please, oblige.
Started in hearing matters, 96. 80 Nagraj.
Parted matter, and in the last occasion, this honorable court has appointed the ADLR for survey of the lands and identification of the who are in possession of the property. Report has been come, please, my lord.
Report hakidara,
But we have not received the report. The contents of the report I do not.
copies thoroughly, objections are.
Please.
The ADLR was court has submitted his report to the court. And if parties have any objections to the report, can file objections to the said report. This matter after 2 weeks. ಆಗ್ಬೋದಾ? ಯಾವಾಗ ಪಾರ್ಟೆಡ್ ಆಗಿರೋದು ಲಾಂಗ್ ಬ್ಯಾಕ್?
ಹೌದು, ನವೆಂಬರ್ ಅಲ್ಲಿ. Sorry.
November.
15/4.
2 weeks.
Before vacation.
ಇಬ್ರು ಏನಾರಿದ್ರೆ ಹಾಕ್ಬೋದು. List this matter on 12/7. 2 weeks ಅಂದ್ಬಿಡಿ ಸರ್. 12/7.
Final hearing matter 97. GB Shastri. M. Shiva Prakash.
We are ready, my lord, but we are ready, my lord, but senior is arguing in 27.
You are ready, but senior?
Senior is arguing in court hall 27, my lord.
Senior is arguing in?
Court hall 27.
Court of?
27, my lord.
Then you argue. If your senior is not having time, then in my court, I never expect the senior counsel only to argue the matter. Even junior also can argue. Yes, ಹೇಳಿ ಏನು? ಅದರ್ ಸೈಡ್ ಯಾರಿದ್ದೀರೇನ್ರಿ? ನೀವು ರೆಡಿ ಇದೀರಾ ಇಲ್ಲ? ನೀವು ರೆಡಿ ಇದೀರಾ ಇಲ್ಲ ಅಂದೆ? ನೀವು ನೆಕ್ಸ್ಟ್ ಡೇಟು, ನೀವು ನೆಕ್ಸ್ಟ್ ಡೇಟು, ಅವರು ನೆಕ್ಸ್ಟ್ ಡೇಟು. ಆಯ್ತು ತೋಡಿ. Both counsel 6 time. List this matter on 12/7.
98.
My lord, interim order may be extended.
Interim order granted earlier is extended. Interim order ಇಟ್ಕೊಳ್ಳೋದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡದೇ ಇರೋದು ನಾಟ್ ಕರೆಕ್ಟ್ ಅಲ್ವಾ? ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್ 2018 ಈಗಲೇ 6 ವರ್ಷ ಆಯ್ತು. ಇಲ್ಲಿ ಬಂದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ.
We'll do it.
12/7 finally granted 2 weeks time. List this matter on 12/7.
98, TP Vivekananda.
Vivekananda, A.V. Gangadharappa. Comments ಆಯ್ತಾ ಇದು argument comments ಆಗಿದೆಯಾ? ಮಾತಾಡೋದು ತೋರಿಸಿಲ್ಲ ಇದರಲ್ಲಿ? ಥರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಮಾಡಿಲ್ವಾ? ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳಿದೀವಿ, ನೋಟ್ಸ್ ಮಾಡಿದೀನಿ ಇಷ್ಟೊಂದು.
Lordships have dictated that it is heard in part.
ಯಾಕೆ ತೋರಿಸಿಲ್ಲ? ಆಯ್ತು ಹೇಳಿ. ಈಗ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕಲ್ಲ? ಹೇಳಿ. ಆಯ್ತು ಹೇಳಿ. ನಿಮ್ಮ first submission, not an ancestral property, it is a government land. No material to show father was cultivating and not did any agriculture work. Alva? Agricultural work. Exhibit P21, his age is 26. Father name is shown as Siddharamaya, not the name of his father. Application not filed by the father. Section 94A, grant challenge before AC, and the same was dismissed. And it has attained its finality. Cross of PW1 admitted. Father eyesight is not in order, admitted for a period of 15 years. Father was not cultivating the land. He was a tailor antla ena helidri. Tailor. Revenue inspector report. Not responsible for the same. ನೀವು ಅವ್ರೇನ ರಿಲೇ ಮಾಡ್ತಾರೆ RI report ಅಂತ. Evidence of PW2, no consequence, not useful to the plaintiff. ಇಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಮಾಡಿದ್ರಿ, ಮುಂದಿಂದ ಹೇಳಿ.
There must be some material to show that as a matter of fact, this land was regulated unauthorizedly by the members of the family. Now, I will take the answer to the letter to the letter of the
ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಪೇಜ್ ಎಷ್ಟು? That means no giant cultivation also.
There was nothing, and this is how the appended report, that there is no material and record to provide. That this land was jointly cultivated by the members of the family, including the father, including the brother. Not a period of the book, paragraph 15 and 54. But you are the adjustment was that and since 1984 you were unauthorized and activate. Who had back for rank of life before the and you were intended. But the land was actually granted with the office of
And all discussions are with regard to they are not residing together and they were residing separately and not in joint cultivation. These are the discussions.
Now, having considered the evidence on the card, the appellate court came to the conclusion that that the land was cultivated either by the father or by the plaintiff as members of the joint family, assuming that they is a joint family, and therefore the plaintiff has to pay the
Hmm.
along with the memo. The thing is stated that we will do that document cannot be included because they are not part of the record. That is one aspect of the matter. Second aspect of the matter is the appellant says, no doubt my father's name, father's father, that is my grandfather's name was Ramalaya. Not Sidramaya, but it was also called as Sidramaya and Ramalaya. Now there is any evidence that the after document. But the first step is kind of that yes, the grandfather's name was Ramalaya. Not Sidramaya, but he was called in the family and Ramalaya both. So therefore, it has to be considered as Ramalaya. And we should not make that. There was no adjacent either for the transport or for the to look into these documents. Okay, one part in the secondary stage there too, at the stage of final hearing, to say that no, my grandfather's name was Karamale and was also called as Siram. Such contention cannot be accepted.
Yes.
So therefore, there is absolutely no infirmity in the judgment and the part by the appellate court and the appellate court has very people.
Yes.
Therefore, the judgment of the appellate court does not perform.
Any reply?
Yes, please.
ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ 4:50 ಅದಕ್ಕೆ ನಾವು ಜಾಸ್ತಿ ಟೈಮ್ ತಗೊಳ್ಳೋದಾರೆ
ಒಂದು 15 minutes ನಾಳೆ ಮಾಡ್ತೀವಿ.
15 minutes
ಆಯ್ತು.
ಅದಾಗಲ್ಲ ಮಂಡೇ ಮಂಡೇ ನೀವಿರಲ್ವಾ ಟ್ಯೂಸ್ಡೇ
ವೆಡ್ನೆಸ್ಡೇ ವೆಡ್ನೆಸ್ಡೇ ಸ್ವಾಮಿ.
ವೆಡ್ನೆಸ್ಡೇ ಕ್ರಿಮಿನಲ್ ಸ್ವಲ್ಪ ಇರುತ್ತೆ ಬೇಡ ಟ್ಯೂಸ್ಡೇ ಇದು ಮತ್ತೆ ಸಪರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ನಮ್ ಲಿಸ್ಟ್ ಆಗ್ಲಿ ರೆಡಿ ಆಗೋಗ್ಬಿಟ್ರು ಫೈಲ್ಸ್ ಎಲ್ಲ ನನ್ನ ಜೊತೆಲೆ ಬರುತ್ತೆ ಈಗ
Even tomorrow at 4:30, my lord, after can conclude it.
ಪಾರ್ಟ್ ರೆಡ್
Please.
ಕನ್ಕ್ಲೂಡ್
Please.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮಾಡಿ ಫಸ್ಟ್ ಅದನ್ನೇ ತಗೊಳ್ಳೋಣ 2:30 ಅಂತ ಹಾಕಿರ್ತೀನಿ
ಆಯ್ತು.
2:30 ಪಾರ್ಟ್ ರೆಡ್ ಅಂತ ಮಾಡಿ ಮೇಡಮ್ ರಿಪ್ಲೈ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಹಾಕಿ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಷ್ಟಿದೆ ಮೇಡಮ್ ಇನ್ನು 10 ಇದೆಯಾ 99 ಚಂದ್ರಕಾಂತ್ ಪಾಟೀಲ್ ಇದಾರಾ ಚಂದ್ರಕಾಂತ್ ಪಾಟೀಲ್
My lord, appearing for the appellants, kindly 2 weeks time may be granted. my
2
lord.
weeks Right.
As we are in the process of procuring information from the
So-
client
Appellant counsel is present ಯಾರು ಇದ್ರ GK ಭಾವನಾ ಇದಾರಾ
on behalf of GK.
both ಆಯ್ತು both the counsels are present for want of time list this matter on 12/7 12th ಬೇಡವಾ ಅಪ್ಲೈ ಮಾಡಿ ತಗೊಳ್ಳಿ ನಾನು ಕೊಟ್ಟಿರೋದು 12/7 ಹಾ ಹೌದು ಇನ್ನು ಅನದರ್ 2 weeks ಇಲ್ಲ ಸಾಕು 2 ವಾರದಲ್ಲಿ ತಗೊಳ್ಳಿ 2 ವಾರದಲ್ಲಿ ತಗೊಳ್ಳಿ ಸಾಕು ಹಾ
he is appearing for all.
ಇಲ್ಲಿ ಓ ಇದು ನೋಟಿಸ್ ಅಂತ ಇದೆಯಾ ಆರ್ಟು? ಹಾ
The appellant must be directed notice in 99, serial number 99.
ಸೇಮ್ ಅಲ್ಲ?
ಹೌದು, ಹೌದು,
ತೊಗೊಳ್ಳಿ. ಆರ್ಟ್ ದಿ ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಏನದು ಚಂದ್ರಕಾಂತ್ ಪಾಟೀಲ್ ಕೆ and Rakesh Bhatt are directed to take notice for R2 in RSA craft 5 of 22. ಹಾ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ 12/7. 15 ದಿವಸ ಹಾಕಿದ್ದೀವಲ್ರಿ? ಹಾ
15 ಬೇಡ.
July 15th.
July 15 ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. 15
ಬೇಡವಾ? ಯಾವತ್ ಬೇಕು?
ಬೇಡ.
ಇಬ್ರಿಗೂ ಒಳ್ಳೆ ದಿವಸ ಹೇಳಿ. ಹಾ 16th. 16/7. 100. ಹಾ ಇಬ್ರು ಇದ್ದೀರಾ? ಸರ್ವಣ. Want of time list this matter on 12/7.
101.
101.
Patil.
ಇಬ್ರು ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಅದರ್ ಸೈಡ್ ಇಲ್ಲ.
ನೀವಿದ್ದೀರಿ. Appellant counsel present, respondent counsel is absent. List this matter on 12/7.
16th ಆಯ್ತು.
ನಿಮಗೂ 16th ಬೇಕಾ? ಆಯ್ತು. ಏನ್ ರಾಯರ್ ವಾರನ?
ಇಲ್ಲ, ಆ ತರ ಏನು.
102. Mantesh Vasmat and BS Nagraj.
I am appear for the respondent number 1, my lord.
Yes, both counsels.
I am for the respondent number 1.
ಎಲ್ಲಿದ್ದಾರೆ ಅವರು?
Respondent number 1.
ನಾಗರಾಜ್ ಅವರು. ಹಾ ಆಯ್ತು.
I am in
ಅವರು ಇದಾರಲ್ಲ.
I am in VC. I am in VC, my lord.
ಆಯ್ತು. You are in VC, your colleague is in physically present. ಆಯ್ತು. Both counsels are present. For want of time, list this matter on 12/7.
103.
ಅಜಿತ್ ಶೆಟ್ಟಿ, ಮಧುಸೂದನ್ ರಾವ್ ಇಬ್ರು ಇದ್ದೀರಾ? ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಯಾರು? R1
Sole respondent is dead. Now, what appears for us is that is legal heirs have already filed execution.
Sir, R2 is
But by inadvertence, not the interim order that was in existence was not continued, not because of.
ಈಗೇನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಿದ್ದೀರಾ?
I've already served, not the topic.
ಕೊಡಿ. The counsel appearing for the R1 submits that R1 is no more. Counsel for the appellant files an application for extension of interim order. And copy is also served on the other side. Already there was an interim order and the same was not extended earlier and hence the same is extended till next date of hearing.
In 5 days to not such days.
And counsel for the appellant is given 5 days time as sought to bring the LRs of R1. ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ. ನಾವು ಎಲ್ಲ ತರ್ಸ್ಕೊಂಡು ಅವ್ರೆ ಒಕ್ಕಲತ್ ಹಾಕೋದಾರ ಹಾಕಿ ನೋಡ್ರಿ, ನೀವೇನಾದ್ರು ತರ್ಸ್ಕೊಂಡು ಹಾಕೋದಾರ ಹಾಕಿ. ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 5/7. ನೀವು 5 days ಅಲ್ಲಿ ಬೇಕಾದ್ರೆ ಅದಕ್ಕೆ 1 ವಾರ ಕೊಟ್ಟಿದ್ದೀವಿ. 105.
104. I appear for the appellant mailer. Appellant mailer.
ಇದ್ದೀರಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ನೀವು appellant ಗ?
Appellant ಸ್ವಾಮಿ.
Appellant counsel present, respondent counsel absent.
Implied amendment
ಏನ್
application.
ಅಮೆಂಡ್ಮೆಂಟ್?
ಏನಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ
ನೀವೇನ್ ಹಾಕಿದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದಾಯ್ತು, ಅವ್ರು ಬರ್ಲಿಲ್ಲ 2 times ಇಂದ ಅವ್ರ ಇದು.
ನೋಡೋಣ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 5/7 ಇದು ಹಾಕೊಂಡಿರಿ ನೋಡೋಣ. ಅಮೆಂಡ್ಮೆಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ ಆಮೇಲೆ ನೋಡೋಣ. 105. ಶರತ್ ಗೌಡ ವೀರಭದ್ರ ಸ್ವಾಮಿ. ನೋಡಿ, respondent counsel present, ಇವರಿಲ್ವಾ? appellant counsel is absent. List this matter on 12/7.
106.
I am appear for appellant.
ಚಂದ್ರಚೂಡ and ಸುಧೀಂದ್ರ ಇಬ್ರು ಇದ್ದೀರಾ?
I am appear for
ಇದ್ರಲ್ಲ ಈಗ.
appellant.
ಆಯ್ತು. For want of time list this ಇದಾರಲ್ಲ. Both counsels are present. For want of time list this matter on 12/7.
107.
SV Prakash. Both counsels are present. For want of time list this matter on 12/7.
108.
Not 8.
Appear for the appellant.
Ramachandra Reddy Chittappa.
Chittappa was here, my lord.
Appellant counsel
We are
is
ready.
present. Respondent is absent. Respondent counsel is absent. List this matter for want of time on 12/7.
Kindly continue the interim order until further. ಇದೆ.
Interim order ಇದೆಯಾ?
ಇದೆ.
Interim order granted, earlier is extended till next date of hearing.
Next date ಎತ್ತಲದ further hearing ಅಂತ. Further until further.
ಫೈನಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ತಗೋಬಿಡೋಣ. ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ನೋಡೋಣ ರೀಚ್ ಆದ್ರೆ. ನನಗೆ ಈ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಯಾಕೆ ರೀಚ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಬೆಳಗ್ಗೆ ಮಿಸ್ಲೇನಿಯಸ್ ಬೆಳಗ್ಗೆ 10:30 12 ಗಂಟೆ 12:15 ಆಗ್ತಾ ಇದೆ. ಯಾಕೆಂದ್ರೆ ಸುಮಾರು ಫೈಲ್ಸ್ ಬಂದೇ ಇಲ್ಲ 6 ವರ್ಷದಿಂದ. ಅದನ್ನ ಹಾಕ್ಸ್ಕೊಂಡ್ ಮಾಡ್ತಾ ಇದೀನಿ, ಹಾಗಾಗಿ ಸ್ವಲ್ಪ ಆಗ್ತಾ ಇಲ್ಲ ಅಷ್ಟು. ಅದರ್ವೈಸ್ ಐ ವುಡ್ ಕವರ್ಡ್ ದಿಸ್ ಮ್ಯಾಟರ್. 109 GM ನಟರಾಜ್ ಪೃಥ್ವಿ ಒಡೆಯರ್ Both the councils are present for want of time, list this matter on 12/7.
110.
110.
Appear for
Jayashree
appellant.
KP and both councils are present for want of time, list this matter on 12/7.
On 67 maybe, my lordship. 16.
14 ಬೇಕಾ?
16, 16,
ಅದೇ 16 7 ಆಯ್ತು.
Mobilizement.
ವಾಸವರಾತ್ರಿ
79.
79.
ಆರ್ ಪ್ರಮೋದ್
ಆರ್ ಪ್ರಮೋದ್ ಯಾರು ಬೆಳಗ್ಗೆ
ಬರ್ತೀನಿ ಅಂತ.
ಬರ್ತೀನಿ ಅಂತ ಬರ್ಲೇ ಇಲ್ವರು ನೋಡು ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 12/7. 12/7 ಅರ್ಲಿಯರ್ ಇಲ್ರಿ ಎಲ್ಲಾನು ಅವಧಿಗೆ ಕೊಡೋದು 12 ದಿವಸ 15 ದಿವಸಕ್ಕೆ ರೀಚ್ ಆಗಲ್ಲ. ನಾವು ಬೇರೆ ಕೊಟ್ಬಿಟ್ಟಿರ್ತೀವಿ ಬೇರೆ ದಿವಸ ಎಲ್ಲ ಒಂದೊಂದ್ ದಿವಸಕ್ಕೆ ಒಂದೊಂದ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿರ್ತೀವಿ. ಏನಾಯ್ತು ಇವ್ರದ್ದೇನು?
ನಾನು ಅದೇ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀನಿ.
ಏನಾಯ್ತು ಮೇಡಮ್? ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾರ ನೋಡಿ, ಅರ್ಜಿ ಹಾಕಿದಾರ?
ಒಂದು ಅರ್ಜಿ ಹಾಕಿದ್ದೀನಿ ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಅದನ್ನ
ಪುಟಪ್ ಮಾಡಿಲ್ವಾ?
ನಂಬರ್ ಆಫ್ ಡಿಲೇಸ್
ಮಾಡಿದ್ರ ತೋರಿಸ್ಲಿಲ್ವಾ ಅವಾಗ? ಏನಂತ ಹಾಕಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್ಸ್ಗೆ ಅಂತ ನೀವು ಹೇಳಿಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ಸ್ಗೆ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಹೇಳಿಲ್ಲ. ಆಯ್ತು ನೋಡಿ, ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಮೇಡಮ್ ನೋಡಿ?
8 ಬೇರೆದೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀನಿ. R6 R31 ಇಬ್ರದ್ದು ಬೇಕಾಗಿರ್ಲಿಲ್ಲ, ಬಟ್ ಸ್ಟಿಲ್ ಐ ಫೈಲ್.
ಬೇರೆ ಬಟ್ಸ್ ಆರ್ ನಾಟ್ ನೋನ್ ಅಂತ ನೀವು ಹೇಳಕ್ಕಾಗಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಆಗ್ಲೇಬೇಕು. ಡೇಟ್ಸ್, ಡೇಟ್ ಆಫ್ ಡೆತ್
ಅದು 4 ಅಪೀಲ್ ಇದೆ. 1 OS 4 ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ಫಸ್ಟ್ ಆರ್ಯನ್ ಅಲ್ಲಿ ಎಲ್ಲಾರ ಹೆಸರು ತರ್ತಾರೆ, ಸತ್ತೋಗಿರೋರ್ದು ಎಲ್ಲಾರ್ಸೆಲ್ಲ ರೆಕಾರ್ಡ್ ತರ್ತಾರೆ. ಉಳ್ದಿದ್ದ ಅಪೀಲ್ ಅಲ್ಲಿ ಅವ್ರು ತರಲ್ಲ. ಆ ಯಾವ್ದು ಸರಿಯಾಗಿದೆಯೋ ಅದ್ರ ಮೇಲೆ 660 ಅಪೀಲ್ ನಾನು ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ. ಆ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರೆ ಈ ಅಪ್ಲಿಕೇಶನ್ಸ್ ನಾಟ್ ನೆಸೆಸರಿ. RSA 660 ಏನ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಇದೆಯೋ ಅದನ್ನ ಮಾಡಿದ್ರೆ
RSA 660 ಇದೆಯಾ?
ಇದೆ ತಮ್ಮ, ಇದು ಕನೆಕ್ಟ್ ಆಗಿದೆ.
ಇಲ್ಲ
ಇಲ್ಲ ಕನೆಕ್ಟ್ ಮಾಡಕ್ಕೂ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ
ಹೇಳಿ, ಅದೇನ್ ಮಾಡೋಣ ಆಮೇಲೆ ನೋಡೋಣ. ಡಿಸ್ಮಿಸಲ್ ತೆಗೀರಿ, ಏನಿದೆ ಹೇಳಿ. ಬೆಳಿಗ್ಗೆ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ಅದು ಬೇಡಲ್ಲ ಈಗ ಹೇಳ್ಬಿಡಿ ಇದನ್ನ. The council appearing for the appellant will submit that he has filed the application for bringing LRs
R6
bringing LRs of R6
31 ಗೆ ನೋಟು ಬರ್ದಿದ್ದೀನಿ ನಾನು.
ಏನಂತ?
They were already made as parties in the trial court in
also given council submission in respect of respond number 31 as not necessary ಅಂತನಾ?
ಹೌದು.
And note accept ಮಾಡ್ಕೋಬೇಕಾದ್ರೆ ಈಗ note ಎಲ್ಲಿದೆ ಅದು?
Submission may be accepted.
Council submission is accepted at the risk of the appellant.
Please ಉಳ್ದಿದ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದೀನಿ.
ಈಗ I1 ಹಾಕಿರೋದು
ಅದಕ್ಕೂ ಸೇಮ್ ಸಬ್ಮಿಷನ್.
ಅದಕ್ಕೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ವಾ ಎಲ್ಲ ಅಷ್ಟೇ. ಅದ್ರ ಮೇಲೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ? IML ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಂತೆ.
20th ಹಾಕಿದ್ದೀನಿ ನಾನು ಅಪ್ಲಿಕೇಶನ್.
ಈಗ ಅದ್ರ ಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಂತೆ. ಆಯ್ತು, ಕಂಪ್ಲೈ ವಿತ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆನ್ IA number 1 of 24.
Great.
ಬೆಳಗ್ಗೆ ಏನ್ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ವಿ ಅದೆಲ್ಲ ತೆಗೆದ್ಬಿಡಿ, ಇದು ಮಾತ್ರ ಟೈಪ್ ಮಾಡಿಸಿ.
ಟೈಪ್ ಮಾಡಿರ್ತಾರೆ. ಏನ್ ಹೇಳಿದ್ರು ಇವಾಗ? 12/7 12ನೇ ತಾರೀಕು 105 105 12/7 ಹೇಳಿ ನನಗೆ